The Murder of the Rosenbergs. By Stanley Yalkowsky. My gratitude is wholeheartedly extended to Aaron Katz, director of the National Committee to reopen the Rosenberg case. It was Katz who convinced me that the United States government's primary motive in its determination to convict Julius and Ethel Rosenberg was to destroy the Communist Party in America. Katz supplied the perspective that made understandable the unconstitutional laws and irrational cruelty that governed during those troubled times. The passage of the Smith and McCarran Acts, the ascendancy to power of Joseph McCarthy and Pat McCarran, and finally the most decisive act of them all, the murder of Julius and Ethel Rosenberg, indeed virtually eliminated the Communist Party in America. Preliminary statement. The author has been criticized for having reached conclusions concerning the loyalties of certain individuals without sufficient supporting evidence. The authors claim that Jacob Golos, today an obscure individual, was a spy for the United States government rather than for the Soviet Union as he was purported to be, is disturbing to communists and liberals who had been so frequently disappointed by those they trusted. To think that Golos, who held such an important position in liberal circles, being the main travel agent for the securing of passage in the 1930s for young men and women willing to give their lives to fight fascism in Spain, was all the while, as the author claims, turning over to the director of the FBI, J. Edgar Hoover. The information he collected is heartbreaking and not believable or bearable to many, especially when the author himself admits that although he may have found the evidence against Golos convincing and his theory of a Golos, Gold, Bentley, Hoover connection compelling, it did not necessarily lead to the inescapable conclusion that Golos was an undercover agent for the FBI. Contents. Preface 9. Klaus Fuchs 1. Crystal and Robert Heinemann 5. Mutual Identifications 12. Harry Gold and Friends 20. Alfred Dean Slack 33. Prelude to Trial 36. Opening Statements 41. FBI Agent Donald Shannon 51 1947 Grand Jury 59 Elizabeth Bentley 64 Harry Gold 75 Witnesses 99 Summations 105 Sentencing 115 Out of Bondage 123 Harvey Matiso 137 William Remington 142 Judge Kaufman in person 149 The Indictment 151 Max Ilitcher 154 David Greenglass 182 J. Edgar Hoover and Niels Bohr 186 January-June, 1945 189 Walter Koski 197 The Atom Bomb Secret Revealed 203 Greenglass and Russia 210 Passport Photos 216 $5,000 is less than $1,000 221 Dr. Spindle and Dr. Schwartz 232 Family Quarrels 236 Ruth Greenglass 240 More Witnesses 261 Harry Gold 265 Witnesses 283 Hotel Hilton 286 John Lansdale, Jr. 292 John A. Derry 298 Morton Sobel's Flight 307 Anatoly Yakovlev 311 Elizabeth Bentley 319 Julius Rosenberg 340 Communist Party member 12,179 359 Vivian Glassman 367 The Daytons and Sarants 374 The completion of Rosenberg's testimony 379 Ethel Rosenberg 389 Benjamin Schneider 399 Motions and Summations 403 Verdict and Sentence 424 Credit for the sentencing 430 Appeals 436 Hoover's Spectacular Fraud 445 The Rosenbergs Die 454 Kaufman's Guilt-Ridden Paranoia 457 Preface. It was a weekend night in 1951 when a misguided group of youths, the author among them, decided to visit a Bronx social club, which was a meeting place for liberals. The group, thinking they were acting out of patriotism and fighting communism, waited for the members to leave, and when they did, assaulted several of them. The police were summoned. They viewed the scene of mayhem, smiled, winked at the group, and then left, ignoring the protests of the victims who demanded that arrests be made. In the federal courts in downtown Manhattan, Judge Irving Kaufman and the prosecutors, Irving SA5-OL and Roy Cohn, were using slander, false evidence, and suborning perjury in order to murder an innocent liberal-minded couple, while almost an entire nation smiled and winked at what they were doing. In reviewing one of America's blackest moments, the prosecution, conviction, and execution of Julius and Ethel Rosenberg for spying for the Soviet Union examination almost necessarily begins with the British physicist Klaus Fuchs. Late in January 1950, Fuchs, on his own initiative, confessed to British authorities that while he was working in the United States in the 1940s he had given the secrets of the atomic bomb to the Russians. Fuchs, a brilliant scientist and expatriate from Nazi Germany, was arrested on February 2, 1950. He went to trial March 1 and was convicted. It was Fuchs's arrest and conviction that led to the arrest of Harry Gold, to the arrest of David Greenglass, and finally to the arrests of Julius and Ethel Rosenberg. The officially presented facts were that Klaus Fuchs, while working at Los Alamos, New Mexico, in 1945, passed to Harry Gold, an American industrial chemist, the secrets of the atom bomb. Gold also at the time received atom bomb secrets from David Greenglass, an enlisted man in the U.S. Army who was also working at Los Alamos, and then passed the secrets to Anatoly Yakovlev, a member of the Russian consulate in New York, who forwarded them to the Soviet Union. Greenglass*'s brother-in-law Julius Rosenberg, an electrical engineer in New York, and his wife Ethel were the masterminds of the spy operation. These facts, however, on inspection, evaporate. The evidence indicates that Gold never met Fuchs or Greenglass, that Gold was never in New Mexico, particularly at the times he claimed he received the A-bomb data. What is more, the Russian Yakovlev, variously described as blonde with blue eyes by one FBI informant, and dark with black eyes by another, was reported to have been in France by yet another FBI informant at a time when Gold said that he was giving him the atom secrets. Other facts accepted at the time were that Harry Gold and Elizabeth Bentley were espionage agents working for the Soviet Union who later turned against the Communists, Gold after his arrest in 1950, and Bentley on her own volition in 1945. But these facts of yesterday are not the facts of today. The internal evidence contained in the FBI files points out that Gold and Bentley were part of an unsavory group of misfits and informers who had been working for the Bureau all along. At the time, Gold's acceptance of a 30-year sentence was regarded as proof that he was a spy, on the theory that only a guilty man would have consented to such a long term. This point was so convincing to the Rosenberg lawyers that they did not even question his credentials and credibility. Today we simply do not know whether something in Gold's bizarre personality led him to agree to spend 30 years in prison, or whether the FBI had some hold over him that was powerful enough to compel his assent. Bentley's evidence also was generally accepted in her many court appearances. FBI Director Hoover himself claimed that her testimony had proved to be honest in every case. Actually, her testimony turned out to be dishonest in almost every instance. If a fact is defined as an occurrence not subject to dispute, the study of the murder of the Rosenbergs begins now, and ever 5-carat-ing is in dispute. From the time of Fuchs's apprehension until mid-May 1950 it is unclear what the FBI actually uncovered. All we do know is that during this period, the FBI's concentration was on someone named Joseph Regenstriech, the man Fuchs identified as Raymond. But on May 9, 1950, J. Edgar Hoover ordered an all-out search for Harry Gold, who might be this Raymond. And on May 22 Gold confessed that he was indeed RA5 Anand. Yet 2 days before this confession, Fuchs was unable to identify Gold as Raymond from any of the photographs presented to him by the FBI agent visiting him in England. On May 22, after Gold insisted that he was the American to whom Fuchs had given A-bomb secrets, motion pictures of Gold were rushed to Fuchs. This time Fuchs, recognizing what was wanted, said, "I cannot be absolutely positive, but I think it is very likely him." Finally on May 24, after viewing still more photographs and motion pictures of Gold, Fuchs announced, "Yes, that is my American contact. But years later, when Marshall Perlin, a lawyer representing the two sons of Julius and Ethel Rosenberg, visited Klaus Fuchs and asked him if he had ever identified Harry Gold as his contact, Perlin said that Fuchs answered, no, he never identified Gold as the courier, either to the FBI, British intelligence, or to his attorney. Perlin explained how Fuchs was set upon by an FBI agent who told him, for God's sake, say he is the man. Gold insists he is, and that Fuchs, wishing to please, in substance responded, all right, if he wants to be that person, I'll say he is that person. There were other problems confronting the FBI in building a case against Gold. J. Edgar Hoover, in an article, The Crime of the Century, for the May 1951 edition of Reader's Digest, conceded that Fuchs described his contact as 40 to 45 years of age, possibly 5 feet 10 inches tall, broad build. Harry Gold was delicate, frail, about 5 feet, 4 inches tall, and 34 years old. Furthermore, Fuchs's sister Crystal Heinemann, who supposedly also saw Raymond, gave the same description that Fuchs had. Obviously it did not fit Harry Gold. Nevertheless, when the FBI learned that Regent Striak could not have visited the Heinemann home at any of the times that Fuchs was there, having been elsewhere at the time, the need to substitute someone else like Harry Gold became essential to the U.S. government's case. With that objective in mind, Hoover wrote, our starting place was Cambridge because Fuchs had admitted meeting the agent there, and because it was the home of Fuchs' sister, Crystal Heinemann. Crystal Fuchs Heinemann was born in Germany on July 22, 1914. She entered the United States in October 1938 and married Robert Bloch Heinemann. They had 3 children, all born in Cambridge, Massachusetts. According to evidence in the FBI files, Robert Heinemann was a communist who had turned informer for the U.S. government. Throughout this book the reader will find references to informers and possible informers. While the term is opprobrious and most people believe that the existence of an informer is rare, the realities of life dispute this assumption. Having a chance to review the FBI files, thousands on thousands of pages, an investigator loses naive faith. Informers are everywhere. Friends, best friends, even brothers turn against those they are supposed to love in order to save themselves. Crystal Heinemann, her husband, their 3 children, and a man named Konstantin Lafazanos all were present when the visitor whom Klaus Fuchs knew as R.A. Mayan arrived at the Heinemann home. Yet none of them were asked to identify Harry Gold as that visitor. Crystal Heinemann in particular was rejected as a witness by the FBI because they considered her mentally incompetent. An FBI report stamp dated February 5, 1950, when she was a patient at Westborough State Hospital in Massachusetts, read: it is noted that she is receiving treatment because her mental illness had caused confusion in her mind as to time, persons, and places. To stress the seriousness of Crystal Heinemann's mental state, the report continued. Mrs. Heinemann recited the following. Approximately 3 weeks before Klaus Fuchs's visit in Cambridge in February 1945, a chemist rang her doorbell and asked if Klaus had arrived. He introduced himself as a chemist who had worked with Klaus, and she is under the impression that he worked at Los Alamos. Questioning revealed that there was no basis in fact now known to her for this assumption. Sometime in the following few months, this same unidentified chemist again stopped at her home and made inquiry as to whether her brother would visit her in the near future. She has a dim recollection that her husband may have met this man as he left the house with a brief introduction. Mrs. Heinemann described the unidentified chemist as follows: about 40 years of age, height, 5 feet 8 inches to 8'1/2", build, stocky, weight, possibly 180 pounds, hair, very dark brown, thin and not curly. Mrs. Heinemann indicated that she might recall the name of the unidentified chemist if it was spoken to her. There also exists the possibility that she might recognize him from a photograph. Actually, Crystal Heinemann's responses to the FBI queries were balanced and forthright. It was just that she disappointed the agents, who appraised her as someone not likely to alter her testimony to suit their plans. On February 14, agents interviewed her again at Westboro State Hospital. At this interview she said very little that differed from earlier interviews, except that she mentioned another witness who might have been present at the time, a man named Konstantin Lefazanos. 6. Nothing in the FBI reports indicated that there were disturbances in Crystal Heinemann*'s thinking. Whatever her emotional problems, they did not affect her ability to give a coherent description of the visits to her home by an unidentified chemist. Nonetheless, the slanders against her and the other witness she named, Konstantin Lefazanos, began and accelerated. An FBI teletype reported that she was completely hallucinated and undergoing shock treatments. Impossible to interview her currently according to medical authorities. Testimony of no value in view of condition. Lefazanos is considered unreliable by Boston who have talked to him. Has medical records as psychoneurotic and is believed likely to be publicity hound. Another FBI memo, dated March 3, read. On the late afternoon of March 2, 1950 Dr. Rollins K. Hadley, Director of the Westboro State Hospital, you advised Special Agents John J. O'Laller and Preston S. Gordon that Dr. Samuel Holt, who is in charge of Crystal Heinemann's treatment, had made a suggestion that Crystal be given a dose of amytol, CT truth serum. The Philadelphia office of the FBI was not willing to go that far. They opposed the suggestion, saying, "This office was in no way responsible for the decision to conduct such treatment, nor will any agent be present or participate in this phase of medical treatment." The FBI's position concerning the Heinemanns had a great deal of mystery about it. There was much afoot, and complete answers will probably never be obtained. Those lucky and thankful researchers who had the opportunity to read the FBI files that finally reached the Columbia University Library sometime in 1989, more than 10 years after they were initially released by the government, found them invaluable. The insights they offered on life itself were well worth the months required to read them. The FBI files were probably released because the FBI wanted them released. Certainly they kept much from view. But if the Bureau wanted to, it could have concealed a great deal more. It was time to have the work of Director J. Edgar Hoover repraised and the malodorous stench of his administration removed. The FBI left enough information in those files to expose Hoover for what he was. On May 22, 1950, according to an FBI memo, Agent August Belmont was expecting Crystal Heinemann to come to Philadelphia to identify gold. That appointment was quietly cancelled. She would never be given the opportunity to see Harry Gold face to face, not when the FBI knew that she would not identify him as the chemist who had visited her Cambridge home. Other examples of the government's investigative methods surfaced. The Heinemanns were involved in a divorce struggle, and Robert Heinemann**'s lawyer was a former FBI agent, James F. Mahan. Informers characteristically hired former FBI agents and former U.S. attorneys to represent them in court. Elizabeth Bentley chose U.S. Attorney Thomas Donegan for her lawyer. David Greenglass, his wife Ruth, and Max Ilitcher, another self-confessed spy, were represented by former U.S. Attorney O. John Rogge. A Boston FBI memo dated May 29, 1951, read. 8. Former Special Agent and now Attorney James F. Mahan advised Special Agent Preston S. Gordon of this division, on May 29, 1951, of the following. In late April 195 Mr. Mahan filed a petition for a devotee CE, on behalf of Robert Heinemann. The grounds for the divorce are adultery and the correspondent named is Konstantin Lefazanos SF of Lowell, Massachusetts. The court has been requested to appoint a guardian to act for Mrs. Heinemann, who remains an inmate at the Westboro State Hospital for the mentally ill. A memo dated 2 days later said. On the afternoon of May 31, 1951, Konstantin Lefazanos appeared at the office of this division and advised S.A. Richard W. Dow of the following. Lefazanos declared that he has been subpoenaed as a witness in the divorce action now being instituted by Robert Heinemann against his wife. Lefezeno said he intended to prove these three items. That Robert Heinemann was a member of the Communist Party. 2a. That Robert Heinemann was at Lefezeno's, was the Lefezeno's then commented that the interviewing agent might well note that he had lost considerable weight since the last time the agents had interviewed him in connection with the Fuchs and Gold case. Here again Lefezeno stated, "My loss in weight is the result of the psychological warfare being waged upon me by S.A. Gordon and S.A. Dow." It is noted that the attorney representing Heinemann has previously advised that he intends to avoid publicity in connection with his client's domestic problems. It can be noted. 9. However, that Lefezeno's will undoubtedly attract newspaper attention if he makes the allegations he declares above. What were the allegations Lefezeno's made that were so worrisome to the FBI? That Robert Heinemann was a government informer? He was, a February 1951 FBI report said. This review reflects that during 1950 Robert Heinemann has been carried as a temporary informant in several reports emanating from the Boston office. The date when he began working for the FBI was not given. But the most glaring unanswered question is why the government did not use Heinemann to identify Harry Gold, especially when Gold had already said that he met him and would assuredly not contradict his identification. J. Edgar Hoover was building a case that he described as the crime of the century, but he was not presenting the available witnesses who could identify Harry Gold as Klaus Fuchs's contact. There was a good reason for the FBI's decision. Robert Heinemann, as well as Crystal Heinemann and Konstantin Lefezeno's, had already been tested with the FBI's first suspect, Joseph Regenstriech. At that time, the FBI very much wanted Regenstriech identified as the mysterious Raymond. Yet try as the FBI might, they could not persuade any of the three to identify Regenstriech, even though Fuchs had done so. They were truthful witnesses and not pliable. This was good enough reason for Hoover to not use them. Fuchs, on the other hand, demonstrated his ability to identify the suspect of the FBI's choice. He identified Harry Gold. By FBI standards, Fuchs could be counted upon, the Heinemanns and Lefezeno's could not. It was essential that 10. They not be permitted to testify. Since Hoover couldn't use these three witnesses, no one else would be able to. Just in case the defense ever got hold of them, they would be so tarnished or so afraid of government retaliation as to be of no use to anyone. Crystal Heinemann had to be presented as incurably insane. Konstantin Lefezeno's would be given similar treatment. He had a big mouth, FBI harassment would close it. He lost a lot of weight because of FBI intimidation, he would lose a lot more if he continued to display an independent spirit. Lefezeno's received clear messages as to what was in store for him if he did anything to upset the government's objectives. Only Robert Heinemann would be treated politely and simply told to stay away from the case. Although the government had concluded that Crystal Heinemann could be expected to remain in an institution for the rest of her life, once Gold had testified in court that he knew Klaus Fuchs, she quickly recovered. Soon after she was released from the hospital, and after divorcing Robert Heinemann, married a man named Albert Halser on October 8, 1954. 11. When Harry Gold was arrested in America some 6 months after Klaus Fuchs confessed, it was because the U.S. authorities decided that Gold would be Raymond. The evidence in the FBI files is compelling that Hoover and the inner circle of agents working with him always knew that Gold had never visited the Heinemanns and never met Fuchs. The Bureau had others like Gold working with them, strange men and women who were ready to admit to all sorts of crimes they had not committed. The government's case rested on aberrant personalities like Harry Gold and Klaus Fuchs. The United States was embroiled in a bitter political war with the Soviet Union. Communism was perceived as a threat to the nation. To many officials in our government, it seemed essential for a communist spy ring to be discovered in order to prove to all Americans that the country was in grave danger. The existence of a spy ring, especially since Russia now possessed the atomic bomb, would confirm the nation's need to rid itself of communists and communist sympathizers. With a communist atomic bomb threatening from the outside and a communist internal revolution threatening from the inside, the government officials who were directly involved made a pragmatic, visceral decision. A hoax conspiracy was formulated. A spy ring engaged in passing atomic secrets to the Russians was invented. Julius and Ethel Rosenberg would be the leaders of this ring, and the nation would become a giant lynch mob. The Rosenbergs would die, for history had to move in this way. 12. Fuchs pleaded guilty, to what? No one really knows. His statement of guilt was an unsupported conclusion. William Scarton, the British police official who investigated him, testified, until Fuchs confessed there was no evidence with which the Crown could have gone to court against him. The British authorities were reluctant prosecutors of Fuchs. They saw him for what he was, a disturbed man carrying a psychological burden, who may very well have been guilty of nothing. On May 23, 1950, Harry Gold was named as a conspirator. It looked as if Fuchs had led to Gold. But that was not the case. Gold had been interrogated by FBI agents before they went to London to question Fuchs. Gold confessed on May 22, the day before Fuchs was persuaded to identify him. Once the US government had Harry Gold's confession, the FBI called their London-based investigators to tell them that efforts should be made to reconcile discrepancies in statements of Fuchs and Gold. As a result, the discrepancies were carefully reconciled. For instance, Fuchs' signed confession of May 26 repudiated a statement he made 3 days earlier claiming that he had met Raymond at the end of June 1945. In the new statement he simply changed his testimony, saying June rather than the end of June, so as to have his latest statement conform with Gold's claim that they met in New Mexico on June 2, 1945. But June 1945 was not mentioned at all in the original charges brought against Fuchs, nor was a visit by anyone to him in New Mexico mentioned. Changes in Fuchs and Gold's statements multiplied. Fuchs originally said that he met his contact once in 13. New York City. Gold, in his May 22 statement, said he remembered 3 meetings with Fuchs in New York City. By the time of Gold's July 10 statement, he remembered at least 5 meetings with Fuchs, and recalled, the relationship between Klaus Fuchs and me was that of 2 firm friends. Once the FBI had a way of connecting Klaus Fuchs with Harry Gold, the next step was for them to connect Gold with another contact, the as yet unidentified young soldier whom Gold later identified as David Greenglass, the brother-in-law of Julius Rosenberg. Everything about the meetings between Gold and Fuchs and Gold and Greenglass was contrived. Gold first stated that he had met Fuchs in Santa Fe in September 1945. Later he also insisted that he met David Greenglass in Albuquerque the same month. Gold's insistence upon September 1945 could have destroyed the case from the start, since Greenglass was not in Albuquerque in September, he was on furlough in New York City. The meetings had to be in June, making it necessary for the FBI to add a few words to Gold's statements. Still, with all the FBI's machinations, too many statements were already in the files that mentioned only the September meeting, not a June meeting. For example, a May 23 FBI memo read, the Philadelphia division advised that Gold had admitted contacting Fuchs at Santa Fe, New Mexico in September ±ER 1945. Gold also admitted that he stopped at the Hilton Hotel in Albuquerque in September of 1945. Not June, and still no mention of the soldier's name. On June 2, Special Agent Edward Skelt noted for the first time that David Greenglass might be the unidentified soldier named by Gold. On June 3, FBI agents visited Gold in the Tombs, the New York City 14. prison he was in, and the next day Gold identified Greenglass from a number of photographs as the one who most resembled the man he had met in Albuquerque. On June 5 Gold's identification of Greenglass still was not certain. It was not until June 15 that Harry Gold at last made a positive identification of David Greenglass as the soldier he had visited in Albuquerque. The same process that had enabled Gold to identify Fuchs now enabled Gold to identify Greenglass. Greenglass*s willingness to be identified. Just as Klaus Fuchs and Harry Gold's testimonies were reconciled, Harry Gold and David Greenglass's testimonies had to be reconciled. These adjustments in testimony were made by the government with a feeling of righteousness. To destroy an enemy who was perceived as a threat to national security, it was considered entirely proper to falsify evidence. Reliable evidence was never submitted to explain what led the FBI to Gold. Fuchs was in British custody for 6 months, voluntarily providing information of every kind in his effort to convince everyone of his guilt. In that time he never once mentioned having been visited by Gold in Santa Fe. We were asked to believe that Klaus Fuchs failed to include in his confession the most important element of his crime, delivery of the secret of the atomic bomb to RA5 Anand, who was now Harry Gold, in Santa Fe. And we were not expected to find it odd that in so many months of providing voluntary confessions, Fuchs forgot about what had happened in Santa Fe. The jurors at the Rosenberg trial never learned that there was considerable doubt about Gold's meeting with Fuchs in Santa Fe in September 1945, or ever, for that matter. Thus they were not given the 15. opportunity to make the deduction that if the Gold-Fuchs meeting did not occur, the Gold-Greenglass meeting in Albuquerque probably did not occur. The government's need for a Klaus Fuchs and a Harry Gold was so great that these master spies had to be created. Fuchs and Gold were ever willing. Gold even referred once to a mystical bond that existed between him and Klaus Fuchs. Indeed, it does seem that two men who were willing to pretend to have done what they did, and plead guilty to what they did not do, were mystically connected on some level. In his one public statement before sentencing, Fuchs said, "I have committed certain crimes. I expect sentence. I have also committed some other crimes, which are not crimes in the eyes of the law. And when I asked my counsel to put certain facts before you, I did it in order to atone for those other crimes." Thus Fuchs as much as admitted that he was confessing to something he did not do in order to punish himself for some unrevealed thing he did do. Fuchs and Gold's willingness to make mutual accusations and admissions was guided by one principle: that each of them demonstrate this willingness to the other's satisfaction. Each refused to identify the other until it was proved to his satisfaction that the other had entered into this pact. Once they recognized that they mutually agreed to be accused and identified by one another, they quickly did so. Though rare, bizarre actions of this kind are not unknown in human experience. Jack Ruby killed Lee Harvey Oswald so that, as Ruby claimed, the wife of the assassinated president would be spared the ordeal of attending the suspected assassin Oswald's trial. One must delve much deeper to determine the true motives for such conduct. 16. But Gold, while willing to accept a 30-year prison term, was not willing to plead guilty to the charge that he passed atomic bomb secrets to the Russians with intent to the injury of the United States. As a result of his protests, the prosecution dropped the phrase. For the government to have acceded to such a request by a purported spy was further evidence of the United States government's long and curious relationship with Harry Gold. In its final wording, Gold's indictment charged that he collected information from Klaus Fuchs and delivered it to persons designated as John and Sam. The indictment was returned under the Wartime Espionage Act, making Gold's crime punishable by death or 30 years imprisonment. But by not requiring Gold to plead guilty to injuring the United States, the government omitted an essential element of the crime he was charged with. It was as if he had pleaded guilty to unlawfully possessing a loaded gun, after the prosecution had acknowledged that the gun contained no bullets. The deletion of the word intent from the statutory charge allowed Gold to plead guilty to the lesser crime, when the judge would punish him as if he pleaded guilty to the greater crime. A new charge was thus created for the first time, by judicial and prosecutorial fiat. The charge was not part of the federal criminal code. It was manufactured by the government and the prosecution. The new crime included mutually incompetent, vague, and incongruent specifications. The impermissible admixture would in its new form be the basis for the indictment of the Rosenbergs and Sobel. Only days after Gold's arrest, his brother told a reporter, "One thing is certain. We want nothing to do." 17. With a lawyer with the slightest red tinge. John D. M. Hamilton, a former Republican national chairman, and August B. Ballard were the attorneys appointed by the court to represent Harry Gold. On December 9, 1950, 5 months after his indictment, Gold was sentenced to 30 years imprisonment for conveying American atom bomb secrets to the Russians during World War II. The sentence was the maximum penalty short of death. Before it was imposed, Hamilton, after conferring with Gold, announced that there would be no petition for a reduction of sentence. This was Gold's decision, he said. "Mr. Gold," asked Judge McGraney, "do you have anything to say? Yeah, Your Honor, I will be very brief. First, nothing has served to bring me to realization of the terrible mistakes as this one fact, the appointment by this court of Mr. Hamilton and Mr. Ballard as my counsel. These men have worked incredibly hard and faithfully in my behalf and in the face of severe personal criticism and even invective, and they have done this not for the reason that they condone my crime, but because they believed that, as a basic part of our law, that I was entitled to the best legal representation available. Second, I am fully aware that I have received the most scrupulously fair trial and treatment that could be desired, and this has been not only in this court, but has been the case with the FBI, with the other agencies of the Justice Department, and with the authorities at various prisons where I have been lodged, both here and in New York. Most certainly, that could never have happened in the Soviet Union. Third, the most tormenting of all this concerns the fact that those who mean so much to me have been the worst besmirched. 18. By my deeds. I refer here to this country, to my family and friends, to my former classmates at Xavier University, and to the Jesuits there, and to the people at the Heart Station of the Philadelphia General Hospital. The judge then imposed the sentence, stating that it had been determined after long and deliberate application of the principles to the facts. Gold's praise of his lawyers, who offered no defense in his behalf, coupled with his patriotic comments and unmistakable happiness in receiving his sentence, could hardly be called a normal response. Who was Harry Gold, and what were his true motives? 19. Harry Gold was born on December 12, 1910, in Bern, Switzerland, to Mr. and Mrs. Samuel Golodnitsky of Kiev, Russia. 4 years after his birth the family moved to the United States. In 1930, a year after graduating from high school, Gold began his career as a chemist at the Pennsylvania Sugar Company in Philadelphia. He would work there for 16 years until 1946, when the company sold its buildings. His employment at Penn Sugar was interrupted only by a layoff in 1932 because of the Depression and by several leaves of absence to attend various colleges, including Xavier University in Cincinnati. He graduated from this institution with honors in 1940 at the age of 30. Information obtained about Gold's job, which apparently gave him leeway to travel about the country almost at will, is difficult to understand. One plausible explanation is that his employment was a cover for his espionage work for a covered arm of the United States government. The description of Harry Gold that was leaked to the press portrayed him as a gullible pawn of the communists. At the time of his arrest in 1950, he was employed as a senior biochemist on a federally financed heart research project at Philadelphia General Hospital. Gold was extremely conscientious and hard-working, said Dr. Daniel W. Lewis, a research fellow in cardiology at the hospital. He frequently put in more time on his job than he was called on to do. You wouldn't really take a second look at him. 20. Said Dr. Pascal F. Lucchesi, superintendent and medical director of the institution. He's only about 5 feet 4 inches tall, has stooped shoulders and always seemed to mind his own business. Other releases said that in college Gold tutored fellow students without pay, even going to their homes to save them car fare and travel time. At a local hospital he donated excessive amounts of blood, offered himself as a subject in dangerous scientific experiments, and did long hours of volunteer work with an intensity that left his colleagues with a lasting memory of him. His lawyer John Hamilton described him as the most selfless person I have met in my entire life. The press carried stories, never substantiated, of Harry Gold's willingness to loan money to anyone who was in need, even people he had never met. More than that, if someone asked for a loan when he did not have the money, he would borrow it himself at usurious rates so he could make the loan. Harry Gold was described as a naive man who had been duped, like many other kind-hearted Americans, into advancing the cause of communism, which they would soon learn was the greatest evil threatening mankind. J. Edgar Hoover wrote of Gold, in promoting the Red Cause, he had been almost morbidly self-sacrificial. Denying himself luxuries, spending hard-earned money, wasting vacation periods, making long trip. He gave everything he had, including his honor. Although too late, he had come at last to see that communism had robbed him of the conscience of a free American. In reality, Gold was very different from the man portrayed in the press. As mentioned, the information 21 available in the FBI files suggests that he was part of a select group of informers whom the FBI recruited, voluntarily or involuntarily, to search out Americans who were inclined to give industrial information to the Soviet Union, gather their names for future reference, check the material received from them first to appraise its value, and then either keep the material or alter it in such a way that the Soviet Union could not benefit from it. Beside Gold, the group included Morel Dougherty, Elizabeth Bentley, Jacob Golos, Thomas Black, and Ferdinand Heller, as well as several others. Thomas Black and Ferdinand Heller had been doing business for years with the Amturg Trading Corporation, the company representing the Soviet Union in the United States. In 1934, Black visited Amturg to inquire about seeking employment in Russia, and he was introduced to one Paul Peterson. According to both Black and Gold, Peterson was a Soviet agent who became Gold's first contact. The FBI had no difficulty in having Peterson identified as a Soviet agent, since people like Harry Gold, Thomas Black, and Elizabeth Bentley were so accommodating in identifying suspects. To protect themselves from mistakes, they would at first use phrases such as, "It looks like him," or "It could be him." The FBI would then check to see if that person was elsewhere when the crime or incriminating act was committed. If he was, the identification would be discarded and a new suspect presented. Aside from suspects who were dead, or who had left the country, the best suspects were those who were willing to confess to crimes they did not commit. This identification procedure, however, was not always accomplished without embarrassing errors. 22. According to an FBI report dated April 1952, both Black and Gold identified a photo of one John Henry DeGroff as the person they knew under the name of Paul Peterson. Both furnished signed statements to that effect. A June 3, 1952, FBI report stated. As of May 1952, Thomas L. Black and Harry Gold had positively identified Johnny DeGroff as their Soviet espionage superior from 1935, 1938 and the subject of instant case. But a serious problem arose. John DeGroff, who was not expected to be heard from, surfaced unexpectedly in Montreal and vehemently denied that he was Paul Peterson. Black and Gold, who claimed to have known Peterson, took several months to revoke their identification of DeGroff as their contact Peterson, though they were confronted with him face to face. This was astonishing conduct. They were claiming that a total stranger was the same man that they had known for some 15 years. Black, in finally withdrawing his identification, still hesitated to say so definitely. Gold, after considerable thought, believed DeGroff was not Peterson. If DeGroff had not appeared, or if he had been dead, like others who could not defend themselves from the FBI's identification system, he would have remained in our history books as the Soviet agent Paul Peterson. Worse, had DeGroff not had an alibi for his whereabouts, he might have been indicted. Gold stated that Black introduced him to Peterson in the latter part of 1935. They met in the vicinity of Pennsylvania Station in New York, and Black then left the two men together. Gold said that Peterson told him never to see Black again, but that over the years 23, he frequently met Black in violation of these instructions. Since Black was an apparent homosexual and Gold lived with Black after Gold's mother passed away, there is an inference that Black and Gold were lovers. Jacob Pass was another close friend of blacks who was a homosexual. Ferdinand Heller, though he was married, was also a close friend of blacks who may have been a homosexual. The homosexual implications surrounding Harry Gold are not mentioned to defame him, but because being a homosexual during those times was as dangerous as being a communist. Homosexuality had to be kept secret, and it may be one of the reasons that men like Gold and Black could be controlled by organizations such as the FBI. The threat of exposure to their family or employers was terrifying. An FBI report dated October 24, 1950, said, Gold steadfastly denies any act of homosexuality or of ever having been involved in anything of the sort. Morel Doherty, Gold's good friend, backed up Gold's denials, claiming that the allegation that Gold was a homosexual was laughable. What else could a friend of so many years say? Harry Gold's relationship with Thomas Black was so close that when it came to proving that he was in Albuquerque in 1945, he relied on Black to support his claims. Gold said he told Black that he was the person to whom Klaus Fuchs gave the information on atomic energy. Gold was confident that Black would support his story. But on May 31, when Black was first interviewed by the FBI, he stated that he never had any reason to doubt Gold's loyalty to the United States, and that he did not know of any trip made by Gold to Albu. 24. Quirk. Black's statement made him eligible for indictment. As we shall see, however, the government never had any intention of charging him with perjury, since once Black was certain of what was wanted, he quickly made his testimony conform to Gold*s. 2 weeks later on June 15, his statement to the FBI read, in the early part of February 1950 after the arrest of Fuchs, Harry Gold, told me that he had been Fuchs' American contact. Know this because he telephoned me from a hotel in Albuquerque. In retrospect, I very deeply regret that I did not at that time come forward with the information which would have aided in Harry's apprehension. These were very odd people, whose minds are almost beyond understanding. Black's comments about his group were protective of them in every way. Black stated to the FBI, Doherty is in no way involved in this things I'm sure, and the reason I'm sure is that he is very anti-Soviet and he's as good a Catholic as comes. I met Doherty through Harry and Harry never said anything about him except that he was very religious and anti-Soviet, and of course, I knew that after talking with him for 5 minutes. At the present time Heller stands precisely where I stand. I believe that this is by far the best country in the world for anybody to live in. It was time, however, for the group to draw away from Harry Gold. They had to appear to repudiate him. Even Morel Doherty, who was so close to Gold that they were referred to as the Goldust. 25. Twins, was forced to sever their relationship. An FBI memo which contained notes of interviews with Doherty quoted him as saying, I had been a friend of Gold's through working with him at the Penn Sugar, but after what he had done to this country to his friends and family, I felt that my friendship obligation had ended. Not likely. Gold and Doherty had both been engaged in criminal conduct of all sorts for years, espionage being only one of their many illegal enterprises. Indeed, Gold, when interviewed by an FBI agent on October 24, 1950, admitted that he and Doherty regularly stole as much as 10 gallons a week of alcohol from Penn Sugar and then sold it to employees for $5 or $6 per gallon. It is likely that Gold's enrollment at Xavier University in Cincinnati was for the purposes of initiation into the government's group of informers. His stay at Xavier was filled with discrepancies. The uninformed FBI agents investigating his comings and goings, unaware of his actual involvement, found a plethora of inconsistencies and unverifiable data. For instance, while Gold was attending Xavier, he claimed he worked at the Mumier Brothers Dairy Company for 1 year and 10 months. An FBI agent noted that the proprietor of the dairy found no records to indicate that Gold worked for the company and also does not recall Gold, which he claims he would if employed 1 year 10 months. There were other discrepancies. The same agent noted that Gold furnished an address, 19 Glendale Street, Cincinnati, during the summer of 1936. There is no number 19 on Glendale Street. There were many other puzzling questions about gold. When the FBI visited him in May of 1950, he requested that they wait several days to search his home. They complied, a strange performance by an 26 agency investigating the passing of atomic secrets to a foreign power. After all, if the FBI were truly worried about gold and considered him a spy, they would certainly have been concerned about the information in his house. One day, much less a week, would have given Gold or the relatives he lived with ample time to destroy the evidence. It seems likely that a covert unit of the government was preparing Gold and themselves for what was to be his partial uncovering. Apparently the agents who first apprehended Gold were sincerely shocked when they were instructed by their superiors to give Gold the time he needed to shape up his cellar before they finally arrested him. It is this writer's thesis that Gold's undercover role was a secret so carefully guarded that it was kept from the ranks of the FBI and known only to a select few. The FBI interviews of Morel Dougherty were so superficial that it is fair to surmise that the interviewer knew Dougherty's secret status. An FBI report dated June 27, 1950, containing Special Agent Albert L. Pierce's notes on one of these exchanges appeared to avoid all questions that would have established Dougherty's glue-like relationship with Harry Gold. In the same way, Dougherty's friendships with Thomas Black and Ferdinand Heller were not areas the government wished to have explored. The FBI had enough difficulty explaining the documents they found among Gold's effects in the basement of his Philadelphia home. His notes describing his contacts and their views on communism sounded as if they had been written for the FBI rather than the Russians. The federal agents who searched the basement, especially the agents who were unaware of Harry Gold's many secrets, must have been even more confused by the 27 vast amount of scientific blueprints and secret data that Gold had kept, instead of sending it to the Soviet Union like a real communist spy. Gold's contacts with the Amturg Trading Company occasionally allowed him to forward information to the Russians, who thereby received data that was either worthless or incorrect. Indeed, the Soviet Union frequently received useless information from major U.S. corporations who were pretending to be helpful. The process of providing a country that was our ally at the time with data that sabotaged its industrial growth was described by Gold at the trial of Abraham Brothman. Thomas Black also explained this process to FBI interviewers. Black claimed that he lied to his Soviet superiors about the nature of the work he had done, and that the written reports he gave them on such subjects as sorbose and the production of penicillin were wholly fabricated and in some instances set out processes which were impractical. Black's inhumanity was spectacular. He provided the Russians, who were so respectful of the Americans, with sabotaged medical information that could have led to the deaths of many Russian citizens. The secret notes found in Harry Gold's basement did not sound like the writings of a communist. Here is a sample. 7 Have been unable to locate the man I heard speaking in favor of Trotskyism at an acquaintance's home about a year ago. Have been trying to locate several people I formerly knew who may be able to introduce me to a member of that organization, but I had not had the time to follow this up as well as I want to. These jottings, written in the form of a diary. 28. Indicated that Gold was investigating communists rather than working for them. The style resembled a typical FBI report on suspected communists or communist S-37 Bathizers. An FBI memo dated June 23, 1950, concluded that the notes were fictitious. Under the circumstances the Bureau had no other choice. Looking through Gold's address book, the FBI found the name of a woman, Vera Kane, whom they interviewed on June 17, 1950. Their report said, during the period of the Depression from 1932 to 1935, she had an apartment at 325 West 11th Street which she used American Samoa, a sort of continuous open house for her bohemian friends. She gave out some 27 keys to the place and always had a meal ready for any of her friends who had a key and who might be hungry. Sometimes over weekends when a lot of the group would stop in at the place, they would sometimes stay overnight in groups of 6 or more. Thomas Black, in discussing Vera Kane, told the FBI in June 1950 that he did not know for certain that Vera Kane was aware of Harry Gold's espionage activities, but he suspected that she was aware because between 1937 and 1944 Vera Kane on a number of occasions told Thomas Black that Harry Gold was not one for Heller and Black to associate with and that it was very dangerous for them to associate with him. Kane apparently did not realize that Black and Heller were working for the government as well. Black also told the FBI that he and Heller had had a falling out because of Heller's jealousy over a woman Black had lived with in New York. The woman was Vera Kane, and Black told the story to contradict. 29. Any impression that he was a homosexual. He was deeply concerned with preventing his sexual preferences from being publicly exposed. Heller supported Black by confirming his story in every way he could, even to the point of remembering the date of the incident of heterosexual jealousy, November 7, 1934. Jacob Pass was another member of the Heller-Black Gold group. The background information on Pass supplied by the PBI files was that he was rejected for military service because of homosexuality. Pass said he was introduced to Gold by Black in 1945. His signed statement to the FBI, dated July 17, 1950, gave this account. I made the acquaintance of Thomas L. Black when we were both employed at the National Oil Products Co. in Harrison, New Jersey. In 1938. He confided in me that he had once been engaged in collecting technical information for the Soviet Union. He was quite dramatic about these revelations and told me that he was the only man in the United States to have been awarded the Order of Lenin though the medal was not delivered to him. He had told me previously that when he decided to cease his activities for the Soviet Union, 2 agents tried to forcibly remove him from the country and drove him to the Canadian border in Michigan if I remember correctly. He escaped. Thereafter he had lived in constant fear of his life. From my intimate knowledge of Tom Black, to the best of my knowledge he engaged in no political activity of any sort. As for the reason why Tom did not turn Gold in, he told me that he could not do it, because he considered Gold a friend. Perhaps on further reflections he would have recognized the other aspect of the man, and taken action. But Gold was arrested before he could come to any decision. 30. Unmistakably evident in FBI documents such as this were the loyalty, friendship, and support Black, Heller, Gold, and Fass gave one another. But this loyalty and friendship was not shared with other fringe members of the group, as the following FBI note referring to Dr. Joseph Skilton, dated July 13, 1950, demonstrates. Black advised the interviewing agents that Fred Heller had told him the previous day that Dr. Joseph Skilton committed suicide on Friday, July 7. Black had learned from Heller that Skilton had come to the conclusion that Black's purpose in giving him some air conditioning equipment for his office was to provide an excuse for Black to use the office as a meeting place for espionage activities. It appeared from Black's story that Skilton considered himself the victim of a plot concocted by Black and Heller. Black, Heller, Gold, and Fass's extended circle of friends and acquaintances was a bizarre group with a complex social structure. Blackmail and extortion were an integral part of their lives. Another FBI memo, dated June 14, 1950, tells us a little more about them. In it Dorothy Wiswell, the ex-wife of Ferdinand Heller, stated that she first met Ferdinand Heller in 1937 and started going with him socially. They were married in 1943 and subsequently divorced around 1945. Between 1937 and 1945 at the time of her divorce she estimated that she and Heller would drive to Newark NJ to see Black approximately once a month. There were times when Heller would visit Black without the presence of Miss Wiswell. She described Black as being a screwball. 31. For example, she stated Black had a pet black crow which had the run of his apartment. He also had some type of animal which she could not recall which Black kept in the bathtub. This animal lived in the bathtub. Blackie, according to her, did not drink and she never saw him in the company of women. Thomas Black and Harry Gold, though they were odd men, were extremely useful witnesses. Their bizarre personalities and the ease with which they provided false statements made them invaluable to the U.S. government. 32. Many innocent people would suffer as a result of Harry Gold's testimony. Alfred Dean Slack was one of them. Slack was charged with espionage for having sold industrial information to Gold from 1940 to 1944, while Slack worked at Eastman Kodak. In mid-June 1950, highly regarded news services described Slack as an atom bomb spy connected with Klaus Fuchs. Slack was universally condemned. On September 1, 1950, Slack, relying on his counsel's advice that he had no other choice, pleaded guilty. On September 22, he was given a sentence he never dreamed he would receive, a 15-year term. When he attempted to withdraw the guilty plea, his request was rejected. Yet Slack did absolutely nothing wrong. Every bit of information he gave to Gold could be found in the public library. The circumstances of Slack's arrest, guilty plea, and sentence were distressing. After being arrested and held on $100,000 bail, which he could not possibly raise, he was held incommunicado for about a week, then given solitary confinement, and finally placed on a suicide watch. Meanwhile, he was constantly interrogated by the FBI. After 3 weeks of this, Slack was permitted for the first time to tell his assigned counsel that he was innocent and had never even heard of Klaus Fuchs. In arguing his right to withdraw his plea of guilty, Slack said that from the day of his arrest until the day he pleaded guilty, he was constantly questioned by the FBI. He argued that one of his lawyers, Kyle King, saw him only twice, once at his initial arrest and again on the day of his sentencing, and that his 33. Other lawyer, Ray Jenkins, refused to see him, even though he had written to Jenkins requesting a meeting. Slack maintained that Jenkins had not properly represented him. Slack explained that he had asked Jenkins to check certain scientific archives which would prove that the information he gave Gold was taken from the public library in Cincinnati. Slack said that Jenkins ignored his requests. In the meantime, the only messages Slack received from Jenkins were delivered to him by the very FBI agents who were interrogating him. These messages, which Jenkins admitted sending, repeatedly cautioned Slack to cooperate with the FBI. Jenkins, who would later join Senator Joseph McCarthy in hunting communists, was actually aiding the FBI while representing Slack. The next time Slack saw Jenkins was in September, the day after his indictment. At that time, Slack was told by the U.S. Attorney that if he pleaded guilty he would be sentenced to 10 years in prison, but would serve only about 3 years. Slack said that Jenkins explained to him that because of the public hysteria there was no choice but for him to plead guilty. Judge Robert Taylor found no merit in Slack's arguments. The judge even added an additional 5 years to Slack's sentence, over the prosecutor's request that Slack be given 10 years. Judge Taylor explained his decision by saying, "Mr. Slack contends that the information he gave did not violate the law. Now, if he had known at that time that it did not violate the law, then he would not have entered a plea of guilty." Judge Taylor was arguing that even if Slack was not guilty of anything, once he pleaded guilty, it meant that he considered himself guilty, and that was enough to make him guilty. 34. Whether he was or not. Once Gold's testimony was deemed essential to the prosecution of accused communists, nothing could be allowed to remain that could detract from his authenticity as a legitimate Soviet agent. Slack had been accused by Gold, Slack had to be found guilty. 35. According to the FBI, Harry Gold first came to their attention in May 1947, while they were investigating Abraham Brothman, an enterprising chemical engineer who was head of his own company. Brothman was suspected of having dealings with an industrial spy ring led by the notorious Russian agent Jacob Golos and his assistant Elizabeth Bentley. One result of the investigation was that Brothman and Gold were compelled to testify before a grand jury that same year. Neither was indicted then. But in 1950, with the arrest of Julius and Ethel Rosenberg, Abraham Brothman had to be arrested as well. His and Gold's 1947 testimony before the grand jury, if allowed to remain uncontradicted, could establish that Bentley, Gold, and Golos knew each other at a time when it was essential that it be established that they had not met. Once Harry Gold was chosen to be a government witness against Julius and Ethel Rosenberg, major changes in his 1947 testimony were absolutely necessary. So although Gold had sworn that he had met Golos, he now swore he never did. Gold recanted all his testimony given to the FBI and the grand jury in 1947. Somehow, based on Gold's recantation, we were to believe that he was telling the truth about Golos in 1950. We had to conclude that just about everything he told the FBI and the grand jury in 1947, statements such as that he was introduced to Golos by a man named Carter Hoodless, an executive of Pennsylvania Sugar Company, and even his identification of a photo of Golos supplied to him by the FBI was all 36. Fabricated testimony, instigated and manufactured by Abraham Brothman, who persuaded him to lie to the grand jury. Gold, we were to assume, was no longer a liar. He had lied in the past when he was a Soviet agent, but now, as a government witness, his testimony was to be considered beyond reproach. The real circumstances under which Gold and Brothman met in 1941, according to the prosecutor, Irving S. A 3-carat pole, in 1950, were that Gold was introduced to Brothman by a Russian, Mr. Simanov, alias Sam. What was remarkable about this new real circumstances testimony was that it was manufactured in a way that could not be disputed. Almost every witness who could shed any light on the events was dead or unavailable. Jacob Golos was dead. He died on November 25, 1943, Carter Hoodless was dead. He died on July 2, 1942, and Sam Semyonov had returned to Russia. Abraham Brothman and Miriam Moskowitz, his friend and business partner, would be charged with an assortment of crimes relating to espionage and perjury in connection with Brothman*'s statement that Gold knew Bentley and Golos. At the trial, Elizabeth Bentley and Harry Gold would be the chief witnesses for the prosecution, Irving Sapel and Roy Cohn the prosecutors, and Irving Kaufman the judge, just as in the Rosenberg trial that would later follow. Judge Kaufman's credentials were formidable. At the age of 20 he graduated from Fordham Law School, first in his class and the youngest graduate in the school's history. Soon afterwards he was appointed a special assistant to the U.S. Attorney. In 1940, at the age of 30, he entered private practice with a friend, Gregory K. Noonan. Kaufman did extremely well. He was politically astute and found himself a 37. Confidential coordinator of federal patronage. At a young age he had the power to choose prospective appointees for the U.S. Attorney's office and even had influence in appointing judges. Judge Kaufman, who was only 40 years old when he presided over the Brothman trial, was carefully chosen by the government. His reputation as an anti-communist had already been established during his tenure as an assistant U.S. attorney. He was so obviously and vehemently pro-government that the administration was concerned only that his overly zealous rulings against accused communists could result in reversals in the appellate courts. The government's proposed case against Brothman and Moskowitz was not without internal opposition. Not only did agents of the FBI find the charges unsupportable, so too did members of the U.S. Attorney's Office. An FBI teletype from New York City, dated July 19, 1950, gave Assistant U.S. Attorney Thomas Donegan's appraisal of the contemplated indictment. Donegan does not feel he can prove Brothman perjured himself before 47 grand jury, since at time of testimony Brothman might have felt he actually met Gold through Golos. Donegan was not objecting on technical grounds, he was saying that the government had no case and that Brothman had done nothing to warrant prosecution. Yet abruptly and unexpectedly on July 28, 1950, the administration decided to indict Brothman and Moskowitz. An FBI memo read: Sapel does feel that it is possible to prosecute Brothman for obstruction of 38. Justice. U.S. Attorney Sapel is calling U.S. Attorney Gleason in Philadelphia to arrange for Harry Gold to come before the federal grand jury in the Southern District of New York on Saturday, July 29, in order that the grand jury can consider this before the statute of limitations runs. Just hours before it would have been too late to bring charges against Brothman and Moskowitz, Sapol had them indicted by a hastily assembled grand jury. Then he arranged for bench warrants against them and had them both arrested that same day, July 29, 1950. There was so much antagonism toward Brothman after his arrest that even though he had the $25,000 bail, A.J. bondsman would not write the bond, fearing that it would be considered unpatriotic. The crux of Sapol and the government's case was that Brothman had persuaded Gold to falsely claim that gold had been referred to him by Jacob Golos and Elizabeth Bentley. From the start the FBI was confused over what position to take on whether or not Bentley knew Gold. Bentley was equally unsure about what to say. To complicate the issue, as late as May 25, 1950, Gold was still maintaining that he knew Golos, making it axiomatic that he also knew Bentley, especially since he had already told the grand jury in 1947 that he did. Although the newspapers reported that Bentley and Gold knew each other, for the time being Bentley remained vague and non-committal. She would await further instructions from the government before she decided whether or not she knew him. A larger question is why the FBI did not ask Gold about having told the 1947 grand jury that he knew 39. Bentley if he really didn't. This was not a minor discrepancy that the grand jury and the prosecutor could have ignored at the time. Although Golos was dead and could not contradict Gold, Bentley was alive and a witness for the government. Jacob Golos' status and the government's treatment of him were equally peculiar. While Golos had been under investigation from, at the very least, late 1938 until his death on November 25, 1943, the FBI files contained scarcely a word about the man they considered one of the most important Soviet espionage agents working in the United States. As for Bentley, who had worked for Golos during that period, the FBI made it appear that she first became known to them in late 1945, 2 years after Golos died. It was not until June 6, 1950, that Harry Gold agreed to change his story about Golos. Gold now said that he never knew Golos and explained that the only reason he said he did at first was that Brothman had made him invent the story. Gold also said he had never met Bentley. So Bentley could now confidently state that she had never met Gold. Irving Sapol was ready to petition for his indictments. The charges against Abraham Brothman were obstruction of justice and perjury. They were based on the government's claim that Brothman and Moskowitz had persuaded Harry Gold to tell a fictitious story to the grand jury in 1947, to throw the grand jury off the track. 40. The Brothman-Moskowitz trial. The trial of the United States of America versus Abraham Brothman and Miriam Moskowitz began on November 8, 1950. Irving Sapol, the government prosecutor, addressed the court. The indictment which is before the court charges what conceitedly is the gravest of offenses: obstruction of justice, affecting the very stability of government. For witness was induced corruptly by these defendants to give false testimony, both the defendant Brothman and the witness did so, resulting in a diversion of the attention of the jury to a false track with a consequent delay of more than 3 years before the investigative processes of the government were put back in the right direction. 41. Sapol expanded upon his comments, until what he was saying was nothing more than an anti-communist speech. Sapol continued. The worldwide quest for communist totalitarian domination under foreign inspiration and direction is a movement to bring about by any available means and by force if necessary the overthrow of all existing governments of all countries including the United States. That the designation of this movement in any country as a political party is merely a false front of respectability behind which lurks a conspiratorial force devoted to violence and coercion ready to strike down the freedom-preserving means by which the people of the United States govern themselves. Sapol was expounding the prevalent fear of the day. Communism and Marxist-Leninist teachings were considered democracy's most serious threat. In the time of the Roman Empire it was Christianity. Ideas disruptive to the entrenched authorities have always been met with crushing force, including laws created to deny civil rights. In 1940 the Smith Act was passed, proscribing penalties for the teaching and advocacy of the overthrow of the government by force and violence. The law was mainly directed at communists. But the violence which the Smith Act sought to curb and which SA 3TOL referred to in his opening statement did not come from the American Communist Party. Whatever violence that did occur was directed at them. The Smith Act was not invoked very much in the 42. Early 1940s. The world was at war and Communist Russia was America's ally against Fascist Germany. But once the war ended in 1945, the anti-communist drive was renewed with vigor. The FBI under Director J. Edgar Hoover, the McCarran Committee led by Senator Pat McCarran, and the House Committee on Un-American Activities became the leading warriors in the battle to destroy communism in America. In June 1947, several high-ranking members of a group known as the Joint Anti-Fascist Refugee Committee, who were suspected communists, were charged with contempt of Congress and convicted of refusing to give the Un-American Committee the names of their contributors. They received sentences of up to 6 months in jail. In December 1947, 10 motion picture executives and artists, later known as the Hollywood 10, were indicted and eventually convicted and sentenced for refusing to tell the Un-American Committee their beliefs or to list their friends and affiliations. For this, the group of suspected communists were given terms of up to 1 year in prison. Since numerous additional arrests had not destroyed the Communist Party, the government decided that greater force was required. A new weapon was added, the blacklist. During 1947 to 1948, Attorney General Tom Clark, whom Irving Sapel and Irving Kaufman had formerly worked for, arbitrarily listed 160 organizations as subversive. To qualify, a group had to do little more than advocate equality for blacks, or higher wages for laborers. The government's drive intensified. On July 20, 1948, 12 leaders of the Communist Party in America were indicted for violating the Smith Act. They were charged in essence with thinking freely, speaking 43 freely, and assembling together. None of the 12 were charged with a specific act. There were no specific acts. Instead, they were accused of conspiring to teach and advocate the violent overthrow of the government. The basis of the government's case was extracts taken from the Communist Manifesto and other communist literature. Philosophical remarks of communist theoreticians were quoted out of context by government prosecutors in order to persuade the public that the nonviolent American Communist Party was actually bent on the violent overthrow of the United States government. As in most of the trials against communists, the government usually had an informer who, in exchange for liberal treatment and other rewards, turned against his former friends and associates. For the Smith Act trial, Louis Budens, the former editor of the communist newspaper, The Daily Worker, was the government's star witness. Budens testified that the Communist Party only pretended to defend democracy and that they used Aesopian language. In other words, Budens claimed that when communists said they wanted peace, they really wanted war. This was the kind of evidence presented by the government. On the other hand, the party showed that far from advocating violence, their program was directed toward improving conditions for the workers, toward racial equality, and toward peace. The party also presented evidence that they were not dominated or controlled by Moscow or any other government. Little that could be said mattered. On October 14, 1949, the jury found all the defendants guilty. Judge Harold R. Medina sentenced all but one of them to terms of 5 years in jail. 44. Appeals all the way to the Supreme Court did not help. The court declared the Smith Act constitutional and upheld the convictions. Communists and their sympathizers were on the run. 6-month sentences, then 1-year sentences, and now 5-year sentences were being given to people whose beliefs did not meet the approval of those in power in America. It was becoming more and more costly to be a communist, but still, communists were unwilling to give up their right to believe as they did. The persecutions intensified with an additional law enacted on September 23, 1950, the McCarran Act. This law declared that communism was an international conspiracy and all communists were foreign agents. The law also required all communists and all officers of Communist Front organization to register with the Subversive Activist Control Board. Once registered, however, the registrants were immediately subject to prosecution under the Smith Act. The Smith Act and McCarran Acts, taken together, made Communist Party membership a crime, made those who were not members but had similar beliefs subject to prosecution, and made them all the equivalent of agents of a foreign power. Going even further, the McCarran Act provided that in case of war or insurrection, concentration camps would be established to incarcerate people whom the authorities decided were subversives, with no need for trials. The destruction of the Communist Party in America was a program undertaken in earnest. The Brothman-Moskowitz trial was one more step toward the government's objective. After completing his reading from a congressional report, SA 5-OL stated, 45. As Your Honor may see from the indictment, the clerk's notes indicate that this indictment was found on July 29, 1950, on the very eve of the running of the statute of limitations. Here SA 5-OL made the first of his many false statements to the court. The indictment was filed late on July 31, 1950. The clerk of the court's records was altered, as shown in the accompanying exhibit, to indicate July 29, 1950. Sapel sought to have Brothman and Moskowitz put in jail immediately at the start of the trial. William Kleinman, counsel for the defense, protested. Mr. Kleinman, but there is no reason why Your Honor should even feel that it is necessary for the orderly process of this case to commit them. There is $25,000 bail for each defendant. Judge Kaufman, we have a policy in this courts regardless of what type case it is, that it is wise upon the commencement of a trial to remand defendants, aside from any application by the government carried purely on the motion of the court itself, I would remand the defendants. Mr. Kleinman, but the case has not yet started. Won't you wait until the case starts? Judge Kaufman, this case has started. On Friday, November 10, Judge Kaufman set out the legal basis for the trial. There are two laws involved in this case. One of them states in part, and I will read only that part which is relevant to this case, that, whoever corruptly or by threats or force or by any threatening letter or communication shall endeavor to influence, intimidate, or impede any party or witness in any court of the United States, or who corruptly or by threats or force or by any threatening letter or communication shall influence, obstruct, or impede or endeavor to influence, obstruct or impede the due administration of justice therein, is guilty of a crime. Another section of the Criminal Code states that it is a crime if two or more persons conspire to violate. 48. The statute that I have just read to you, and if one or more of such persons does any act to affect the objects of the conspiracy. For the prosecution, Sapel stated to the jury on November 13. This is not a contest between opposing lawyers. This is a trial of issues arising out of charges that the defendants deliberately corruptly sabotaged an investigation conducted by a grand jury of this court so that it was misled and misdirected and thrown off its proper course, and thereby the true administration of justice was defeated. I am fully confident of your verdict that these defendants are guilty after you shall have heard the evidence. For the defense, Kleinman told the jurors, it is our contention that there was no corrupt agreement between Brothman and Gold to have their testimony conform. Indeed, I think we shall be able to show to your satisfaction that in salient points their testimony did not conform. That there was no agreement, there was no corrupt agreement to impede the investigation then being conducted by the grand jury. Kleinman then addressed Judge Kaufman. Your Honor, I move for the exclusion of all witnesses during the trial and during the taking of testimony. Mr. Sapel, that is acceptable except the usual formula that agents of the Federal Bureau of Investigation may remain. 49. Judge Kaufman ruled in favor of Sapel. Thus, for no acceptable reason, FBI agents, who were witnesses like anyone else, subject to the same rules governing all witnesses, were permitted to remain in court, and hence could make sure that their testimony was consistent. Irving Sapel then called Donald E. Shannon to the witness stand. 50. Mr. Sapel, what is your occupation, please, Mr. Shannon? A special agent, Federal Bureau of Investigation. Mr. Sapel, now, Mr. Shannon, on May 29, 1947, were you engaged in your official duties as a special agent in the Federal Bureau of Investigation? A. That is correct, I was. Mr. Sapel, will you tell us where you were? A. I was out at the offices of A. Brothman Associates, in the Chatham Phoenix building in Long Island City, 41st Avenue. Mr. Sapel, at about what time did you arrive at those offices, Mr. Shannon? A. At about 11:15 a.m. In the morning. Mr. Sapel, were you alone? A. No, I was accompanied by Special Agent Francis D. O'Brien. We waited at the office, and approximately half an hour later Mr. Brothman came into the office. We introduced ourselves to him. We exhibited our credentials. And at the very outset of the interview, we exhibited to him a photograph. Mr. Sapel, that is a photograph of Jacob Golos. A. We asked him to look at the photograph and to advise us, to tell us, if he knew the party whose picture we had shown him. Mr. Sapel, what did he say or do? A. He looked at the photograph a short time. He turned the photograph back to us and he said, no, I don't know that man. We asked him to look again, to look carefully at the photograph. He did. He turned it back and he said, no, I don't know that man. We then asked him if he ever heard of a man by 51. The name of Jacob Golos. He said the name meant nothing to him. At that point we showed him another photograph. Mr. Sapel, did Brothman examine the photograph? A. Yes, if he looked at the photograph. We asked him if he knew the party whose picture we had shown to him at this time. He said yes, he did know the party. He then told us he did know the party whose picture we had first shown to him. I asked him who he was. He said he couldn't remember the name, but he knew the party. I then asked him why he had told us in the first place that he didn't know this party. He stated that he thought when we showed him the picture and we said we were investigating a violation of the United States and that espionage was involved, that this party perhaps had some connection with the Russian spy ring and that for that reason he didn't want to be involved. He said when we showed him the other photograph of Elizabeth Bentley that he realized then that perhaps we knew the story, and at that time he told us he did know both people. Mr. Sapel, did you have any further conversation in the course of your interview about his connection with Elizabeth Bentley and with Golos, whose picture he had identified, but whose name he was still unable to furnish? A. Yes, we asked him how he met this party Golos. He stated that this party Golos had come into his office sometime in 1938 or 1939 and that he advised him, Brothman, that he had some connections with the Russian government and that he thought that perhaps he could get some business for Brothman with the Russian government. He stated that subsequently after this meeting with 52. Golos, also in 1938 or 1939 carried Helen, we exhibited to him a photograph of Jacob Golos. Mr. Cohn, the same photograph you displayed to Brothman? A. The same photograph of Jacob Golos we had shown to Brothman that morning. He looked at the photograph for several seconds, maybe 60 seconds, maybe 100 seconds, and said, yes, he could recognize that photograph. It wasn't too clear but he was able to recognize it, and I asked him who it was. He said, that is John Golish or Gulish. I asked him where he met this person, and he said he met him sometime in 1940. At a meeting of the American Chemical Society in Philadelphia, Gulish or Golish gave him a telephone number at which he could contact Abe Brothman in New York City. And about 2 weeks later, he said, he put a phone call 56 through to Brothman in New York City and made arrangements to meet Brothman. He said that the meeting took place sometime after this telephone call which to the best of his recollection was in November of 1940. He said that on this occasion, Brothman turned over some blueprints to him. Gold's statement summarizing this interview was read to the court, and Brothman*'s attorney, William Kleinman, then cross-examined Special Agent Shannon. Mr. Kleinman, Mr. Shannon. In May, 1947, when you showed the picture of this Golos to Mr. Brothman, did you know whether he was alive or dead? A. I did. Mr. Kleinman, what was he? A. He was dead. Mr. Kleinman, when you showed the picture of Elizabeth Bentley, who was recognized by Mr. Brothman as Helen, you knew something about her, didn't *to you? A. I did. Mr. Kleinman, she had been under investigation, had she not? A. I didn't know that she was under investigation. Mr. Kleinman, you know that this man Golos had been under investigation? Just yes or no? A. I really didn't know whether he was under investigation. Mr. Kleinman, now, at the time that you first saw Mr. Brothman, can you tell us whether or not Miss Elizabeth Bentley had made any statements to the FBI or given any evidence to any agency of the government? 57. Mr. Sapel, that is objected to as improper cross and is irrelevant. Judge Kaufman, I will sustain that objection. John Foley, another government prosecutor, then questioned Mrs. Adelaide E. Lowe, the secretary to the grand jury that heard Brothman and Gold's testimony in July 1947. 58. Mr. Foley, Mrs. Lowe, are you a member of the federal grand jury that was convened on June 17, 1947? A1 was. Mr. Foley, and would you tell us on what date Mr. Brothman testified before the grand jury? A. Mr. Brothman testified before us on the 22nd day of July, 1947. Mr. Foley, Mrs. Lowe, did a Mr. Gold, Harry Gold, testify before the grand jury? A. He did. Mr. Foley, on what date did he testify? A. Harry Gold testified before us on the 31st day of July, 1947. Mr. Foley, Mrs. Lowe, what was the grand jury concerned with or directing its efforts towards at the time when Mr. Brothman and Mr. Gold testified before the grand jury? A. We were investigating acts of espionage. Mr. Kleinman, one have no questions of Mrs. Lowe. Judge Kaufman, very well. You are excused. Sapel began to read the 1947 grand jury minutes. Abraham Brothman, called as a witness, having first been duly sworn by the foreman, testified as follows. Q. Mr. Brothman, you were interviewed May 29, 1947, by special agents of the Federal Bureau of Investigation, is that correct? A. Yes. Q. And did you furnish those special agents Shannon and O'Brien with a signed statement? A. Yes. 59. Q. I show you grand jury exhibit number 6, and ask you, is that the photograph that was exhibited to you by special agents of the Federal Bureau of Investigation? A. Yes. Q. And you identified him as the man that contacted you? A. That's right. Q. And that is Jacob Golos? A. Yes. Q. Now, can you tell the grand jury about what date you first met him? A. Well, as I have recollected the thing, I believe it was about the early part of 1940, the very early part of 1940. Q. What commission did he say he was attached to and from which he had been dismissed at the time that you met him? A. As I recall, he said he was attached to the Government Purchasing Commission. Q. Which government? A. The Russian Government Purchasing Commission. Q. How did you happen to employ Gold? A. Gold had been working for the Penn Sugar Company. When he could no longer work there, I offered him a job in my place because I thought he was a very good man, and he has worked out to be such. Q. But your original contact with Gold was through Golos and Helen? A. That's how I originally met him. This statement made by Brothman that he met Gold through Golos and Bentley was the crux of the government's charges that Brothman committed perjury and obstructed justice. Mr. Sapel, I desire now, Your Honor, to read the testimony of Harry Gold, a co-conspirator, before the same grand jury. Mr. Kleinman, do I understand, Mr. Sapel, that 60. You are about to read Harry Gold's testimony? Mr. Sapel, that is right. Sapel then read the grand jury minutes containing Gold's 1947 testimony. Harry Gold called as a witness having first been duly sworn by the foreman testified as follows. Q. I show you a picture grand jury. Exhibit 69 and I ask you if you recognize the person appearing on that photograph. A. Yes, I do. Q. Under what name did you know this individual? A. I knew this man under the name John Golos. Was introduced to Golos by Carter Hoodless. Q. Did he mention that he had connections with a foreign country? A. No, he didn't. Gold said Golos never mentioned any connection with the Russians. Brothman said Gold had connection with the Russians. Gold's testimony often contradicted Brothman's in ways that drew suspicion to Gold rather than Brothman. The reading of Gold's testimony before the grand jury continued. Q. All rights, go ahead. Then you met Brothman? A. Then I met Brothman. Q. When you talked with Brothman, did you tell him who you were? A. Yes, I told him who I was. Q. What did you say to him? A. I told him that I had met Mr. Golos and that Mr. Golos had wanted me to come up to go over these various processes. Q. How long have you been employed by Mr. Brothman now? 61. A. I have been employed by Mr. Brothman since May of 1946. Q. Do you hold any office in his corporation? A. I am the chief chemist and I am due to be made a partner in the firm shortly. Q. Are you a member of the Communist Party? A. No. Q. Do you consciously belong to any Communist Front organizations? A. I wouldn't know what a Communist Front organization is. No. I would never belong to anything like that. Q. You are not married? A. I am single. Q. You said on the first 2 trips Brothman gave you some material to turn over to Golos. A. That's right. Q. You did not turn that material over to Mr. Golos. A. No, I never saw him again. Q. You took those blueprints back to Philadelphia? A. That's right. Mr. Donegan, did Mr. Brothman tell you the questions he was asked before the grand jury and what his answers were? The witness, no. He just told me that they would go into my background, my training and so forth, and that they would go into any connection that I had with John Golos. The reading of Brothman and Gold's 1947 testimony to the grand jury seemed innocent enough. How could Brothman's lawyers know that Thomas J. Donegan, the U.S. attorney who questioned them, was personally involved with another government witness called before that same grand jury, Elizabeth Bentley? But in 1950, after Irving Sapel decided to prosecute Brothman and Moskowitz and advised his staff that Elizabeth Bentley would be one of his witnesses. 62. He admitted he had learned that one of his assistants, Thomas J. Donegan, had known Elizabeth Bentley for years and had represented her in a civil action back in 1947. Sapel conceded that this fact, if known to the defense, could embarrass the government. But the FBI noted that nevertheless, Sapel seemed to be determined that Mr. Donegan take part in the scheduled trial. The dishonest and malevolent participation of the U.S. Attorney's Office was evident throughout their connection with the case. The civil suit in which Thomas Donegan, although he was an assistant U.S. attorney, privately represented Elizabeth Bentley was against U.S. Service and Shipping Corporation. This was a company that Bentley had once NM, which was being investigated for communist-inspired activities. Bentley, who was serving as a government witness in 1947, sued for back pay. According to an FBI memo, she threatened that she would probably be of no further use to the government unless this matter was resolved promptly and to her satisfaction. The case was settled on June 5, 1947, to Bentley's satisfaction. In the years that followed, Bentley demanded and often received cash payments from the FBI and U.S. government for her testimony. While several of the FBI agents refused to be intimidated by her and, as we shall see later, recommended that she not be paid for her testimony, finding her unreliable and mentally unbalanced as well, U.S. Attorneys Irving Sapel, Roy Cohn, and Thomas Donegan catered to her whims. After Harry Gold's grand jury testimony of July 31, 1947, had been read in its entirety, Elizabeth Bentley W.A. called to the stand. 63. Elizabeth T. Bentley, called as a witness on behalf of the government, being first duly sworn, testified as follows. Mr. Sapel, were you ever a member of the Communist Party? A. Yes, I was. Mr. Sapel, when did you join the Communist Party? A. About the middle of March, 1925. Mr. Sapel, will you tell us the circumstances under which you met Mr. Brothman first, and when? A. Yes, in the spring of 1940, after a conversation with Mr. Golos, I met Mr. Brothman at a Chinese restaurant which is on 53rd Street. We had a meal there and after that we had a long discussion. Mr. Sapel, before you had the meal, was there an introduction all around? A. Yes, Mr. Golos introduced Mr. Brothman as Abe Brothman, and he introduced me as Helen. Mr. Sapel, now go on and tell us, the introductions having been effected, the dinner having been had, what was the conversation amongst the three of you? A. Mr. Golos explained to Mr. Brothman that it would be rather difficult for him in the future to see him each week or each 2 weeks, and that therefore I would take his place in order to bring him directives from the Communist Party, to collect his Communist Party dues and to collect any material that he had to be relayed to Mr. Golos. Mr. Sapel, in respect to the payment of dues to 64. Which you have testified did Mr. Brothman pay Communist Party dues to you? Mr. Kleinman, I object to this, if your honor please, as not relevant to the issues and as incompetent and immaterial. Judge Kaufman, I overrule you on that. I thought yesterday I made my position clear, that on the question of motive, they will be relevant. A. Yes, Mr. Brothman did pay Communist Party dues to me. Mr. Sapel, how long did these meetings continue from the time of the first meeting in the spring of 1940? A. Until the early fall of 1941. Mr. Sapel, remember if you will the end period of your meetings with Mr. Brothman. Can you recall any particular matters which were discussed between you? A. Yes, there were a number of matters discussed between us. Perhaps the most important was that Mr. Brothman was dissatisfied with dealing with Mr. Golos and myself. He felt that neither of us were engineers or had any technical background, and that we did not understand his explanations as to the blueprints. He began to ask if we couldn't put him in touch with an engineer with whom he could talk them over. Mr. Sapel, thereafter, did you have anything to say to Mr. Brothman about that? A. Yes, not too long after that I told Mr. Brothman that it had been decided that he would be turned over to a new contact. He objected. Then asked Mr. Brothman to give me the license number of his car so that that license number could be turned over via Mr. Golos to the new contact. Mr. Brothman objected again. He said he did not understand why he had to 65. Meet people via that odd way. Why couldn't I or Mr. Golos do the introducing? I explained to him again that this was a decision of the Communist Party and he must abide by it. He ended by agreeing, and I wrote down his license number which I passed on to Mr. Golos. Mr. Sapel, did you know the person who was to be the new contact? A. No. Mr. Sapel, did you ever know a man named Harry Gold? A. No. Mr. Sapel, around this period of time that you have described in 1940 and 1941 had you ever heard of the name Harry Gold? A. No, I had never heard of Harry Gold. Mr. Kleinman, did you testify before a congressional committee in July of 1948? A. I think it was the last day of July that I started testifying. I am not entirely certain whether it was the 1st of August or the 31st of July. Mr. Kleinman, when did you first testify before a grand jury? A. In June 1947. Mr. Kleinman, at that time in June of 1947 were you asked questions concerning Harry Gold? Mr. Sapel, that is objected to if the court please. That is within the confines of the grand jury, and I do not think counsel has a right to go into that. Sapor's interjection at this point demonstrated his knowing participation in a fraudulent indictment. Sapol had introduced portions of the grand jury minutes to support his indictments, which hinged to a 66. Substantial degree on Bentley's claim that she did not know Harry Gold. Whether or not she testified before the 1947 grand jury that she knew Gold was of critical importance. Had she said she did, the indictments of Brothman and Moskowitz would almost certainly have been dismissed. Sapol's choice to withhold Bentley's grand jury testimony concerning her connection with Gold demonstrated a fraudulent intent that was endorsed by Judge Kaufman. Judge Kaufman, I do not quite see the relevancy. Mr. Kleinman, do you want me to make it clear? She has denied here on direct examination that she knew Harry Gold or that she ever saw him. I want to find out if there is any conflict between the position she took in 1947 and the one which she is stating now. I think that I would have a right. Mr. Sapol, I do not think it is at all material. Mr. Kleinman, I want to find out if she testified about Brothman on any of those occasions and if so, if there is any inconsistency between her testimony before the grand jury and her testimony in this court. Your Honor, I can't answer that by yes or no. I can only tell you that I don't remember. Mr. Kleinman, but sometime in 1950 did you testify before a federal grand jury in this building? AVCS, I did. Mr. Kleinman, at that time were you asked questions concerning one Harry Gold? I think I was, I can't recall. Mr. Kleinman, WELU at that time the name Harry Gold did have some significance to you, did it not? WELU very vaguely, Mr. Kleinman. Mr. Kleinman, you mean it was not reported in the 67 newspaper that a man had been arrested for spy activities in May of this year? Very vaguely, I paid little attention to it. But an FBI memo dated March 9, 1950, conclusively disputed Bentley's testimony. The memo confirmed that Bentley, who was a confidential informant identified by the FBI as Gregory, knew Gold and knew about his relationship with Golos. Prepared by Special Agent John R. Murphy, Jr., the memo stated, Gold, according to confidential informant Gregory, acted on behalf of Jacob Golos, known Soviet agent now deceased, in 1940 and 1941, in picking up blueprints from Abraham Brothman. The memo showed that Bentley knew Gold all along, and it provided confirmation of the Golos-Gold connection. It also established that Elizabeth Bentley, while working under her alias, confidential informant Gregory, told the FBI that Gold acted in behalf of Golos. It proved that Bentley, who claimed that she never knew Harry Gold, was the government's primary source for determining that Gold acted in behalf of Golos. It proved that Bentley committed perjury during the Brothman-Moskowitz trial when she testified in November 1950 that she never met Gold and only vaguely heard of him, when months before in March of the same year she provided the FBI with extensive material concerning Gold's relationship with Jacob Golos, the very relationship that Brothman was charged with having falsely described. The FBI kept this document of critical importance away from Abraham Brothman and Miriam Moskowitz. Hence they were prevented from proving they were framed and establishing their innocence. The cross-examination of Elizabeth Bentley continued. Mr. Kleinman, did you go along to introduce this new contact to Mr. Brothman? No. Mr. Kleinman, do you know if Mr. Golos went along to introduce this new contact to Mr. Brothman? Mr. Golos told me he didn't. Mr. Kleinman, you never saw that contact did you? No. Mr. Kleinman, you never asked who he was? No. Mr. Kleinman, did you not say in your testimony before the committee that, after Golos's death, you met a great many Russians, and that was the thing that decided you that you did not want to be a communist? I don't know what I said in the testimony. I can tell you exactly how many Russians I met since Mr. Golos's death. Mr. Kleinman, were they, in fact, Russians? That I don't know. One was definitely Russian. One I think was Lithuanian. The other, I don't know. Mr. Kleinman, and because of the conduct of these Soviet agents, you decided not to remain a communist? That is correct. Since one of them was the head of the Russian secret police in this country, it was a foregone conclusion that his behavior represent 70. Add the sentiments of the rest of them. Mr. Kleinman, as soon as you quit, did you go to the FBI? AN09 It took me some months to make up my mind what I should do. Mr. Kleinman, did you tell the grand jury all that you have testified to here concerning Brothman? Just yes or no? Are you referring to the first grand jury? The second or the third? Mr. Kleinman. Mr. Kleinman, WELU please help me out. I do not know. How about the first one? Let us take it that way. Did you tell them A? I can't recall whether I was asked questions about Mr. Brothman. Mr. Kleinman, how about the second grand jury? I can't recall either of those two grand juries asking me about Mr. Brothman. They may well have but I don't recall. Mr. Kleinman, search your memory please. I would like to find out whether you were asked anything about Brothman by that grand jury or before that grand jury. I am sorry 9 Mr. Kleinman I don't remember. I was asked about too many people. Mr. Kleinman, can you tell us whether or not you testified concerning Brothman before the 1947 grand jury? AN09 I cannot tell you. Mr. Kleinman, I make the request to make available to me, or to have your honor read in order to determine whether the minutes should be made available to me, the grand jury testimony of Miss Bentley in 1947 and in 1950. Judge Kaufman, on what ground? 71. Mr. Kleinman, on the ground that there may be matters there which are inconsistent with her present testimony and which should be made available to me for the purpose of cross-examination. Judge Kaufman, that may be present in every case that is tried here. You have to make some showing before me, as I understand the rule that there is something inconsistent. Mr. Kleinman, well, with a witness who denies any recollection of what she said there never can be an occasion for showing any inconsistency but I think it is the duty of the courts and I respectfully urge it. Judge Kaufman, there is an obligation on the court to read these minutes when there has been something that has occurred during the course of the case or during the course of the testimony of a particular witness to indicate that before the grand jury the witness said something which was inconsistent with what the witness is testifying to today. And to ask this court to sit down and go through that testimony and for this court in effect to be your counsel and determine wherein she was inconsistent with her present testimony, I do not think that is an obligation which should be. Kaufman prevented Brothman's lawyer from being able to show Bentley's inconsistent statements. Merely by saying she did not recall what she had previously said, her testimony, with Judge Kaufman's help, was unimpeachable. Judge Kaufman would not allow Kleinman to view the testimony she previously provided to grand juries. Kaufman's ruling in effect rewarded Bentley for her evasiveness and dishonesty, since no matter what she said, or claimed she did not recall, it could not be disputed or challenged. 72. Mr. Kleinman, I do not want to burden the court. But we have the most unusual condition with this witness. She has refused to give me any definite recollection of anything that she has said or what was said to her before the grand jury or before the congressional committees. She puts it as being due to lack of memory. Judge Kaufman, she says that she has testified before so many bodies grand juries and investigative committees, that she cannot remember what she told any particular body. Mr. Kleinman, and, therefore, I think that it is our duty today now to determine whether she did tell the grand jury anything about Brothman in 1947. Judge Kaufman, I have allowed you a wide latitude, but you have not shown anything inconsistent or even anything that comes close to being inconsistent. Even if she did or she did not tell anything about Brothman in 1947, it has not been established that what she has testified to here was inconsistent with what she testified to before the grand jury. Mr. Kleinman, she testified, you remember. She said that she told the FBI about Brothman in 1945 or 1946, but she cannot tell us whether she testified before the 1947 grand jury about Brothman. Judge Kaufman, your request might very well be for the FBI statements. I will not permit you to examine the grand jury minutes, nor do I see any necessity for me to examine them, in the absence of any showing before me that there is anything inconsistent. Mr. Kleinman, I take exception to your Honor's ruling. Now my next request, which your Honor has already anticipated, is that I ask to have available to 73. Me the records of what the witness Bentley told to the FBI as to the defendant Brothman. Judge Kaufman, of course that request indicates to me just how absolutely baseless is your former request for the grand jury minutes, and for the same reason I deny that request. Judge Kaufman's actions were unparalleled. After he teasingly recommended the FBI statements as a possible means of showing Bentley's inconsistent testimony, he denied the request of Brothman's lawyer for them. Bentley's statements, no matter how false or contradictory they may have been, were suppressed by the judge to protect Elizabeth Bentley from exposure as the dishonest witness she was. 74. Harry Gold took the witness stand and was questioned by U.S. Attorney Sapel. After Sapel established that a notation on a white card in Gold's handwriting that was found in the cellar of his home was competent evidence to support Gold's oral testimony that he met Brothman for the first time on September 29, 1941, Sapel asked Gold to describe that meeting. A. Brothman made inquiries of me. Abe asked me about the Soviet agent who had preceded me, and whom he identified as a woman called Helen. He also asked about the welfare of the Soviet agent who had come before Helen. Mr. Sapel, when he mentioned Helen and John, had you ever met either of them? A. I never met Helen or John. But if Gold came as a replacement for Helen, it was reasonable for Brothman to assume that Gold knew Helen and John, who was actually Elizabeth Bentley and Jacob Golos. After all, even at the trial Gold did not dispel the impression he gave Brothman that he was sent to him by them. Mr. Sapel, did you say anything at that time to Abe about your personal your marital status? A1 told Abe that I was married and had a wife and 2 children twins. Mr. Sapel, was that true? A. That was a lie. Judge Kaufman, on your meetings with Abe, did 75. You ever say anything to Abe about your Soviet superior? The witness, I told Abe I had a Soviet superior. I did not identify him by name. I only indicated I acted under orders from this Soviet agent. Mr. Sapel, at a meeting with Brothman in December, you had a conversation with him. A. I had a talk with Abe sometime around the middle of December of 1941. Mr. Sapel, what did you say and what did he say? A. I told Abe that in order to facilitate and expedite the transfer of information to the Soviet Union, that I had effected arrangements through my Soviet superior. Mr. Sapel, let me interrupt for just a moment. You have used that phrase Soviet superior. At that time, were you mentioning the name Sam to him or were you referring to him as your Soviet superior? A. I never mentioned the name Sam to Abe. Judge Kaufman, I must ask you Mr. Sapel, at this point, to address your questions to the witness in such a way that he does not testify to what Sam said to him or what he said to Sam until I am convinced that there has been a meeting between Sam and the defendant Brothman. Kaufman was instructing Sapel on how to question Gold. He wanted Sapel to show that a meeting took place between Sam and Brothman. To reach this end, the judge not only suggested the questions he wanted Sapel to ask of Gold, but advised Gold of the answers he expected to receive from him. Judge Kaufman, he can say I went to Sam. I saw 76. Him at such a time. Mr. Sapel, that is exactly what I am going to do now. Judge Kaufman, and after he saw Sam he saw Brothman. I don't want details. Kaufman's statement that he didn't want details was camouflage language to cover the detailed instructions he had given Sapel to present testimony that Gold first saw Sam before he saw Brothman. Mr. Sapel, thereafter, When did you see Brothman next? A. I saw Abe again sometime between Christmas and New Year's of 1941. Kaufman was still not satisfied with Sapo's efforts in establishing the proper sequence in the interrelationship of Gold, Brothman, and Sam. The judge impatiently questioned Gold for Sapo, interjecting the answer concerning Sam that he insisted on receiving from him. Judge Kaufman, after you met Sam, what did you tell Mr. Brothman? A. I told Abe that a report giving great praise to the Buna's work had been received. Kaufman, did you tell Mr. Brothman who gave you that report? A. Yes, I did. Kaufman, and who did you say gave it to you? A. I said it was my Soviet superior. Mr. Sapo, do you remember the occasion of a meeting with Brothman at which you received a report on mixers? 77. A. Yes, I do. Mr. Sapo, when did it take place? A. Sometime in November of 1942. Mr. Sapo, as the result of the conversation which you had with Sam Carrot and following the conversation with Sam, did you then have a meeting or a conversation with Brothman? A. I had a meeting with Abe following my talk with Sam, and I told Abe that a very important Soviet dignitary Carrot, a Russian official Carrot QS soon coming to this country Carrot, that he was making a special trip here for the explicit purpose of meeting with Abe and talking to him. Mr. Sapo, subsequent to that talk with Abe Carrot, did you arrange a meeting? A. I did. Mr. Sapo, where did the meeting take place? A. It took place in the Lincoln Ode 45th Street and 8th Avenue. The time was sometime in December of 1942. Mr. Sapo, what time did he arrive? A. WELU after we had been in the room for about 20 minutes SF there came a knock at the door and I opened it to admit Sam. Mr. Sapo, under what name did you introduce him to Abe? A. I told Abe that this man was George Just. George F. That's all. Judge Kaufman, let me ask you something, was George introduced as your Soviet superior or as the man that was coming from Russia that you had told Abe was coming from Russia? The witness, I introduced George as a Soviet dignitary who had come over especially from Russia. 78. How could Brothman know or be expected to know that Gold was referred to him by a Sam, a Soviet superior on September 29, 1941 when in December of 1942, Brothman did not even know a Sam even existed, and for the first time met a so-called agent codenamed George who, according to Gold, was really Sam. The government testimony connecting Brothman with Sam Semyonov was not remotely credible. Mr. Sapo, now Carrot, do you remember the 29th of May, 1947? A. I don't remember the 29th of May, but I remember an occasion a day or so prior to Memorial Day of 1947. Mr. Sapo, do you recall on that day at about 3 o'clock where you were? A. A little before 3 I was in the Elmhurst laboratory. Mr. Sapo, tell us what happened that day at that time. A1 went to Queens Plaza. And went up to the Brothman offices, that was a routine procedure with me. Mr. Sapo, what happened when you got into the office? Who did you see? A. Abe came forward. Mr. Sapo, what did he say? A. He said, look, Harry, the FBI was just here. They know everything. They know all about me. They know that you were a courier. It must have been that bitch, Helen. Mr. Sapo, what else did he say? A. They even have pictures of you and I together. You have got to tell some story to cover me up. They 79 are coming to see you this afternoon. Did you know John? I replied that I did not know John. Abe then said, you have got to tell the same story I did to cover me up. He then launched into a description of a picture that he said had been shown him by the agents of the FBI. Mr. Sapo, did he describe to you what the person in that picture which had been shown to him what that person looked like? Abe told me that the picture was that of a man with a wizened face, a wry grin, a receding hairline and curly hair, what there was of it. Mr. Sapel, what else did he say to you? Abe told me to identify that picture as John Golyas. He told me to make up any story to conceal the true facts as to how we had actually met, and said that I should tell the FBI that I actually met him, Abe, through Golyas. But according to Gold's own testimony, Brothman could not have known what Gold told the FBI. Whatever Gold said had to be different from what Brothman said. Any detail of how he was introduced by Golos to Brothman by definition had to differ from what Brothman said. Since Brothman did not give Gold any details, he could not possibly know what Gold would say. Tell some story to cover me up had to be a story that differed from Brothman *s. Sapel then asked Harry Gold what time the FBI arrived at his laboratory. A. Sometime after 4 o'clock, about 4 o'clock I would say, just about 4. After I had been there about 20 minutes, 2 men entered. It was a large man and a smaller one. They looked around and 80. They asked for Harry Gold. I came forward and said that I was Harry Gold. They said that they represented the United States government. They wanted to talk to me. The 2 agents Shannon and O'Brien showed me several pictures. Among those was one of a man with a wizened face a wry grin, receding hairline, and curly hair. They asked me whether I knew this man, just as they had asked me about the other pictures, whether I knew any of the others. I identified the man as John Golyas. Conveniently, the FBI agents did not ask Gold about Golos's bright red hair, his blue eyes, or his short stature, nor did the government claim that Brothman told Gold any of these physical details to prepare him for the FBI agent's visit. Mr. Sapel, I show you Government's Exhibit 2 in evidence, Mr. Gold. Do you recall whether that was the picture that was shown to you by agents Shannon and O'Brien? Is it a clear likeness? A. This is a picture that I was shown. Mr. Sapel, that is the man whom you had identified as John Golos or John Golyas, although you had never in fact seen him before? A. I had never seen him before. I have never seen him. Mr. Sapel, all right, continue. A. In the course of my talk with agents Shannon and O'Brien, I told them a completely false story involving how I had allegedly met Abe through John Golyas. Mr. Sapel, was it true or false that you had first met Brothman in 1940, in October of 1940? 81. A. It was false. Mr. Sapel, when actually did you first meet Brothman? A. On the night of September 29, 1941. There was no reason for Brothman to say he met Gold in 1940 rather than 1941. Nonetheless, every lie Gold told became Brothman's lie. But there was actually only one issue and one goal of the prosecution, to establish that Golos did not introduce Gold to Brothman so that Gold's relationship with Elizabeth Bentley and Jacob Golos could remain unexposed. Judge Kaufman, let me get back to something you just said, that so-called instructions or advice from Brothman was the only reason that you had for making those statements to the FBI. A. That is correct. Judge Kaufman, don't you really have reference to the fact that the type story that you were telling, in fact, was dictated by Brothman? The witness, that is correct. Judge Kaufman, as distinguished from the reasons so called. I do not know whether you see my point, Mr. Sapel. Mr. Sapel, well, as I see it, Brothman told him to tell a false story that he had told, and directed him to conform his story with his. Mr. Kleinman, Your Honor, I submit it is improper for these Judge Kaufman, disregard that statement of Mr. Sapel vs. Continue. Kaufman pretended to be correcting SA 57 poll when it was he who was reinforcing SA 5T, or's questions and 82. Coaxing the jury to believe that Brothman had instructed Gold to lie before the grand jury. Mr. Sapel, I merely tried to answer Your Honor's query. I think I see it eye to eye with Your Honor. Judge Kaufman, proceed. Mr. Sapel, did the defendants Moskowitz and Brothman arrive at the laboratory thereafter? A. Yes, they did. Mr. Sapel, what was said? A. The greater part of the conversation was between Abe and myself, and we reassured each other, kept reassuring each other, that very likely the FBI did not know as much about us as we had at first feared. Mr. Sapel, what was the subject of the conversation amongst the three of you? What did you talk about and what did you say? A. First Abe asked me to tell him the story, what sort of story I had told to the agents. And I related in detail the completely fictitious story involving Carter Hoodless and the American Chemical Society and John Goliash. Brothman *S asking Gold what he had told the agents indicated that he had no idea beforehand what Gold would be saying to them. To create a conspiracy, Brothman, who had already testified, would have had to ask Gold to falsify his testimony to match his. They would have had to make plans, define objectives, and rehearse their testimony. This did not occur. Gold was free to say anything he wished. Furthermore, unless there was constraint of some kind by means of force or fear to testify falsely, conspiracy to commit perjury could not be charged. If anyone should have 83. been in fear, it was Brothman. It was evident in the questions he asked Gold. Brothman was aware that Gold was a liar who could say anything. Mr. Sapel, about that time, do you remember driving to Pennsylvania Station with Abe? A. Yes, I do. I was going home to Philadelphia for the weekend. Mr. Sapel, when did you return? A. I returned a day or so later. It was, I think, the last day of the Memorial Day weekend. Went directly to Sunnyside to Abe's home. Mr. Sapel, what did you and Brothman and his wife do? Where did you go? A. We went to Peekskill, where Abe had a summer home at that time, some distance out of Peekskill, New York. Mr. Sapel, did you have some conversation with him that night about a visit that had been made to your home in Philadelphia? A. I told Abe that while I had been home for the weekend, in fact shortly after I had arrived, I had been visited by two Philadelphia agents of the FBI. These men had made inquiries about any blueprints of the Hendrick Company, which I had told agents Shannon and O'Brien might still possibly be in my possession, and the two men had conducted a very cursory search of the house. It wasn't even a search. They just asked about the blueprints, and I took them around the house and said there weren't any. Abe was greatly concerned about this. He was critical of the fact that I had even admitted to the agents Shannon and O'Brien the fact that there might be blueprints, and also to the Philadelphia men that there was the possibility of such blueprints. 84. Part of the FBI memo describing that visit to Gold *S Philadelphia home read: on May 21, 1947, Special Agents William B. Welt and Fred C. Bierkby contacted the home of Harry Gold, 6823 Kindred Street, Philadelphia. Harry Gold appeared cooperative and looked through his personal effects, which he stores at his parents' home, to determine whether any of the blueprints mentioned in referenced teletype were still in existence. He was unable to locate any such blueprints. Mr. Sapel, I want you to go back a period of some 6 weeks after that Declaration Day weekend. Do you recall some incidents one night when you were coming toward New York from Elmhurst, or when you were coming from New York to Elmhurst? Either way. A. When I entered the firm's offices, Abe told me that he had that day received a subpoena from a federal grand jury sitting in New York to appear and testify before them. Mr. Saj-Pol, do you recall a conversation sometime after that, perhaps a day or two, with Miss Moskowitz concerning this subject? A. Yes. Mr. Saj-Pol, what was the conversation? A. Miriam told me that she was concerned because, at that time, Abe had stated that he had considered changing the story he had originally told to the agents of the FBI, that is, considered changing it when he would tell it to the grand jury. And she said that she was going to try and get him to stick to the original story. Mr. Sapel, sometime thereafter. Did you and 85. Moskowitz and Brothman meet for dinner again? A. Yes, we did. Mr. Sapel, did Moskowitz say anything? Miriam told me that she and Gibby Needleman together had succeeded in persuading Abe from his desire to which she had told me about several days before to change the original story which he had given the agents of the FBI, and that between the two of them, with mostly Gibby being effective, that Abe had been persuaded to tell the same identical story he had previously given just before Memorial Day of 1947. If Gibby Needleman, a lawyer whom Brothman, Moskowitz, and Gold consulted, did what Gold said he did, it was perplexing why he was not indicted. According to Kaufman and SA5-Or's reasoning, he should have been. If obstruction of justice occurred, Needleman did more, not less, than what Miriam Moskowitz was charged with doing. Mr. Sapel, now I project you to the morning of Brothman's appearance before the grand jury. Do you remember that? Yes, if I do. Mr. Sapel, did you see Brothman before he left to go to the grand jury? Yes, I did. Mr. Sapel, did you have any talks with him then? Abe told me at that time, or asked me rather, he asked me whether there was anything at all that I should tell him now before he went up before the grand jury. I should tell it to him that morning. He said that he didn't want to go up before the grand jury and hear before them for the first time. 86. Of some incriminating incident or bit of evidence that might serve to trip him up. He said, "It is better if I hear it from you now." Gold was describing Brothman as worried about what Gold would say, rather than asking Gold to conform his testimony to his. Brothman wanted to protect himself from Gold. Brothman was worried that his truthful statements could be made to sound like lies. Mr. Sapel, did you see him after his appearance before the grand jury? Yes, I did. Mr. Sapel, describe the circumstances, and what was said. I asked Abe whether there had been any mention of my name. He said, no, there had not, my name had not been brought into any of the questions he was asked. If indeed Brothman wasn't asked any questions about Gold, how could Gold make his testimony conform to Brothman's testimony concerning Gold's relationship with Bentley and Golos? Mr. Sapel, do you remember the night before you were to appear before the grand jury? Well, before that and sometime in between, I can't place it accurately, sometime in between the time that Abe told me about the subpoena having come to the lab and sometime before the night that I appeared before the grand jury, Abe gave me a transcript, a copy, of the grand jury testimony he had given to the grand jury. It was a copy. He told me. 87. That I should read it over and use it for a guide. But I hardly glanced at it because he had also said after he had appeared before the grand jury, that he had left out certain things. Gold saying that he hardly glanced at the statement was his denial that he had entered into the conspiracy. Furthermore, once Gold admitted that the statement Brothman provided was incomplete, he was saying that he could not very well rely on Brothman's summary, since information was left out. All Brothman asked from Gold was a true story. Brothman never mentioned Carter Hoodless. Brothman never said that Gold met Golos at a Chemical Society meeting in Philadelphia. Those details were all Gold's invention. But even if we accept the government's version, there was simply nothing for Gold to alter or conform, since Brothman said that the grand jury did not question him about Gold's relationship with Bentley and Golos, they didn't even mention Gold's name. Mr. Sapel, did you tell the grand jury the same sort of a false story as you told to agents Shannon and O'Brien? Regarding the time and circumstances under which you and Brothman first met? Yes, I did. Mr. Sapel, how long did you remain with Brothman and Associates in their employ? I remained with the Brothman firm up until June of 1948. Mr. Sapel, about the time that your employment with Brothman, terminated, do you remember an incident when both Brothman and Moskowitz were absent from their places of business for some short interval? 88. Yes, Abe and Miriam Carrot late in May of 1948, went on a business trip to Switzerland together. Mr. Sapel, how long were they gone? About a week or 10 days. Mr. Sapel, when did they return? A. Very early in June of 1948. Mr. Sapel, what happened with respect to your employment by the Brothman firm? A. I left the employment of the Brothman firm right after Abe returned. Mr. Sapel, the last time you saw Brothman, what words did he tell you? If you remember? AWELU He said to keep the story clearly in mind, regarding the fictitious story we had originally told. Mr. Sapel, you may examine Mr. Kleinman. Mr. Kleinman, WELU How about your feeling with respect to your own country Mr. Gold the United States Did you consider whether or not you were helping or hurting the United States? A. I could not see that I was in any way harming the United States. Mr. Kleinman, and that was while you were doing this industrial espionage, is that right? A. That is while I was doing the industrial espionage. Mr. Kleinman, all that was necessary at that time, Mr. Gold, was for anybody to go over to an engineering place like Hendrick and ask for or request just what you have there on that blueprint, and he could have gotten it for a fee, is that right? A. That is correct, but I asked that question in November of 1935, and I got an answer. They said that they had an experience to the effect that people would give them information, would sell them a 89. SF American firms would sell them a process and that they would take it over there and put it in operation and they would find that somewhere down the line, someone from the top man or someone down the chain of command had sabotaged the thing. Mr. Kleinman, you mean by that, Mr. Gold, our American engineers were attempting to sabotage the Soviet people? A. I am repeating what I was told. Mr. Kleinman, all right. The next question is, did you believe that our American industrialists and engineers were sabotaging the Soviet people by giving them these spurious plans and blueprints? A. I knew that there were many people in the United States who disliked the Soviet Union. Mr. Kleinman, you did not answer my question, Mr. Gold. Did you believe that story when it was given to you? A. Yes, I believed the story. Mr. Kleinman, however, the information was available to anyone who could read the engineering books, is that right? A. That is exactly what they didn't want. They could purchase all the books they wanted at Barnes & Noble. They were interested in processes in proven operation in the United States. They wanted them exactly as they were in a plant and exactly as they were working in a plant. Mr. Kleinman, did you intend any harm to the people of the United States? A. I did not. Russia was an ally at that time. Mr. Kleinman, when were you arrested in connection with the charges you pleaded guilty to in Philadelphia? A. I went into voluntary custody on the 22nd of 90. May, 1950. Mr. Kleinman, when did the FBI see you in the month of May? A. They came to see me on the 15th of May. Mr. Kleinman, you were not then arrested? A. No, I was not. Mr. Kleinman, when did you first admit to the FBI that you were a spy? A. On the 22nd of May. Mr. Kleinman, that was some 7 days after they started to question you? A. That is correct. Mr. Kleinman, returning for a moment to the question of the nickel catalysts, on which we had some testimony, didn't you perform several experiments for Brothman either in your laboratory at Penn Sugar Company or some other place? A. Yes, I did. Mr. Kleinman, when? A. Sometime in either very late 1942, possibly early 1943. I am not sure of the dates, either. Mr. Kleinman, were you assisted in that work by somebody in the laboratory? A. Yes, I was. Mr. Kleinman, what is that person's name? A. Morel Doherty. Mr. Kleinman, how long have you known Mr. Doherty? A. 21 years. Mr. Kleinman, is Mr. Doherty married or a single man? A. He is married. Mr. Sapel, at this time I will start imposing an objection. Judge Kaufman, he said he was married. 91. Mr. Sapel, I am talking about the general line of questioning. I don't see its connection here. Judge Kaufman, I don't either. Mr. Kleinman, Whenever you went to New York, did you do so during the working day or at night? A. I did go sometimes during the working day. When I saw Abe, it was mostly at night. It was the longer trips that I utilized my time off for. Trips to see Abe I made in the evenings, most of them. There were a few that I made during the day. Mr. Kleinman, when you went off on these longer trips, who covered your work for you? A. Who covered my work for me? Gold's repetition of questions was his internal polygraphia response. Questions concerning Morel Doherty disturbed him. Mr. Kleinman, that is what I asked. A. Morel Doherty. Mr. Kleinman, did you tell him where you were going? A. No, I did not. Mr. Kleinman, did you tell him the reason for the trips? A. I did not tell him the reason for the trips. I always invented an excuse as to where I was going, but it was never the place where I said I was actually going. Mr. Kleinman, when you first met Abe, you told him about your family, didn't you? A. On orders from Sam. Mr. Kleinman, you started to tell Abe from time to time some rather intimate details of your marriage, didn't you? 92. A. Oh, yes. Mr. Kleinman, not only did you make up a wife and family, Mr. Gold, but you also made up a story about the death of your brother. Did you in that story include details of your brother having been a paratrooper and having died in a paratroop jump? A. I can't recall. Mr. Kleinman, these stories that you told Abe about your family and children and brother, they continued until the time the FBI first spoke to you in May of 1947. Is that right? A. Yes. They continued until the FBI spoke to me, the very first day, in 1947. Mr. Kleinman, that was the first time that you told Brothman that there was no truth in any of these stories you had told him, is that right? A. That is correct. Unknown to Brothman *S attorney. Judge James P. McCranery had ordered a psychiatric examination of Harry Gold, before the day he sentenced Gold to a 30-year term. The psychiatric report, dated December 9, 1950, described Gold as a neurotic and hostile personality with traits adding up to an imbalance. Mr. Kleinman, did you continue to see your Soviet superior in 1946? A. I did not. Mr. Kleinman, or in 1947? A. I did not. Mr. Kleinman, or in 1948? A. I did not. Harry Gold was incapable of testifying truthfully. The FBI and the U.S. Attorney's Office had several 93 statements in Gold's handwriting that attested to his meetings with his Soviet supervisor, Anatoly Yakovlev, in February and December of 1946. Mr. Kleinman, in September 1947, there were some negotiations going on with the Stanton Company and with A. Brothman Associates. A. That is right. Mr. Kleinman, you stated that there arose continually, or periodically at least, states of emergency. Were these matters also a financial emergency? A. The financial emergency was that there was simply no money for salaries. Mr. Kleinman, the Stanton contract was the only thing that indicated a hope of relief from these financial difficulties in 1947. Is that right? A. In 1948, 1947, or 1948, okay. Mr. Kleinman, it was promised that you would become and be made a member of the firm with a proprietary interest if you remained. Isn't that right? The witness, yes, I was promised, but a number of promises of a like nature were made starting from 1946 on. The situation was this. When there was no money, I was a partner. When there was money, I became an employee, and that didn't happen to me alone. Mr. Kleinman, there came a time when Abe Brothman went to Switzerland? A. That is correct. Mr. Kleinman, while Brothman was in Switzerland you went to the offices of A. Brothman and Associates as distinguished from the laboratory, is that right? A. I went there on a couple of occasions. Mr. Kleinman, did you look through the office files? 94. 2. For anything in reference to the Stanton Agreement or the Stanton Contract. A. I did not. Mr. Kleinman, did you have any occasion to go through the office files for anything? A. I did not. Oscar did. Mr. Sapel, Oscar who? Mr. Kleinman, Oscar Vago, I assume. The witness, Vago. Mr. Kleinman, did Oscar tell you that he did? A.O. Yes. In the event that Oscar Vago, Gold's co-employee at the Brothman firm, had any idea about appearing as a witness for Abraham Brothman and Miriam Moskowitz to dispute Harry Gold's testimony, and in so doing upset the prosecution's plans in other scheduled anti-communist trials, Irving S.A. 3-OL had a solution. He arranged for Vago to appear before the grand jury. Asked before the grand jury if he had gone to Hungary without his wife in 1929, and remained there until 1932, Vago replied that he had. Vago was indicted for perjury on September 20, 1950. Unfortunately, he had lied when he testified that he was outside of the United States for 4 years, it was only 2 months. He also lied when he claimed that his wife did not accompany him, she did. For these lies Vago was held in $50,000 bail, the equivalent of at least $1 million today, even though he returned to the grand jury a week later to recant his testimony. Vago, who was arrested only a few days before the Brothman trial began, would be treated without mercy. His attorney could not get his bail reduced. Finally, in June 1952, after both the Brothman-Moskowitz and 95 Rosenbergs-Sobel trials were over, Judge Sylvester J. Ryan, after finding Vago guilty of perjury on technical grounds, suspended his sentence. Vago had spent nearly 2 years in prison. In releasing him, Judge Ryan criticized the prosecution, noting that Vago had lied only to avoid being deported, since his student visa had expired and he was in the United States illegally. The judge recognized that Vago's indictment had nothing to do with his involvement in any of the pending espionage trials. The cruelty dispensed to this man was one more in the chain of heartbreaking acts of inhumanity that Irving Sapel dispensed during his tenure as a government prosecutor. Sapel achieved his purpose here. Harry Gold could say anything he wished concerning Oscar Vago without fear of contradiction. The cross-examination resumed. Mr. Kleinman, did you put in the call to Brothman? Did you tell him that there was no monies, that you wanted money? A. Oscar Vago had sent 2 cablegrams to Abe in which he said in effect, "F, we are starving. For God's sake, send us some money." Mr. Kleinman, however, Brothman did return within a few days, did he not? A. Yes, he did. Mr. Kleinman, was there a discussion as to how much money he owed you or the firm owed you for back pay? A. There was a discussion at a later date. He owed me around $3,800 or $4,000. Mr. Kleinman, now, to come down to May 29 to the power of 1947, did Brothman state that he had made a statement to the FBI agents? Asterisk. IES. 96. PIARRY Gold. Mr. Kleinman, Brothman did not say to you, "Tell the FBI that it was through Carter Hoodless that you met Galosh," did he? A. Brothman said to make up a story, any story, so I made up a story. Mr. Kleinman, between the 22nd of July and the time that you received your subpoena, did you have any further talks with Mr. Brothman about his testimony before the grand jury? A. I cannot recall any. Mr. Kleinman, did you indicate to Abe in your talks with him any desire on your part to tell the grand jury the truth when you appeared before it? A. One had no opportunity. The first thing that Abe did was to tell me that all he wanted me to do was to tell the same story that he had told the grand jury so as to cover him up. But Gold never knew what story Brothman told the grand jury. All we know is that Abe Brothman was not sure what he was going to tell the grand jury. And finally, after he did testify, all he told Gold was that he did not mention his name. Whatever Brothman swore to on July 22, 1947, was not forced upon Gold when he testified on July 31, 1947. Gold had nothing to conform his testimony to. Mr. Kleinman, did Abe threaten you? A. No, he did not. Mr. Kleinman, did Abe intimidate you? A. No, he did not. Judge Kaufman, are you about finished now? Mr. Kleinman, nearly, Your Honor. I have maybe another 15 minutes. I think I should be through with him in about 10 minutes perhaps. Do you want 97. Me to continue or wait until tomorrow? It has been a long day, Judge, and I am coming to the end of my cross-examination. Judge Kaufman, all right. You will assure me that it will be no longer than 10 minutes tomorrow? Mr. Kleinman, I started with 15, Judge, and I cut it down to 10, but I will promise you not to be repetitious. Judge Kaufman, I know what happens overnight. You will think of certain questions to ask that have not been asked. WELU, we will recess until 10:30 tomorrow morning, ladies and gentlemen. 98. On November 21, 1950, after Harry Gold had completed his testimony, Fred C. Birkby, a special agent of the FBI, was called as a witness for the government. Birkby was questioned by U.S. Attorney Foley. Mr. Foley, did you on June 3 and June 6 of 1950 conduct a search of the home of Harry Gold? Yes, I did. Mr. Foley, on what day did you search the living room? June 3, 1950. Mr. Foley, on what dates did you search the cellar? June 3 and June 6, 1950. Mr. Foley, in your search of the closets, did you find a folder? Yes, I did. Mr. Foley, a red folder? Yes, I did. Mr. Foley, what did that folder contain on the outside? On the outside, it was marked AB. Stuff. Mr. Foley, what did you find in that folder? The folder contains some blueprints, some papers with mathematical and chemical data, and a small white card. Mr. Foley, do you remember anything about the card? The card contains some handwritten material including what appeared to be a license number. Mr. Foley, what date did you find it? 99. On June 3, 1950. Mr. Foley, V-hat is the license plate number on that card? A2M9088/SIC, 2N9088. Birkby was the same FBI agent who had visited and searched Harry Gold's home back on May 31, 1947, and found nothing of value. Yet he was specifically called in to search Harry Gold's cellar on June 3, 1950, and this time he miraculously discovered Gold's handwritten notation with Sam's instructions to meet Brothman that a swarm of FBI agents could not find after 2 weeks of intensive searching. Joseph P. Walsh, a New York City patrolman, was then called as a witness for the government and questioned by U.S. Attorney Roy Cohn. Mr. Cohn, I would like you to examine Government's Exhibit 22 for identification. Patrolman Walsh. Does it indicate that a summons, a parking summons, was given to Abe Brothman? Yes. Mr. Cohn, and on what date? August 15, 1941. Mr. Cohn, does that also contain the license plate number of the car on which Brothman was given a ticket? Yes. Mr. Cohn, and would you read that license plate number to His Honor and the jury? A2N9088. Judge Kaufman, I might tell the jury that the purpose of this testimony was not to establish that Mr. Brothman was guilty of the hideous offense of 100. Receiving a parking ticket, but the purpose of it was to establish that he had a car in August of 1941 with the license plate 2N9088. Judge Kaufman was giving irrelevant testimony and aura of legitimacy, for the jury was persuaded to believe that evidence was mounting against Abraham Brothman. Brothman's license plate number, which he never denied having, was utilized as evidence against him merely because Gold had written it on a piece of paper. A false document from a false witness was being supported by the victim's truthful statements found within the document's contents. Benjamin G. Dan, a business associate of Abraham Brothman, was called as a witness by William Kleinman, the lawyer for the defense. Mr. Kleinman, and by whom are you employed, sir? A Hendrick Manufacturing Company. Mr. Kleinman, did you deal in any classified material? A. Not that I knew of. Mr. Kleinman, were any of those drawings or proposals secret in their nature? A. Not to my knowledge. Judge Kaufman, I take it that Mr. Kleinman is attempting to establish that it was just a normal business transaction that was being engaged in between Gold and Brothman. That is the purpose of this testimony, Mr. Kleinman, isn't that right? Mr. Kleinman, yes, sir. Judge Kaufman's tone denigrated Kleinman's defense that Brothman had engaged in normal business. 101. Transactions with Hendrick Manufacturing Company and Harry Gold. U.S. Attorney Irving Sapel then began his cross-examination of the witness, Benjamin G. Dan. Mr. Sapel, this is a question Mr. Dan which implies no personal reflection HUD is somewhat as a matter of course in connection with the progress of this trial. As an official of Hendrick Company can you tell us, was it customary to effect the payment of Communist Party dues in the course of your business as a means of sales persuasion? A. No, Mr. Kleinman, I object to that. Judge Kaufman, he answered. Kleinman then request I need Benjamin Dan. Mr. Kleinman, is there anything about the literature that you saw that has been called to your attention, or about any of the blueprints that attempted to describe or designate any product article or process which was secret or confidential? A. Not that I know of. Mr. Kleinman, Your Honor, I should like to make an offer of proof. The offer of proof is this. We have subpoenaed the public library and we have here the original publications in which there appeared these matters which I had marked for identification as having been published material of Brothman. Judge Kaufman, this is in furtherance of your contention that there was nothing secret about these processes, they were published articles. Mr. Kleinman, that is right, and common knowledge that people could have gotten by a little research. 102. Judge Kaufman, I am going to tell the jury in my charge that it makes no difference whether they were secret or not secret. Theodore R. Olive was then called as a witness for the defense. Mr. Kleinman, where are you employed? A. The magazine Chemical Engineering. Mr. Kleinman, did you from time to time publish articles of which Mr. Brothman was the author? A. Yes, sir. Mr. Kleinman, did there come a time when Mr. Brothman gave you a report on this manufacture of Buna's synthetic rubber which contained various mathematical computations and designs of the plants for the production of synthetic rubber? F. Yes. Mr. Kleinman, I offer that in evidence. Mr. Sapel, my objection is based on its immateriality. Judge Kaufman, I will receive it, but I want the jury to know now, and I will further instruct them again tomorrow, that with respect to the charge in this indictment, it is not material whether or not the reports or blueprints or any of the material that was given to Gold or Miss Bentley were secret processes or novel processes, or anything of that character. This is not the charge here. Kaufman adjusted to the evidence that there was nothing secret by saying it would not matter anyway. The jurors were instructed in a very real sense to convict Brothman and Moskowitz. They were told not to try to figure out why or what charge they would. 103. Be convicting them of, that was a technical area that they must leave up to Judge Kaufman. Kaufman continued. The point in this case is that they conspired to obstruct and impede justice, and all of this background was introduced for the purpose of establishing the true relationship between the parties. In other words, to show that they did actually obstruct justice, that the conspiracy was successful. But a conspiracy to obstruct justice meant just that. And yet no evidence was produced to show any obstruction of justice, other than Sapel's bare statement that the government was delayed in an espionage investigation for 3 years, without explaining in what manner the government had been delayed or obstructed. 104. I summations on November 22, 1950, William Kleeman presented to the jury his summation for the defense. Mr. Kleinman, I have asked you to scrutinize the testimony carefully, and I have asked you to look at the witnesses carefully, and I am sure that you will agree with me that the prosecution's case hangs basically and primarily upon the testimony of the witness Harry Gold. It is true that we have the testimony of Elizabeth Bentley, we have the testimony of Mr. Shannon, and there was offered in the case the grand jury testimony, but I am sure that you will agree with me that you must decide the guilt or the innocence of Abe Brothman and Miriam Moskowitz basically and primarily upon the testimony of Harry Gold. Ladies and gentlemen, who had the most at stake, who was the courier? It was Gold. And yet Gold wants you to believe that, when the FBI came into the picture, that he said nothing, and that Brothman said to him, "You've got to tell a story to get me out of this." Who was an accomplished liar, I might say, to the point of giving indications of not only being a schizophrenic but a pathological liar. Who could have built up such a story about a wife, about the courtship of a girl, the meeting of others, the close details about a marriage that never took place, about children that never existed? Who could have built up such a story except the most accomplished pathological liar? What was the purpose of all that? What kind of a man does these things, and how can you believe a man like that? You are asked to believe 105. Him now beyond a reasonable doubt. At the beginning of the case, I was terribly tied that you might get an idea that there was something so awfully mysterious about these blueprints. There was nothing mysterious about these blueprints. They dealt with standard objects and standard processes. They dealt with things that Mr. Brothman had originated, which were published, which were matters of common knowledge, which anybody with the least bit of knowledge could have gone to any of the textbooks and found out about, which you could have gotten from publications in the public library. There is nothing in this case against Miriam Moskowitz except that Gold testified that she was concerned because, at that time, Abe had stated that he had considered changing the story he had originally told to the agents of the FBI. That is, considered changing it when he would tell it to the grand jury. And she said that she was going to try and get him to stick to the original story. If the original story was a true one, surely he should not change his story, but is that any proof that she knew whether the original story was true or false when she advised him not to change his story when he appeared before the grand jury? Again, all you have is the testimony of Gold on this thing. You will recall, he made mention of the fact that his former employer in New York owed him $4,000, you see, it always rankled in his breast that he was fired, that he was thrown out of his place, and perhaps that his former employer owed him money. But what motivates a man like that? I said at the outset that he had a disordered mind, a devious mind, nothing that you and I can understand. He is not a 106. Summations person, we understand. But yet you are required under our law not only to understand /IIM, but to believe him beyond a reasonable doubt before you may convict Brothman, before you may convict Miss Moskowitz. The government then presented its summations. Irving Sapel argued. The defendant SF Abraham Brothman and Miriam Moskowitz ZF are charged in the indictment with having conspired and agreed together and with each other and with other SF to defraud the United States of America in the exercise of its governmental function of administering and enforcing the criminal laws of the United States of America and to influence obstruct and impede the due administration of justice. Abraham Brothman is charged, corruptly endeavored to influence Harry Gold who was a witness before the grand jury on July 31, 1947 and actually he did influence him. Furthermore, he obstructed, he influenced and he impeded the administration of justice. Was Brothman telling the truth to the grand jury when he denied to them that he had any connection at all with the Communist Party, or was that story, as the indictment charges, a false story? And isn't the truth that Brothman*'s meetings with these people was in his capacity as a communist, as a supplier of blueprints, documents, and information, complete details of processes, for the use and benefit of the Soviet Union? The true story was bared in this courtroom in the testimony of Miss Bentley, in the testimony of Harry Gold. Their testimony is proven truthful beyond possible contradiction by a little white card. Governments. 107. Exhibit 10, found many years after it was written and used, in a cellar in Philadelphia. The story is proven and supported by the silent but significant records of the police department of the city of New York as to the license number of Brothman's automobile 9 years ago in 1941. The truth of the testimony offered here by Miss Bentley, Gold, and others, is conclusively established by the failure of the defense to produce one solitary word contradicting any of this testimony. Mr. Kleinman, I must make an objection to that. Judge Kaufman, overruled. I will deal with that later properly myself. Think Mr. Sapel is fully familiar with the rules and with the dangers of trespassing the rules. Proceed. Thus Judge Kaufman let stand Sapel's remark that the defense had not submitted one word contradicting Gold's testimony. Kaufman's stance encouraged Sapel to continue in the same vein. The one issue at this time, as far as Gold is concerned, is whether or not he told the truth. His truthfulness is established by the testimony of the other witnesses, by documents, and even more eloquently by the fact that not one word Harry Gold has spoken in this courtroom has been contradicted by any evidence produced by the defense. Mr. Kleinman, I object to that. Judge Kaufman, denied. When the judge denied Kleinman's objection for the second time before the jury, he in effect endorsed Sapel's comment as that of his own. By his actions, Judge Kaufman let the jurors know that he wanted 108 summations them to believe that Gold was a truthful witness whose testimony had not been contradicted. Sapel continued. The FBI then went out to see Gold at the laboratory. Gold, following Brothman's direction, told his lying story and added to it the concocted explanation of how he had met John Golish as induced by Brothman, later on. Miss Moskowitz said that Brothman should stick to the same false story he had told the FBI. She said at that time that Brothman had shown signs of a desire to make some changes in his tale when he went before the grand jury. To block this, Miss Moskowitz vowed that she would use her powers to persuade Brothman to tell the identical false story to the grand jury. Gold testified before the grand jury on July 31. He spoke about John Golish, this man who Gold had actually never met. He gave the grand jury a story and information about John Golish that he could have gotten from only one person, the defendant Brothman. As the court will undoubtedly tell you, whether or not Brothman was giving the Soviet Union secret or confidential information, or whether Brothman was giving the Soviet Union established plans and processes which the Soviet Union wanted in the very form in which it was desired, is not the crux of this case. The charge here is obstruction of justice. That obstruction was perpetrated to retard an investigation of espionage to conceal the activities of these parties on behalf of the Soviet Union. The jury retired from the courtroom, and Kleinman, 109, asked Judge Kaufman to explain to the jury that the testimony of Harry Gold, who is an accomplice, is to be scrutinized and acted upon with great caution, and is to be subject to grave suspicion. If the jury does not believe the testimony of the witness Harry Gold, they must acquit the defendants. Mere association, suspicious circumstance, or even opportunity to commit a crime are not of themselves sufficient grounds upon which to base criminal responsibility, and the jury may not convict the defendant Miriam Moskowitz if they come to the conclusion that the evidence against her amounts to mere association, suspicious circumstance, or opportunity. There is no direct proof in this case that the defendant Miriam Moskowitz knew whether the defendant Brothman's statement to Special Agent Shannon and his testimony before the grand jury on July 22, 1947, was true or false. Judge Kaufman refused Kleinman's request, however, and made his own statement to the jurors. After first reading them the substance of the indictments brought against Brothman and Moskowitz, Kaufman stressed, "The obstruction of justice statute is one of the most important laws ever adopted. It is designed to protect witnesses in federal courts and also to prevent a miscarriage of justice by corrupt methods. This appraisal of the special quality of the obstruction of justice laws was Judge Kaufman's message to the jurors that as patriotic Americans he expected them to bring in a guilty verdict. Judge Kaufman Con. 110. Summations continued his statement to the jurors. The grand jury was investigating espionage and subversion in 1947. They had the right to know the true facts. If Harry Gold's present story is true, that grand jury might have uncovered the espionage activities of Harry Gold and others at that time, in 1947, and the grand jury had a right to know the true facts. As I have said, the grand jury had a right to get the true and unadulterated story. In considering the guilt or innocence of the defendants, you must first consider whether a false story as to their relationships was told by Brothman and Gold to the grand jury in 1947. If you find that a false story was told, you must determine whether the false story was the result of an agreement or an understanding. If so, who were the parties to this agreement or understanding, that is, who were the members of the conspiracy? To find Moskowitz guilty, you must find beyond a reasonable doubt that the relationship between Gold and Brothman was other than that testified to before the grand jury, that Moskowitz knew the relationship between Gold and Brothman to be other than that testified to before the grand jury, and that she was a member of the agreement to give false testimony before the grand jury, that is, that she cooperated in the mutual understanding or agreement. It is the government's contention that her conduct indicated that she knew the true or actual relationship. But Moskowitz, who came to work for Brothman years after the events concerning Brothman and Gold's meetings occurred, could not have known what took place between them. Whatever she knew was hearsay. 111. Under any circumstances, it was not possible for her to know the actual facts of an occurrence that happened years before she arrived. Given the temper of the time, however, Harry Gold had the power to destroy anyone the government prosecutors selected for him to destroy. After deliberating, the jury returned to the courtroom. The forelady, we, the jury, find the defendant Abe Brothman guilty of counts 1 and 2, and the defendant Miriam Moskowitz guilty as charged. Judge Kaufman, ladies and gentlemen, I want to thank you for your thorough and patient deliberations. I think your verdict was an intelligent one, and I think it was a proper verdict in accordance with the evidence in this case. I think that your verdict was a complete vindication, as far as I am concerned, of the jury system. I want to say to you, Mr. Sapel, that you have my congratulations upon a job well done. I think the evidence was exceptionally well presented. You had your problems because, as I understand, there was a most serious problem as to whether or not any indictment under our statutes could be found, and that it was due to your ingenuity in searching the statute books and finding the obstruction of justice statute, because there was a serious question about the statute of limitations having run on the matter of espionage itself. Kaufman recognized and appreciated the efforts made by Sapel to find a technical way to bring charges against Abraham Brothman and Miriam Moskowitz even though there was apparently no legitimate 112. Summations way to bring them. Kaufman also recognized that the statute of limitations may have run on all the charges as they were brought. Mr. Sapel, the tributes of course I appreciate. Really they belong not to me. They belong to the Department of Justice they belong to my able staffs particularly Mr. Cohn and Mr. Foley and Mr. Donegan, the Special Assistant to Attorney General McGrath, and to the Federal Bureau of Investigation with whom I have worked closely and well. Judge Kaufman, I want to say in reference to the FBI in this case that it is a revelation to me, because I have worked with the Bureau in years past as an Assistant United States Attorney and as Special Assistant to the Attorney General but it gives me great mental security and I am sure it does you ladies and gentlemen that we have an agency such as the FBI in operation guarding our internal security. Their work is truly amazing, particularly their work on Mr. Gold. It is just amazing. I think that Mr. Hoover and the Bureau should be congratulated in their work on this case and I ask you to please advise him of my statement. All that was missing from the proceeding was the singing of the national anthem. Judge Kaufman continued. Mr. Kleinman. I think it is proper also to say that you have the appreciation of the court for the way you demeaned yourself throughout this trial. You were an advocate all the way. It is most unfortunate that we do not have more lawyers, particularly in this type of case, who can demean themselves as you did. 113. You fought for your clients every inch of the way, you let nothing get by, and yet you acted as an advocate, and you have the appreciation of the court. Mr. Kleinman, Your Honor is very kind to say so. Thank you. 114. November 28, 1950, was the date scheduled for sentencing. On that day Irving Sapel addressed the court, Mr. Sapel, proceeding to Abraham Brothman first. He was considered to be a member of the Communist Party at large. I do know that on one occasion he addressed a meeting of a communist club in the Chelsea district, expounding his views. Turning now to the defendant Miriam Moskowitz. There is information that she, too, was an active communist, attending meetings in 1948 and 1949 of a Communist Party club in the Chelsea district. She is named in the first count alone with Brothman, the conspiracy count. In the light of the fact that the defendant Miriam Moskowitz was not concerned, as far as we know, with offenses related to espionage, it is recommended as to her on the first count that she be sentenced to the maximum term of imprisonment of 2 years, and also fined the maximum of $10,000. As to the defendant Abraham Brothman, it is recommended on the first count the same punishment be imposed upon him. As to the second count, that the maximum available there likewise be imposed, that is, 5 years, together with a $5,000 fine. Mr. Kleinman, I have been instructed by my clients not to make any presentation outside of the evidence in this case. I have been specifically instructed not to make any argument to Your Honor based upon any feeling of sympathy, and I, therefore, under instructions from my clients, refrain from advancing any such. 115. Arguments or suggestions to the court at this time of sentence. Since what we say here will gain some publicity if I only make this suggestion. I know that Your Honor will not confuse this case with the spy investigations, the atomic bomb revelations, Gold's activities as a spy, and Judge Kaufman, it is merely a question of degree. Kaufman's bias could not be contained. His every effort from the beginning of the trial to the end was to do as much harm as possible to Abraham Brothman and Miriam Moskowitz. Mr. Kleinman, the information that the defendant Brothman gave, I think it was even told to the jury, were matters of common knowledge open to the public. Mr. Sapel, may I just add a word? If these defendants had not indulged in their shenanigans in 1947, Harry Gold, what he stood for and what he did, might have been discovered 3 years earlier. If anything, the testimony Brothman provided led to Gold and should have resulted in his investigation. Brothman provided evidence that Gold was intertwined with so-called communist espionage agents, Jacob Golos and Elizabeth Bentley. Brothman actually led the FBI to Gold, Golos, and Bentley. But the government was impelled both to maintain the secrecy of Gold's undercover role and justify what appeared to be its own bungling in not pursuing Gold. By way of Judge Irving Kaufman and the prosecutors Irving Sapel and Roy Cohn, the government manufactured false charges against Abraham Brothman and Miriam. 116. Moskowitz, claiming it was misled by them. Judge Kaufman, the defendants in this case have not only been convicted of obstruction of justice CF, but what aggravated the case here is the fact that the obstruction of justice CF serious by itself was laid in the background of espionage. I said in my charge to the jury that the obstruction of justice is one of the most serious crimes on the statute books, because only by safeguarding the purity of the judicial process can it be protected. I believe those were my exact words. When you destroy the courts, you have made the first inroad, I believe, to the destruction of your country. When the verdict came in, I said it was beyond my comprehension that anyone would commit an offense of this character against this country, and what is strange about this is that the very country that these defendants sought to undermine, and the evidence was clear and the verdict of the jury was clear on that particular point, that the very country that they sought to undermine gave them a fair, a painstaking, and impartial trial, something they could not have obtained from the country they sought to aid. Kaufman was using Harry Gould's very words, the words in which he commended the judge and lawyers when he was sentenced to a 30-year jail term. Kaufman continued, "The parents of these defendants came to America seeking a haven from oppression, so that these defendants, their children, could be brought up in a wholesome atmosphere, an atmosphere which recognized that God had created a human being, the greatest thing which God has ever done." 117. There are so few safe havens remaining on earth today, and it seems to me that these defendants sought to undermine the staunchest supporter of freedom in the world today. I cannot understand. I said that when the verdict came. I repeat again, I just cannot comprehend why these defendants and others seek to destroy that which protects them from tyranny. The matter of imposing sentence, you know, Mr. Kleinman, is never a pleasant task for any court. It is almost a godlike function. You sit and pass sentence upon a fellow human being. In this particular case, I must say that I have deliberated. I have spent a great deal of time giving a great deal of thought to the matter of sentence, and I have come to but one conclusion, and that is that I regret that the law under which these defendants are to be sentenced is so limited and so restricted that I can only pass the sentence which I am going to pass, for I consider their offenses in this case to be of such gross magnitude. I have no sympathy or mercy for these defendants in my heart, none whatsoever. The sentence of the court is as follows: the defendant Brothman, therefore, is sentenced on count 2 to 5 years imprisonment and $5,000 fine. On count 1, he is sentenced to 2 years in prison and $10,000 fine, the sentence on count 1 to commence upon the expiration of the sentence on count 2, the defendant to stand committed until the fines are paid. The defendant Moskowitz is sentenced to 2 years on count 1 and a fine of $10,000, to stand committed until the fine is paid. At this juncture, another lawyer, Albert Sadler, 118, appeared on behalf of Brothman and Moskowitz. Mr. Sadler, on behalf of the defendants, we respectfully ask your honor to admit the defendants to Hale pending an application to the Circuit Court of Appeals pending appeal. Judge Kaufman, on what ground? You never called them to my attention during the trial. You mean by my failure to charge some of your requests? Mr. Sadler, yes, sir. Judge Kaufman, if I remember I think you only called 2 or 3 to my attention. Mr. Sadler, yes, but I think as the record appears the requests which were submitted to your honor asked that you specifically charge certain things and you specifically denied them, and the record so discloses. Judge Kaufman, how did they get into the record? Those were my notes. Mr. Sadler, they appear in the record. Judge Kaufman, they should not be in the record. I don't know how they ever got in there. Those were notes and should not be part of the record. Those were notes for my personal benefit when you came to the bench, and should not be in the charge. I think the stenographer extended himself on that and gratuitously put in something that should not be there, and the court will strike it out. This is the height of something or other. I have never heard of anything like that. He takes my notes off the bench and puts them in the record. That is to be stricken out. Judge Kaufman's denials of the defense lawyer's requests were so blatantly prejudicial that he had them deleted from the record. Because of the judicial 119 power of intimidation he possessed, Kaufman could get the stenographer to do anything he wished. So he simply had a portion of the stenographer's typed minutes deleted. Kaufman continued, instructing Sapel. Mr. Sapo, will you please take that up with the stenographer, that portion that should not be in the record. Those were my personal notes. The stenographer was over-ambitious and overextended himself. He was a very capable stenographer. He just is not a lawyer and does not know what is to go in and what isn't. I certainly do not want anything in the record that contains my personal notes as to just what I am doing to every charge. Mr. Sadler, the impression I got was that you were making specific rulings on each request. Judge Kaufman, no, that was a matter of convenience to me. By this means Kaufman prevented a number of appeals arguments from being raised. Judge Kaufman, I think I have made myself clear on that. I believe if you check with Mr. Kleinman, he will tell you the understandings and that was the procedure we agreed upon. And I want the stenographer instructed to correct the record accordingly. With respect to your application for bail, the application is denied. On July 26, 1951, the United States Court of Appeals upheld the convictions of Abraham Brothman and Miriam Moskowitz on conspiracy to defraud the government of its function of enforcing federal criminal 120 laws, but reversed Brothman's conviction of obstruction of justice, lessening his sentence by 5 years. 121. Elizabeth Bentley. The government prosecutions moved rapidly. The Brothman-Moskowitz trial had begun less than 3 weeks after Alfred Slack was sentenced in September 1950. Now, on December 18, 1950, less than 3 weeks after Miriam Moskowitz and Abraham Brothman were sentenced, the trial of the U.S. government versus William Remington was ready to begin. Remington, an economist working for the U.S. Department of Commerce, made a fatal error without realizing it. He defended himself against Elizabeth Bentley's charges that he was a communist by successfully suing her for libel. In so doing, he thoroughly discredited her. Early on, Bentley's credibility was not as yet of critical importance to the government. But once the 123 year 1950 arrived, and the U.S. Attorney General had decided to use Elizabeth Bentley as a witness in the government's case against the Rosenbergs and Morton Sobel, it was essential that her credibility be restored. The main case against the Rosenbergs and Sobel was in jeopardy of being lost unless Abraham Brothman and Miriam Moskowitz as well as William Remington were convicted of the charges pending against them. Sapel and Cohn succeeded in convicting Brothman and Moskowitz, now Remington remained. William Remington did not deny Bentley's claim that he gave her information. He just denied that there was anything improper about doing so, since nothing he gave her was secret. As he said, it was all printed data, or information released by the government in bulletin and other ways. Remington explained that he was introduced to a man named Jacob Golos, who said that his name was John and that he was a writer. In March 1942, Remington had dinner with him and his assistant who called herself Helen Johnson. Helen Johnson was actually Elizabeth Bentley. At dinner Remington said Golos told him that Bentley did research for him as well as for a group of writers who contributed to a publication called PM. Remington testified, "I was flattered that a writer of books should need my help." Remington said that Bentley met him on several occasions and often brought him communist literature. But, Remington reported, he became suspicious of Bentley when he learned that she was not connected with any writer at PM. We are talking about 1942, supposedly before Bentley turned government informer. Yet she and Golos were using assumed names, and lying to their contact. The implication is that whether or not Remington was 124 a communist, he had a reasonable instinct that warned him of something not right about Bentley and Golos. There would be no need for communist spies to overstate their communism by claiming to be connected with a liberal publication like P.M. if they were not so connected. It was only if they were pretending to be communists that they would make a great show of leftist affiliations. And indeed, Bentley and Golos' purpose was to entrap communists. They engaged in this purpose with a single-minded determination. They, like Harry Gold, went around the country hunting their communist prey. Elizabeth Bentley claimed to have been a communist, and a member of the Communist Party, for 3 years, from 1935 to 1938. But her story was that after 1938 she left the Communist Party. This was her explanation when evidence surfaced showing that after she graduated from college, she joined an Italian fascist organization in Italy, an odd act for an avowed communist. She accounted for this inconsistency by saying that she joined because membership in that particular group enabled her to get discounts on purchases. Bentley testified, "We all belong to it, not from a point of ideology, but simply because we got cut rates on various things. Before using Elizabeth Bentley as a government witness, U.S. Attorney Roy Cohn decided that a biographical sketch should be obtained from her. On October 23, 1950, the FBI gave him the report of Special Agent John J. Dennehy after he interviewed her on October 13. Dennehy wrote, "Miss Bentley was informed of the requests of Mr. Cohn and this matter was handled very elegantly by the agents. Miss Bentley, as usual, you took it in stride and advised that there 125 had been some occasions when she had been indiscreet and that if this information became known to the defense it would of course be rather embarrassing to her. After her indoctrination into the communist cause she stated that she became a real communist and, on many occasions shared her room with male communists. She related that on some very few occasions she probably had sexual intercourse with some of these individuals, but that for the most part it was just an accommodation in order to give these people some place to sleep. She related that it would, of course, be almost impossible for her to have a jury believe that while she was living at a certain address if 15 or 20 men stayed at her home at different intervals over a period of a month or two, that with a few exceptions this was merely an accommodation. She stated that, she had been indiscreet on some occasions but stated definitely that she was not promiscuous. Elizabeth Bentley was a fascinating and enigmatic personality. She told much about herself in a book she had written, an autobiography, Out of Bondage. The reader of this book is left with astonishment that the government would have been desperate enough to use a witness like her. The book begins. As the SS Vulcania sailed into New York Harbor that July day in 1934, I leaned on the deck rail and looked at the skyline wistfully. It was good to be back in my own country after a year's study in Italy, I thought, and yet what, really, was I coming back to? I had no home, no family. Nor was there much prospect of finding a teaching position. After Bentley told of joining the Communist Party. 126. She described her initial meeting and relationship with Jacob Golos, the man she called Yasha. I had been told he was a leading agent of the Communist Internationale, that I could trust him implicitly, and that I should obey his orders without question. Although short in stature he was powerfully built with a large head, very broad shoulders and strong square hands. His eyes were startlingly blue his hair bright red, and I was intrigued by the fact that his mouth was very much like my mother's. We usually met in small out-of-the-way restaurants where we would not be seen, and after eating drove around in his car. He would look over the material I had brought, listen to what I had to report, and then, going over the situation with me, point out what was important and what trivial and tell me what to look for in the future. Undoubtedly my greenness at undercover work exasperated him, but he was always very patient. He would carefully explain why I had done the wrong thing and then proceed to set forth the correct methods. My amateurish attempts to listen at closed doors and search waste baskets especially annoyed him. It was on a cold, snowy night in December that I discovered I was in love with him. His hand touched mine, I looked at him, and then quite suddenly I found myself in his arms. "I love you very much," he said, "yet there is the shadow of pain in my heart because I know what lies before us." I didn't understand what he meant. "I can see that you are puzzled," he said. "But then you don't understand the situation we are." 127. In, you and I have no rights under communist discipline to feel the way we do about each other. The whole fabric of my world seemed to be collapsing around me. "But that's absurd," I cried. "They have no right to demand that." "Yes," he said gently, "they do. If personal relationships are allowed to get in the way of the movement, we shall never achieve our goal. There is only one way out," he explained reluctantly, "and that is to stick together and keep our relationship unknown to everyone. It will be a hard life for both of us. We will not be able to live together, we will only be able to see each other occasionally. Do you think you would be able to do that?" I had already made my decision. Here was the man whom I admired, loved, and trusted. I belonged with him, no matter how hard the road ahead might be. Elizabeth Bentley's description of her love affair with Jacob Golos, who was married at the time to Celia Golos and had a girlfriend named Caroline Klein, only accentuated the power of her vivid imagination. Even if we believe that Golos actually told her that party discipline prohibited select members from falling in love, we can see that what he said to her was intended to keep her from getting too close to him. One night Yasha came to see me looking white and strained. "I'm afraid it's happened. Our offices were raided this morning by the Department of Justice and they planted agents at the front door to question anyone who comes in. It's very lucky that I told you under 128. No circumstances to come up there. Otherwise you might have been involved. I've been served with a Dutses Tecum subpoena," he said wearily, "and that means I *ve got to appear in court with all my files and documents. There's not time to destroy anything, and some of that material is going to involve our comrades badly. Why didn't I get rid of it before?" The indictment of world tourists went before the federal court in New York and the trial began. It seemed to drag on endlessly, first in New York and later in Washington. Yasha was on the stand hour after hour. The American authorities were trying to get him to admit that he had been mixed up in illegal activities, but solidly and unwaveringly he stood his ground. But the frightful strain was telling on Yasha. His red hair was becoming grayer and sparser, his blue eyes seemed to have no more fire in them, his face became habitually white and taut. When he came to see me, he would fall on the couch, trying to catch his breath after the 3 flights of stairs he had climbed. What was aging Yasha was not alone the grueling trial but the sense that he had let down his old comrades. The files which the Department of Justice had seized in their World Tourists raid proved conclusively that Earl Browder had gone abroad under a pseudonym and with the aid of faked papers. He was arrested on the charge of passport fraud. This seemed to upset Yasha more than anything else. "Earl is my friend," he kept saying, over and over. "I have known him for many years and I like him. It is my carelessness that is going to send him to jail." 129. According to Bentley's version, it was the material that Golos and perhaps even she had provided that led to the imprisonment of Earl Browder, the head of the Communist Party in the United States. Bentley describes Golos as asking rhetorically, "Why didn't I get rid of it before?" The answer was implicit in the question. Golos simply informed on Browder and provided the government with the information they needed to convict him. Over the years the FBI had been receiving extensive information from a confidential informant identified as T1 who was able to obtain information from World Tourists, Incorporated. It is not overreaching to surmise that Elizabeth Bentley, who was confidential informant T1 after 1946, was the same T1 who had been providing the FBI with data from World Tourists for several years before 1946. It was shortly after November 1945, when Bentley was said to have first begun working for the FBI, that she was given the code name Gregory, while still maintaining the same T1 designation. The name Gregory was with little doubt used by the FBI to identify information received from her after her status with them had changed in early 1946. The FBI and J. Edgar Hoover had been interested in World Tourists Incorporated and Jacob Golos for quite some time. On August 18, 1941, Hoover sent a teletype to the New York office, advised by return wire whether World Tourists, Incorporated now out of existence. A teletype reply the next day said, "World Tourists Incorporated still operating." Surveillance of J. N. Golos contemplated near future. Since J. Edgar Hoover was personally interested in Jacob Golos and World Tourists Incorporated, as far back as 1941, it is not logical to believe that the FBI knew nothing about Elizabeth Bentley, a 130 woman supposedly so close to Golos, until late 1945, when she first reportedly came to their attention. Bentley *'S story continued. "We were convinced that our telephones were being tapped, hence our conversations over the wire were purely business ones. Every so often a communist electrician would check the walls of Yasha's office inch by inch to make sure that no dictaphones had been planted. To be doubly secure, we never talked there unless the radio was turned on or one of us sat and continually jiggled the telephone receiver to break any sound waves that might be picked up by a hidden microphone. In general, we made it a policy not to keep too many incriminating documents in our possession. Those which it was absolutely necessary to preserve were carefully placed in the World Tourist Safe, and a complicated set of booby traps was rigged up to ensure against tampering. Bentley then explained that in mid-1941 Golos made an important contact with a group of communists who worked for the government in Washington. Jubilantly he came to my office one day to announce that he had just had a long and satisfactory conference with the leader of the group, who had come up to New York. "Who is he?" I asked curiously, knowing that I shouldn't ask such a question. But Yasha was quite willing to tell me. "His name is Nathan Gregory Silvarmaster, and I used to know him quite well in the party way back in the early 30s. He's a trusted comrade whose 131 record of revolutionary activity dates very far back, almost as far as mine." "He sounds like a good person, I said thoughtfully. "He is, and so is his wife Helen, whom you will soon meet. I am trying to persuade them to accept you as an intermediary. Your job is to sell yourself to Helen, make friends with her, and give her the feeling that you are completely reliable." It sounded like a tall order. The next day, however, found me in Washington on my way to 5515 35th Street NW. The door of 5515 was opened by a slight, wiry woman of about 40, with dark brown hair done in a knot at the back of her neck and rather wary brown eyes set in a face that seemed more Polish than Russian. Optimistically I hoped that I had made a good impression on her, but I had a strong feeling that she was still very suspicious. A week or so later Yasha informed me that the Silvarmasters had agreed to accept me as their contact, albeit somewhat reluctantly. "You'll have to let them get used to you gradually," he said with a sigh. "Greg is satisfied with the arrangement, but Helen suspects you of being an undercover agent for the FBI. We've tried to argue her out of that idiocy, but she's the kind of woman who relies heavily on feminine intuition, and she insists her hunches are invariably right." I laughed ruefully. It was bad enough to spend a good share of my time dodging the FBI without being accused of working for them. Yet, looking back on the episode now, I wonder whether Helen didn't have a deeper insight into human nature than all the rest of us. 132. It was in the summer of 1942 that I finally met Earl Browder. He had taken a summer cottage on a lake near Monroe, New York, WHE / he could rest and do some writing. As Yasha and I drove into the front yard, Earl was standing on the front steps, nonchalant in baggy trousers and a sport shirt, with his pipe in his mouth. Irv's wife Raisa came bustling in from the kitchen with plates and napkins, shouting imperious orders in Russian. She acknowledged her introduction to me briefly, almost without interest, and then launched into a long conversation with Yasha. Point one, wondered to myself just why Earl, who seemed so nice, could ever have been attracted to her. What I did not then know was that Raisa, even as far back as the revolution, had been a powerful figure in the GPU organization in Russia, and that she still worked for it. One of her duties was to keep her husband in line and make reports on him. Browder had evidently had no choice in his marriage. The powers that be in Moscow had issued the orders and he had had to follow them. Bentley did not have the remotest basis for claiming that Earl Browder had been ordered by the Russian Communist Party to marry Raisa, or that Browder was kept under party control by his wife. The truth is that Bentley was not a well woman. The FBI and the U.S. Attorney's Office had known since 1948 that she was mentally unbalanced. Nevertheless, they repeatedly maintained that she had never been treated for a psychiatric disorder. It was not until March 1958 that an FBI report admitted she received psychiatric examination in a Hartford hospital 10 years before. 133. In her book, Bentley said that one day Golos told her that the Communist Party wanted to separate the two of them. Anger seethed through me. They couldn't take me away from Yasha. I wouldn't let them do it. Over my dead body, I said violently. They can't do that to you, I said savagely. Just let me at them and I'll tell them a thing or two. They may be able to kick other people around, but they've never run into an American. Ordinarily we're peaceful people, but when we get mad we can be plenty tough. Soon afterward Yasha won a partial victory. Was not to be taken away from Yasha, and I would be able to continue on helping him with the other agents in Washington. I greeted the news with a whoop of joy. Now things were going to be all right. Sometimes in the midst of his pacing Yasha would stop and stare at me savagely. Then in the tone of a man being tortured beyond his endurance, he would cry out, if I turn traitor, turn me in. Bentley's reference to G.K. Los's mentioning his fears of becoming a traitor to the Russians was a curious comment. Bentley, after describing how Golos died on a Thanksgiving evening in 1943, then told about her last meeting with a Russian espionage contact, whom she identified as Al. I bring greetings from Moscow, he said expressionlessly. And now I think we should have dinner. Where would you like to eat? I asked steadily. Anywhere that is not near the Soviet embassy, he said. After all, I am a high official there and I. 134. Should not like to meet anyone I know. We'll go to Naylor's on the waterfront. At this hour of the evening there won't be many people. I hope the food is good, he said thoughtfully. Americans are such stupid people that even when it comes to a simple matter like cooking a meal, they do very badly. My face must have gone white, for he suddenly looked at me with the impersonal interest of a scientist viewing a germ under the microscope. Ah, yes, I had forgotten for the moment that you, too, are an American. But then you are very different from the rest of your fellow countrymen. You, at least, have brains. You are very fortunate. A great honor has just been bestowed on you. The Supreme Presidium of the USSR has just awarded you one of the highest medals of the Soviet Union, the Order of the Red Star. I stared at him. The Red Star, I said dazedly. I don't blame you for being overwhelmed, he said. It's an honor that few people receive. He pulled a clipping, in color, from his pocket. This is a facsimile of the decoration, he said precisely. The original will arrive very shortly. But you can take my word for it that this medal is one of the highest, reserved for all our best fighters. The Red Star entitles you to many special privileges, you could even ride on the streetcars free. Jacob Pass claimed in an affidavit for the FBI that Thomas Black told him that he had been awarded the Order of Lenin. David Greenglass said that Julius Rosenberg had received a citation from the Russians that had certain privileges with it in case he ever went to Russia. J. Edgar Hoover, in his article, The 135 Crime of the Century, wrote, the Soviets, to be sure, had honored Harry Gold. Gold had been awarded the Order of the Red Star for his outstanding work on behalf of the USSR. One of the privileges of the award was free trolley rides in the city of Moscow. Never once was the remotest evidence given of the existence of these awards. It was the cultic language of Hoover, Bentley, and Gold. Bentley continued. He stopped for a moment, then seeming to sense that I was not too impressed by this, he went on. Besides, you are a member of the most powerful organization in the Soviet Union. We are the ones who really rule the country. Just wait until you pay a visit to Moscow, you will be wined and dined and treated like a princess. We know how to reward our people for what they have done. A wave of revulsion and nausea swept over me. I thought for a moment I was going to be violently ill. Hastily I pulled on my coat and got to my feet. Vd better leave now, Al, I said unsteadily. Tm afraid VLL miss the last train. As he handed me into a cab, Al took my hand and kissed it. Goodbye, darling, he said. I didn't answer, for I think if I had I would have spit in his face. So this was what the top leaders of the communist world movement were like. A slow rage crept into me. I knew then what I was dealing with. We have all been fooled. The conclusion was inescapable. I must go to the FBI and tell them what I knew about Soviet undercover work in the United States. From now on I would be a notorious person, the Red Spy Queen. 136. 3 years after Bentley's book was received, another, very different book appeared, False Witness by Harvey Matisow. Like Bentley, Matisow was a former communist who wrote about what prompted him to turn on his former associates, falsely accusing many of them of being communists. Money, not fame alone, was an important consideration. Once Matisow saw the benefits that false testimony, especially against communists, could bring, he embarked upon a career of providing statements to the news media that he admitted he just made up. When Matisow was asked by a reporter from the Hearst publications, "How many student communists are there in the United States?" he replied, without any basis at all, "There are 3,500 in the New York schools." Matisow wrote, "Seeing myself on television and hearing reports of my doings on the radio all built up my ego. I considered myself a success. I had my identity. I was a national figure." Having established himself as a professional witness on communism in education, Matisow was besieged with requests for his services. William Jansen, superintendent of the New York City schools, hired him as a paid consultant in February of 1952. Matisow said, "As consultant investigator I contributed much to the intimidation of teachers. Signed affidavits incriminating people, some of whom were later suspended." Matisow's services were soon in demand by others. Even the New York City Police Department sought him out. He was also approached by Dr. John Jacob Theobald, president of Queens College. Matisow, who quit 137. College, was flattered. Here was a professional witness informer being sought out by the distinguished president of a college. Professor Theobald visited him at his cold water flat in Greenwich Village. Matisow described Theobald as determined upon cleansing his school of all non-American ideas. He didn't want communists or pro-communists on his campus and was looking to me for help. Matisow reflected, "I was on the lowest rung of the ladder of life, and yet with all this the president of a college, the superintendent of the largest school system in the country, the police commissioner of the most respected police department in the nation looked to me for counsel and advice." He described how his career as an informer advanced. "My testimony before the House Committee on Un-American Activities was successful enough to entice other committees to call me as a witness. The Senate Internal Security Subcommittee headed by Senator Pat McCarran of Nevada was the major recipient of my testimony. Was quite cognizant of the absurdity of my testimony. But I wanted the headlines and I knew the committee also wanted them." Matisow's sworn statement accusing a certain black actor was enough to cause the studio to cancel the actor's contract and blacklist him in Hollywood. Matisow wrote, "The basis for my statement on this actor, who was a Negro, was that I had known him to have associated with certain Communist Party members. The truth was I had never seen him at a Communist Party meeting and had no knowledge whether he was a Communist Party member or not." 138. About his dealings with Roy Cohn, Matisow said, "After my first meeting with Roy Cohn, the United States attorney prosecuting the Second Smith Act case against Communist Party leaders, agreed to be a witness at the trial. Preparing my testimony was not an easy task for Roy Cohn or me. We both knew that I had to supply stories telling where the defendants said violent overthrow of the government. Roy Cohn and I started to pore over the document SF picking out quotations. Cohn worked feverishly hard in getting me to memorize my lines so I would not miss my cue. This was not difficult for me. I loved play acting. I had to testify in regard to facts implicating each defendant and show that the defendant was guilty as charged. I could not give opinion as I had done before congressional committees. I had to remember conversations, or speeches that the defendants had made. I related a conversation with the defendant Alexander Trachtenberg. He, being a book publisher, had discussed a book by Andrei Vyshinsky, The Law of the Soviet State. The defense counsel bitterly objected to the admission in evidence of this book, but, I succeeded in getting into the record, that Trachtenberg had referred to a passage which incited revolution. This was not so. Shortly before this book went to press, I signed an affidavit describing how I had testified falsely at this trial. The following is an excerpt from the affidavit: the question of my testimony concerning the book The Law of the Soviet State, by 139. Andrei Vyshinsky, was first raised by Roy Cohn, Assistant United States Attorney, who worked with me in preparing my testimony. I informed him that Trachtenberg had discussed the price of the book. Cohn stated that this would not be sufficient to lay the necessary foundation for its introduction in evidence. Cohn pointed to a passage in the book and told me that that passage was important in proving the government's case. He then asked me if I had discussed anything with Trachtenberg which would tie him with this passage, and I said, no, I had not. Nevertheless, thereafter, in several sessions with Cohn, we developed the answer which I gave in testimony, tying Trachtenberg to that passage. We both knew that Trachtenberg had never made the statements which I attributed to him in my testimony. Matisow also related the circumstances that led to his trip to Salt Lake City in October of 1952 at the invitation of the Senate Internal Security Committee. At that Senate hearing, he claimed that the mine mill union had plotted to cut off copper production for the Korean War. Matisow wrote, "It was here that I had my first face-to-face encounter with Clinton Jenks, a man who was once a friend, and whom I later helped convict in a federal court. I was no more than 2 or 3 feet from him and was asked to repeat my charges. I testified that I had 3 conversations with him in which he told me he was a Communist Party member. Actually, there was no basis whatsoever for this statement of mine, and in January, 1955, the lawyers for Jenks's defense received from me a sworn statement to that effect." 140. My testimony alone had convicted Jenks. There were no other witnesses who could say Jenks was a communist and had violated the Taft-Hartley law. Harvey Matisow tried as best he could to expose a sickness that had enveloped him and so many others. He concluded his book and this unfortunate stage of his life with a sworn confession. Affidavit of Harvey M. Matisow in the case of United States of America vs. Clinton E. Jenks, January 20, 1955. Harvey M. Matisow, being duly sworn, deposes, and says, 1. I make this affidavit in support of the motion by the defendant for a new trial, and to do what I can to remedy the harm I have done to Clinton E. Jenks and to the administration of justice. 2. I appeared as a witness for the government against the defendant in the course of the trial in this court in January, 1954, on an indictment charging Mr. Jenks with having filed a false non-communist affidavit with the National Labor Relations Board on April 28, 1950. 3. The matters I testified to were either false or not entirely true, and were known by me to be either false or not entirely true, at the time I so testified. Matisow's efforts were ignored. Finally he was arrested, convicted, and jailed, not for providing false statements in his prior testimony, but for his later retractions which the courts held were false. 141. At William Remington's December 1950 trial there were many witnesses to testify to his loyalty, and indeed he was loyal. He merely had certain leftist beliefs that were strictly in the cerebral sphere. Remington was respected by his co-workers as a fair-minded person, who generally advocated positions unfavorable to Russia, though he may, when he was a youth, have associated with communists. To Remington's shock, the government presented as its first witness Anne Moose Remington, his former wife. She testified strongly against Remington, too strongly, claiming that Elizabeth Bentley visited her every 2 weeks to collect party dues while she was married to Remington, and that she saw her husband give Bentley some pieces of paper which were top secret. She said her husband told her in 1938 that he was a communist. She also testified that she and her husband attended Communist Party meetings. Under cross-examination she was unable to recall any other people who attended these Communist Party meetings. She admitted that she did not know how dues were computed and she and her husband had no dues book. She also acknowledged that when she and her husband attended a Marxist class in economics in New York, her husband challenged the doctrine of the communist speaker so forcefully that the two of them had to leave quickly. One key setback for Remington's lawyer, William Chandler, was the rulings of Judge Gregory K. Noonan, who refused to allow the defense to see Anne Remington's grand jury minutes, which bore stark evidence of the intensive questioning she underwent for 5 hours. 142. Before she finally agreed to testify against her ex-husband. There was another curious but not innocuous fact concerning Judge Noonan. He was a close friend of Judge Irving Kaufman. Indeed, they were more than friends. They had been partners in a highly successful law firm before they were both appointed to the federal court. Judge Noonan*'s appointment was no doubt owed in some degree to Judge Kaufman. While he was still practicing as an attorney, Kaufman held the powerful position of confidential coordinator of federal patronage and consequently had the power to recommend Noonan for judgeship. Before the trial could get underway, it was learned that Irving Sapel had been intimidating witnesses called by Remington. Sapel was seeing to it that they were first called before a grand jury controlled by his prosecution team. Witnesses called in Remington's behalf were terrified by these tactics. Chandler's office bitterly charged that the government was using the grand jury for the sole purpose of intimidating potential defense witnesses. Chandler described Sapel's tactics in a December 28, 1957, article written by Fred J. Cook. We had gone up to New Hampshire and we located two witnesses both Communist SF who knew the makeup and membership of the Communist Party and the Young Communist League of the state. One a woman was a party official with access to all the membership records. She had checked them and told us that Remington's name definitely did not appear anywhere. We told them we would call them when we needed them. Then I suppose I made a mistake. I telephoned them from my office using my regular phone and told them to come to New York. The next 143 morning when they arrived, two FBI agents were waiting on the station platform with subpoenas for them to appear before the grand jury. They were so frightened that they notified us they would claim their constitutional privilege and refuse to testify. And so we had to let them go back to New Hampshire, unheard. But William Remington was the victim of an even greater outrage. John Jaland Brunini, the foreman of the grand jury, who had been so effective in making certain that Remington was indicted, it came out, was closely involved with Elizabeth Bentley and had done editorial work on her autobiography, Out of Bondage. Chandler produced two witnesses who testified that Bentley and Brunini had a contract, entered into before Remington was indicted, that guaranteed him part of the profits of the book. One of the witnesses, Eileen Collins, the publicity director of the publishing house, testified to her knowledge of the contract. Mrs. Collins said that these facts had troubled her conscience, and that at her urging, a law student who was a friend of hers called Judge Noonan*s chambers and told his clerk these facts. Judge Noonan at the time stated, "This is the first time I ever heard of it." Whether or not Judge Noonan heard it for the first time or not was immaterial, he was hearing it now. John Brunini and Elizabeth Bentley were helping prosecute William Remington for a financial reward. During the trial it became clear how SA5OL had managed to get Remington's ex-wife to turn against him. SA3 asked Remington, "Now will you say whether it is true or not that you committed adultery with another woman named Jane?" Remington answered, "Yes." Though his extramarital affair occurred, as he testified, after my wife and I were 144 estranged, it still was painful enough when heard by Ms. Remington to have her testify vindictively against him. Remington was convicted on February 7, 1951, and sentenced to 5 years in jail. He remained free on bail until August 21, 1951, when his case was heard on appeal and his conviction reversed. But Irving Sapel, Roy Cohn, and the government could not accept the reversal. In early 1953 Remington stood trial again, not for the old charges of espionage or communist affiliation, but for lying in his testimony when he denied the government's charges. Instead of going to trial on the old case, the government just claimed that it lost the case on appeal only because Remington lied. For the second trial, Miles Lane was the prosecutor, and the judge was Vincent L. Leibel. The trial moved quickly to a conclusion. On January 27, 1953, Remington was convicted of 2 counts, lying when he denied passing documents to Bentley, and lying about his membership in the Young Communist League. This time Remington failed on appeal. Later Remington's lawyer, Chandler, in an interview, explained what led him to appeal the first conviction. He spoke to the attorneys for Remington's ex-wife, who told him that the circumstances of her appearance before the grand jury were so peculiar she would not even discuss them with them. Finally Chandler was given access to the grand jury minutes. They showed, he said, that for 3 hours Carrot and Remington's story was the same, generally Carrot as her ex-husband's. In essence Carrot it was this: she and Biluqt one time had friends who were communist SF but they had never been members. Bentley Carrot she 145 said, had never figured much in their lives. This was the gist of her testimony before the grand jury. Then, Brunini, the foreman, the man who helped Miss Bentley with her book, really took over. He accused Anne of lying and trying to protect her husband. She protested that it was late and that she would like to go out and have some lunch and consult her lawyer. Brunini told her she could get something to eat when she told the truth, that everyone knew that her husband had been a communist. The misconduct that occurred secretly behind the closed doors of the grand jury was surpassed only by the monstrous conduct of Irving Sapel. An FBI report dated October 31, 1950, written by Special Agent J.G. Spencer, shows that Sapel and his assistant Thomas Donegan, the same assistant who represented Bentley in a civil matter years before, knew all along that the grand jury foreman, John Jaland Brunini, was working closely with Elizabeth Bentley. The report also demonstrated the FBI agent's serious concern in regard to this matter. It read: after some deliberation between Donegan and Sapel suggested that Miss Bentley be asked to come to NIS, Sapov's office as soon as possible that morning, October 30. During the conference Miss Bentley was interrogated by Mr. Donegan and Mr. Sapel concerning her relationship with John Brunini, who incidentally is also a resident of the Shelton Hotel where she is presently residing. The seriousness of this situation is of course concerned with the fact that Brunini was the foreman of the grand jury that indicted Remington, and during the progress of the grand jury Brunini met Bentley socially, talked about her writing a book, arranged a 146. Publisher for her. Carrot obtained an advance of $2,000, and subsequently collaborated with her during the trial. Sind at the present time is editing this book. Donegan volunteered that during a recent conversation he had had with Brunini regarding this incident, Donegan asked Brunini if there had been any intimate relations between himself and Miss Bentley, and he denied that such was the case. At the conclusion of the conference both Mr. Sapel and Mr. Donegan agreed that Miss Bentley should be moved to a different hotel. Regarding Brunini's tactics with Remington's wife before the grand jury, Chandler said that Brunini told Anne Remington, "We have teeth but we do not like to use them." Chandler continued, "Time and again, the other woman was thrown in her face. Finally, after a whole hour of this, she came around and gave out the version she told from the witness stand. We were not allowed to keep those grand jury minutes, but I made an affidavit of what was in them, and this went up to the appeals court. It was this that formed the basis for Judge Leonard Hand's strong dissent." William Remington was sentenced to 3 years in jail. While in jail he was beaten over the head with a brick by a fellow inmate, and he died on November 25, 1955, at the age of 37. He was scheduled to be released the following August. Commenting on the murder, acting warden Fred Wilkinson said, "You'll get pretty much the same reaction concerning loyalty in a prison climate as in any other community." Robert G. Thompson, one of the communist leaders sentenced by Judge Medina in the Smith Act trial, fared better than Remington. Thompson, who had won the Distinguished Service Cross for his bravery during 147. World War II, was only severely beaten by a fellow inmate while in jail. 148. Judge Kaufman in person. Moving ahead some 30 years to mid-March 1984, Judge Irving R. Kaufman, among his countless honors, was now chairman of the President's Commission on Organized Crime. Kaufman had been appointed to that post by another patriotic warrior against communism, the President of the United States, Ronald Reagan. The commission was in the process of investigating organized crime's influence over legitimate banks. James Fratianno, a notorious criminal, testified that he had killed 19 people and that he knew a mafia member who had hidden $1 million in his mattress. That is all Fratianno said. Kaufman's technique had not changed in all these years. He used Fratianno to colorfully repeat, as the commission traveled from city to city, the facts about his murders and his knowledge about the existence of the great organized Italian crime ring known as the Mafia. Fratianno's testimony had nothing to do with exposing the methods by which banks help legitimize organized crime's illegal cash. Yet Kaufman and the committee he headed created the impression that Fratianno, his murders, and the Mafia were all part of a massive money laundering scheme involving national banks of the United States. Decades before, Kaufman used Elizabeth Bentley in almost the same manner. She helped intensify the paranoia of our nation, convinced as we were that communists or even liberals were loyal only to Russia and ready to commit espionage against us. Bentley's expert testimony confirmed that American communists were the equivalent of Russian spies. Elizabeth Bentley had been fighting communism for 149 years before the rest of the nation was ready to join her. The war against communism, however, did not begin with her. It had raged as far back as the Palmer raids of 1919, when thousands of communist sympathizers, and aliens were arrested. Our successful capitalists dreaded communism's appeal. It could mean the end of all they acquired. After all, it had happened in Russia, it could happen in America. Communism was a danger that had to be eradicated. But in the late 1930s and early 1940s we had joined with our ideological enemy to wage war with an even greater enemy, fascism. We and the Russians won, and there were amicable feelings between our two nations. It took time to sour them. But as 1948 moved into 1949, our newspapers began pounding Elizabeth Bentley and J. Edgar Hoover's message that communists were the equivalent of Russian spies working for Russia and that Russia was not our ally but our enemy. Still, most Americans were not convinced this was so. It took more time. Then on September 25, 1949, President Truman announced that an atomic explosion had occurred in the Soviet Union. Fear gripped our nation. The Russians had the atom bomb. Now, it was not just J. Edgar Hoover and Pat McCarran battling communism. Senator Joseph McCarthy became a national figure, the public became obsessed, and communists were hunted in the United States as oppressed people have been hunted throughout the history of mankind. This was the setting for the beginning of the trial of Julius and Ethel Rosenberg and Morton Sobel. 150. The trial of the Rosenbergs and Sobel. The trial of the United States of America versus Julius Rosenberg, Ethel Rosenberg, and Morton Sobel began on March 6, 1951. Judge Irving R. Kaufman announced to the jurors, "Mr. Schaefer will now read to you the indictment in this case." Then the judge explained to the jury that punishment would be decided by him alone. He told them, "That is completely within my jurisdiction, not within the jurisdiction of the jurors." Irving Sapel made his opening statement. The indictment returned by the grand jury is a simple one. It is charged that the three defendants, the Rosenbergs and Sobel from 1944, until the time when they were indicted by this grand jury some 151 months ago, conspired and agreed with each other and also with other conspirators, including Harry Gold, David Greenglass, David's wife, Ruth Greenglass, and one, Anatoly Yakovlev, an agent and official of the Soviet Union, and with others, to deliver information, documents, sketches, and material vital to the national defense of our country, to a foreign power, namely, to Soviet Russia. The evidence will show that the loyalty and the allegiance of the Rosenbergs and Sobol were not to our country, but that it was to communism, communism in this country and communism throughout the world. We will prove that the Rosenbergs and Sobol, acting separately and in concert, engaged in a ceaseless campaign to recruit promising members for their Soviet espionage ring. They were ever on the lookout for those whose state of mind and sympathies were such that the Rosenbergs and Sobol thought they would be ripe for a proposition to betray this country by stealing its secrets and giving them to the Soviet Union, to advance its cause and the cause of world communism. The evidence will show how at the behest of the Rosenbergs, green glass stole and turned over to them and to their co-conspirator Harry Gold, at secret rendezvous, sketches and descriptions of secrets concerning atomic energy and sketches of the very bomb itself. At this point, Alexander Bloch, who was assisting his son in representing the Rosenbergs, objected to Sapol's statements. Mr. A. Bloch, if your honor please, I move for a 152. Mistrial in this case upon the ground that the opening statement of the learned United States Attorney was inflammatory in character and introduced an element which is not pertinent to the case or relevant to it, to wit, communism, and made other inflammatory and damaging statements which are not part and should not be part of an opening. Judge Kaufman, your motion is denied. Mr. A. Bloch, I object to communism being mentioned at all on the ground that there is no causal connection between communism and the crime charged in the indictment. If it is done for the purpose of showing motive, they have to show that there is some causal connection. Mr. Sapol, it will be shown. Judge Kaufman, I accept Mr. Sapov's statement that he will show that causal connection. The objection is overruled. I am admitting this testimony on the theory of motive. But why would communism necessarily be a motive? A belief in communistic principles would not necessarily mean that a communist would be loyal to Russia simply because Russia was a communist country. The government was using primitive bias as a substitute proof for motive. 153. Max Elitshire was the first witness called. He was the government's chief witness against Morton Sobol, the young scientist who had fled to Mexico at about the time of Julius Rosenberg's arrest and was charged with having conspired with Rosenberg to transfer secret government information to the Soviet Union. Elitshire and Sobol had known each other for years. They had gone to school together and lived only a few feet from one another. What could have made Elitshire, who considered Sobol his closest friend, testify against him? Elitshire was at one time a member of the Communist Party. In order to obtain employment for the U.S. Navy, he had to deny that he was ever a member of the party. Elitshire was eligible to receive a 5-year prison term for having obtained his job by false pretenses. This was one of the reasons that may have prompted him to claim that he was approached by Sobol and Rosenberg to engage in espionage. Before the jury took their seats in the jury box, Sapol asked Judge Kaufman to exclude all witnesses from the courtroom, the usual procedure undertaken to prevent witnesses from hearing each other's testimony and making it the same. Sapol, however, asked that an exception be made as to the agents of the Federal Bureau of Investigation. Emanuel Bloch, in his desire to be as accommodating as possible to the government authorities, agreed to allow FBI agents who participated in the case to remain in the courtroom during the trial. Bloch's concession, however, could only hurt his clients, since 154. The FBI agents could match their testimony to that of the other witnesses whenever it suited them. Max Elitshire was called to the stand as the first government witness. He was questioned by United U.S. Attorney Irving S.A. 5-Pole. Mr. Sapol, do you know the defendant Julius Rosenberg? A. Yes, if I do. Mr. Sapol, do you see him here in court? A. Yes, if I do. Mr. Sapol, where were you living in 1944 in the summer? A. At 247 Delaware Avenue Southwest in Washington. Mr. Sapol, about that time did you see the defendant Rosenberg? A. Yes, I did. Mr. Sapol, tell us the circumstances under which you saw him. A. One evening, it was early, Before supper, I received a phone call from a person who said he was Julius Rosenberg. Judge Kaufman, when was this? The witness, in June, 1944, he said that he was a former classmate. I remembered the name, I recalled who it was, and he said he would like to see me. He came over after supper, and my wife was there and we had a casual conversation. After that he asked if my wife would leave the room, that he wanted to speak to me in private. She did, and he then said that there were many people who were implementing aid to the Soviet Union by providing classified information about military equipment, and so forth, and asked whether in my capacity at the Bureau of Ordnance would I have access to and would I 155. He able to get such information and would I turn it over to him? Mr. Sapel, is that the first time you met him? After Shu you yes. Mr. Sapel, I take it then that Rosenberg, Sobel you and you studied engineering at City College together? Yes. Mr. Sapel, after your graduation sometime in 1938, did you move to Washington? R/IES. Mr. Sapel, when did you see Rosenberg next? A. In the summer of 1945. Mr. Sapel, when did you see him next? A. He called me again in September of 1945. Mr. Sapel, did you see him? A. Yes. He came over to the house. Mr. Sapel, what did he say? A. Well, the war was over and he was saying that even though the war was over there was a continuing need for new military information for Russia, and again was trying to get my views about it, whether I would want to contribute in the future. I said I would see, and if I had anything and I wanted to give it to him, I would let him know. Mr. Sapel, thereafter did you see Rosenberg? A. Yes, I did. Judge Kaufman, when was this? The witness, either the end of 46 and possibly 47, the date I don't know. I told him about my new work. And he then interrupted and told MC there was a leak in this espionage, and because of that there were precautions being taken by him. He told me it would be best if I don't see him, if I don't visit him, that I don't come to see him until he lets me know or until someone informs me. Otherwise I think that 156 was the substance of the conversation. Mr. Sapel, about that time where had Sobel been working? A. At GE. Mr. Sapel, did his employment change then? AWELU sometime in 1947 he took a position at the Reeves Instrument Corporation. Met him more than once at Reeves. Mr. Sapel, do you recall the occasion when you had lunch with him? A. Yes, end of 1947. I don't remember the month. Mr. Sapel, at this luncheon conversation what was said? A. Well, there was this request for names or information about any engineering students that I might know, who were progressive. Told him. Didn't know anybody. However, if somebody came along, would tell him about it. Mr. Sapel, then, did there come a time when you went to work for the Reeves Instrument Company, too? A. Yes. Mr. Sapel, when was that? A. In October 1948. Mr. Sapel, now. At the time you first came to work for Reeves or immediately preceding that, did you have any conversation with Sobel about your plans? A. Yes. Had been informed. Well, my plans for leaving the Bureau of Ordnance started some months before. Left, however, when finally did decide to leave, which was about in June of 1948, again on the occasion of a visit to New York on business. Called him and told him that I was planning to leave the Bureau, that had definitely decided to do so. He 157 said, don't do anything before you see me. I want to talk to you about it, and Rosenberg also wants to speak to you about it. He made an appointment for me to meet Rosenberg at 42nd Street and 3rd Avenue, which I did. Mr. Sapel, what did Rosenberg say to you? A. Rosenberg asked about my plans to leave. Told him I had decided to leave Washington. He said that that was too bad, that he was sorry to hear it, because he had wanted me to stay there. At the Bureau of Ordnance, he needed somebody to work at the Navy Department for this espionage purpose. And he wanted me to change my mind. Sobel was along, and I recall that he agreed with Rosenberg in his trying to convince me to stay down at the Bureau of Ordnance. Sobel left and Rosenberg and I had dinner together. Mr. Sapel, what was the conversation in the course of that dinner? AWELU. Among other things, we continued to talk about this espionage. He asked whether I knew of places where important military work was done. He also told me about the fact that money could be made available for my education, if I so desired. Mr. Sapel, now, there came a time when you drove to New York with your family. That is correct. Mr. Sapel, when was that? The end of July or the beginning of August. Just about the end of July. I was coming up to look for a place to live and my family and I drove up to New York. We were going to stay at the home of the Sobels during the search for a home, a permanent home. Mr. Sapel, did you come to Sobel vs home with 158? Your family? Yes, I did. Mr. Sapel, did you talk to him? Did you see him there? Yes, I did. Judge Kaufman, this is the end of 1948. The witness, no, June-July of 1948. Well, on the way up. Ilitcher was apparently not sure of the date, and Saj-ol later tried to correct him by supplying it. None of the defense lawyers objected to Sapel*'s coaxing testimony, not having realized how important it was for the government to establish that Ilitcher's visit to Sobel and subsequent drive to Catherine Slip occurred on or after July 30, 1948, the date when Elizabeth Bentley's role as a government informer was officially announced. Mr. Sapel, just a moment. Excuse me. I think the witness said the end of July or August. The witness, yes. Mr. Sapel, go ahead. On the way up to New York, upon leaving Baltimore we had stopped to buy some dishes and we went off the main road, and on coming back one noticed that one was being followed. Once it was determined that Max and Helene Ilitcher were planning a trip to New York City in late July 1948, an FBI memo dated July 29, 1948, requested that they be followed to ascertain where the Ilitchers attempt to obtain their apartment in New York. Surveillance began on Friday, July 30, the day the couple left their apartment in Washington, D.C. 159. First it was the agents of the Baltimore office who watched them. At 1:49 p.m. the Philadelphia agents took over. At 4:55 p.m. surveillance was turned over to the agents of the New York office at 97th Street and Riverside Drive. A July 30 FBI report signed by Special Agent in Charge Edward Skelt included a teletype he had sent that stated, Max and Helene Ilitcher. Extremely alert for surveillance. Skelt said the couple should be followed only for the purpose of finding out where they would stay that night, then surveillance should be discontinued. The Ilitchers first went to his father's residence at 1571 Lexington Avenue, and why the agents who were following them did not consider that their resting place was not explained. Only when the couple left his father's place and went to Morton Sobeir's home did the FBI decide to end surveillance. Another Telet 5-E sent by Special Agent Skelt the same day said, evening of July 30 Max and Helene Ilitcher proceeded to home of M. Sobel. Ascertaining if Sobel has telephone in home, and if so consideration being given to request technical surveillance in attempt to follow Max Ilitcher's efforts in locating apartment New York. Skelt then wrote to the New York Telephone Company asking them for Morton Sobel's telephone number. Skelt reported on August 5 that they had advised him, there is no telephone listed for 164 to 15 or 164 to 1770 3rd Avenue, Queens, New York. But Sobel lived at 164 to 1770 3rd Ave. Sobel's telephone number was OL8-0829 and both Sobel's address and telephone number were listed in the 1948 New 160 York City telephone directory. The FBI, which spent a fortune in time and effort following Ilitcher to his destination, now made a point of terminating the project. The question is why? The answers are not easy to come by, but what is certain is that the FBI was following useless and counterproductive procedures. The FBI agents at their worst could not have been so incompetent. More had to be involved. Was Ilitcher working undercover for the FBI? If so, it might explain how, in June of the following year, he was able to board the USS Mississippi in Norfolk, Virginia to inspect top-secret Navy equipment. There seems to be no other way to explain how a prime espionage suspect could be given such free access to secret government installations. Ilitcher, when interviewed about this event, did not deny that it occurred. In fact, the information received from him led to the investigation of Lieutenant Commander Morton Prager, the party who gave him permission to visit the installation. Ilitcher, the evidence strongly suggests, was being used to test the adequacy of national security by exposing weak links in the military. In all likelihood, gold was used in a similar capacity. For example, on May 31, 1950, the FBI received a report from David C. Evans, a reputable citizen who claimed that he recognized gold from a newspaper photo as the same person he saw at White Sands, New Mexico, when a rocket was launched on September 15, 1949. Evans said that gold was in the company of two Army photographers. The reports concerning Ilitcher's visit to the USS Mississippi and Gold's visit to a government rocket launching site were not actively pursued by the FBI in Ilitcher's case and attributed to a mistake in identity in Gold's case. 161. Max Ilitcher continued his testimony. Ilitcher, I then proceeded on to Sobel vs. When I got there, we had one child and we put the child to bed. I called Sobel aside and told him that I thought that I had been followed by 1 or 2 cars from Washington to New York. At this point he became very angry and said that I should not have come to the house under those circumstances. However, he didn't seem to believe that I had been followed. He finally agreed that I would stay. However, a short time later he came over to me and said he had some valuable information in the house, something that he should have given to Julius Rosenberg some time ago and had not done so. It was too valuable to be destroyed and yet too dangerous to keep around. He said he wanted to deliver it to Rosenberg that night. I told him it was foolish under the circumstances, that it was dangerous, it was a silly thing to do. However, he insisted and said that he was tired. He asked me to go along. Upon leaving, I saw him take what I identified then as a 35mm film can. No reference was made to it. He took it. When we got into the car, he put it in the glove compartment. He drove over to Manhattan along the East Side Drive and he parked outside the Journal American building. He left the car, he took this can out of the glove compartment and left, and I drove up the street and down and parked facing the East River Drive on Catherine Street and waited for him there. He came back approximately a half hour later, or perhaps a little shorter, and as we drove off I turned to him and said, "Well, what does Julie think about this, my being followed?" He said, "It is all right, don't be concerned about." 162. It is 0K. He then said Rosenberg had told him that he once talked to Elizabeth Bentley on the phone, but he was pretty sure she didn't know who he was and therefore everything was all right. We proceeded back to the house. It was essential to the government prosecutors that Elizabeth Bentley's name be mentioned by Max Ilitcher. Once her name had come up in connection with Julius Rosenberg, she could appear as a witness and testify that the Communist Party of the United States took orders from the Communist Party of the Soviet Union. Her testimony on this theme was considered so critical that the government prosecutors did not believe they could win their cases without her. But for Ilitcher's mention of Bentley's name to sound credible, he had to say he had heard it after July 30, 1948, the day when her name was first announced to the public. That is why the trip to Catherine slip on July 30, 1948, the very day the FBI decided to not follow Ilitcher for just another 10 miles after following him for over 200 miles, was appended to Ilitcher*'s testimony. Mr. Sapel, just a moment. At that time was the name Elizabeth Bentley under discussion? It had been in the newspapers just prior to that time. Mr. Sapel, in the time that you worked with Sobel at Reeves Instrument Company or at any time did you ever see Sobel take any papers or documents? In the course of his duties I did, as far as I know, I saw him he had a briefcase and he did take things out of Reeves Instrument. 163. Presume that they had to do with work. Emanuel Bloch, the attorney for Julius and Ethel Rosenberg, then began his cross-examination of Max Ilitcher. Mr. E.H. Bloch, and when was the first time that you spoke to the FBI? It was July of 1950. Ilitcher's appraisal of the time he first spoke to the FBI was not very convincing. He had probably been cooperating with government officials for years before July 1950. On April 24, 1948, J. Edgar Hoover gave direct orders for an investigation of Max Ilitcher. But then an FBI teletype dated May 12 stated, "All investigation in this case suspended at the direction of the Bureau." A few weeks later yet another FBI memo reported that on July 8, 1948 authority was given to install a tel mic at Ilitcher**'s residence at 247 Delaware, Washington, D.C. It does not call for deep intellectual penetration to see that the investigation of Ilitcher was discontinued because he was cooperating with the FBI, even to the point of allowing them to tap his phone to record calls from the outside. There is additional evidence to support the contention that Ilitcher was a long-time government informer. In 1941, he dated a woman named Bernice Levin, and when he visited New York City in 1947 and 1948 he resumed the relationship. Ilitcher admitted to the FBI that he had been romantically involved with Levin. If Ilitcher's relationship with her was merely an 164 adulterous liaison, it would require no further discussion. But it was not that simple. Bernice Levin had been supposedly forwarding information to Elizabeth Bentley. The FBI noted. On September 20, 1948 Elizabeth T. Bentley, former self-confessed Soviet espionage agent, furnished to Special Agents Thomas G. Spencer and Lawrence Spillane, the following signed statement concerning Bernice Levin. Sometime in the fall of 1941 when I was making my first trips to Washington, D.C., at the request of Jacob Golos, the latter informed me that Bernice Levin, who was employed in the War Production Board, was a person I should contact and who would furnish information to me. After I first contacted Miss Levin she started to give me information. To the best of my recollection the information supplied by Miss Levin was concerned principally with production figures of items and materials which came to her attention while in the employ of the War Production Board. The greater likelihood is that Ilitcher, rather than Rosenberg, was the one who knew Bentley. Bernice Levin was Ilitcher's girlfriend in 1941, during the period when she was said to be actively passing information to Bentley. The probability is that Ilitcher knew Golos as well. The evidence suggests that Ilitcher was solicited by the FBI in the same manner that Bernice Levin, William Remington, and a host of others were recruited and enveloped in Bentley and Golos's counter-espionage operation of uncovering spies working for the U.S. government. Ilitcher, it is suggested, was at some time, in the 1940s, placed in a vulnerable position, and offered alternatives of cooperating with 165. The government or undergoing indictment. For Ilitcher, the choice was not difficult. Ilitcher was the hunter, rather than the hunted. He searched out Sobel, he turned Rosenberg's innocent visits into an attempt to obtain information for the communists. It was Ilitcher who chased after a very reluctant Julius Rosenberg. Ilitcher seemed to enjoy the perverse excitement of having a friend and at the same time informing on him. Block re-examined Illit Share. Mr. E. H. Block, did you make any written statements either to any members of the FBU who questioned YOUF or to Mr. Sapo or any members of the staff? A. Yes. Mr. E. H. Block, on how many occasions? A. 3. Mr. E. H. Block, did you pass any information secret classified, confidential or otherwise, of the government of the United States, to the defendant Julius Rosenberg, at any time? A. I did not. Mr. E. H. Block, as a matter of fact, from your own story on direct examination, you rejected all overtures on the part of anybody to try to enlist you in stealing information from the government, isn't that correct? A. Well, I didn't reject them. I went along. I never turned over material, but I was part of it. I mean, I was part of discussions concerning it until 1948. Mr. E. H. Block, you didn't, though. A. I did not. Mr. E. H. Block, let me ask you, did you ever? 166. Sign a loyalty oath for the federal government? A. I did. Mr. E. H. Block, when? A. I think it was sometime in 1947. I don't remember the time or the time of year. Mr. E. H. Block, at the time you verified that oath, did you believe that you were lying when you concealed your membership in the Communist Party? A. Yes, I did. Mr. E. H. Block, so you have lied under oath? A. Yes. Mr. E. H. Block, now, when for the first time did you see a member of the John O'Rourke firm? A. I would say about a week after the first interrogation. Mr. E. H. Block, now, you had merely the most casual relationship or acquaintanceship with Julius Rosenberg during your student days, isn't that right? A. Yes. Mr. E. H. Block, and you didn't see him, you say, from the time of your graduation in 1938? A. That is correct. Mr. E. H. Block, until June, 1944? A. That is my recollection. Mr. E. H. Block, and then you say he telephoned you sometime in the early part of June 1944 and asked to come to see you, is that right? A. Yes. Mr. E. H. Block, and then you say Rosenberg, not having seen you for 6 years, hardly knowing you, launched into an overture to you to engage in getting information? T.M. X.E.S. Mr. E. H. Block, did you mention the name of Bentley when you were first brought downtown for 167 questioning in June 1950 to this building to the FBI agent? A. I did not. Mr. E. H. Block, who was the first one who suggested the name Bentley to you? A. I believe before the question could be answered, Judge Kaufman interrupted, instructing Illit Share to provide the answer the judge sought, namely, that Illit Share mentioned Bentley ***'s name on his own volition. Judge Kaufman, did anybody suggest Bentley to YOUF or did you state the name on your own volition? AWELU I don't recall. I believe that someone during some interrogation said did I have anything to do with Bentley F, but it wasn't in relation to this particular testimony that I gave about the trip. Mr. E. H. Block, in other words the word Bentley or the name Bentley was projected into your mind by somebody either in the FBI or on the prosecuting staff of the United States government, is that correct? Yes. Mr. E. H. Block, do you remember when it was first mentioned? A. I do not. Mr. E. H. Block, do I understand that you signed 3 statements? A. Yes. Mr. E. H. Block, so that in the first statement you didn't mention this particular conversation where Bentley's name was mentioned by Sobel, and in the second statement you didn't mention this particular conversation where Bentley's name was mentioned? Is 168. That an accurate statement? A. That is correct. Mr. E. H. Block, when did you testify before the grand jury the first time? A. The middle of August. Mr. E. H. Block, did you testify on more than one occasion before the grand jury? A. Yes. Mr. E. H. Block, how many occasions? A. 2 times. Twice. Mr. E.H. Block, now carrot, when you testified before the grand jury for the first time, did you mention the word Bentley? A. WELU, I don't remember whether I actually testified to it before the grand jury, carrot, whether that question was asked. I had. Judge Kaufman, you had what? The witness, I had already told the FBI about this trip. Mr. E.H. Block, I am going to ask you a very simple question. Did you mention the name Bentley at any time during your interrogation before the grand jury the first time you testified before the grand jury? Judge Kaufman, don't answer. It has been answered. He said he wasn't asked, carrot, but he had already told the FBI about it before. Kaufman was encouraging Ilitcher to lie, and when Ilitcher did not promptly comply, Kaufman did the lying for him. Ilitcher did not say that he was not asked the question before the grand jury, Kaufman said it. Ilitcher testified that he did not remember whether that question was asked. To make this episode even more disturbing, Kaufman, after Ilitcher 169 said, I had already told the FBI about this trip, led the jury to believe that Ilitcher mentioned Bentley's name to the FBI, when it was apparent that Ilitcher was referring to the trip he took in Sobel's car to Catherine Slip, not to his mention of Elizabeth Bentley's name. Mr. E.H. Block, who recommended you to Mr. Rogg's office? A. No one. Mr. E.H. Block, did Mr. Rogg tell you TCAT? David Greenglass was a defendant in TK's case? A. Well, TK told me they were defending Mr. Greenglass. Mr. E.H. Block, and you didn't ask Mr. Rogg or any member of TK's firm anything about any duality, in representing you on TK one cand and a defendant in TK's very same situation on TKatker. TK witness, well, we went down to Mr. Rogg's firm with our recommendation. Mr. E.H. Block, but can you say we, you mean you and your wife? A. Yes. My wife was with me. Mr. E.H. Block, now, prior to TK time TCAT you went down to Mr. Rogg's office, was any mention made here in TK federal building by anybody, Ukatker it be a federal man or Ukatker it be a member of Mr. Saple's staff or Ukatker it be you, about Mr. Rogg? A. No. Mr. E.H. Block, was Kiss name ever mentioned? A. No. Mr. E.H. Block, prior to TK time? A. No. Mr. E.H. Block, and, sir, you are you not? 170. Presently unemployed? A. That is correct. Mr. E.H. Block, were you fired? A. WELU, I was asked to resign. Mr. E.H. Block, did you buy a new automobile with TK last 2 weeks? A. Yes. Mr. E.H. Block, but can you bug TCAT automobile? Did you cave any worry in your mind about any future prosecution by TK government against you? Mr. Saple, I fail to see TK relevancy. Judge Kaufman, I will let Kim answer. Mr. Saple, will your honor hear me? Judge Kaufman, you say TK is no relevancy. I am inclined to agree with you, but I am going to let Kim answer. Mr. Saple, will your honor let me state on the record my objection? I think TK cross-examination is taking a turn. Look, is equally unfair to TK prosecution. First, TK is an implication. TK United States government recommends lawyers and witnesses to defendants. TK witness, TK question was Ukatker I was worried? Yes, I was. Saple was telling Ilitcher not to mention that anyone related to the U.S. Attorney's Office referred him to John Rogg. Although the question that had been posed by Block had nothing to do with Saple's complaint of irrelevancy, Saple was anticipating Block's direction. He was terrified of what Ilitcher might say if he were again asked who referred him to O.J. Rogg. Saple was telegraphing an urgent message to both Ilitcher and Kaufman to be very careful with this line of questioning. It could lead to the 171 revelation that he or his staff had referred Ilitcher and other government witnesses to lawyers who were former prosecutors. As shocking as this may sound, prosecutors frequently did send informers, prosecution witnesses and friends to lawyers they favored, and they almost always took a share of the fee collected. This was customary procedure, with a third party usually making the contact in order to protect the referring prosecutor from exposure. The legal fees paid to Ojan Rog were very likely shared with Irving Sapel. Edward Coons, Morton Sobayer's lawyer, then began his cross-examination of Max Ilitcher. Mr. Coons, in June 1944 you said you had a conversation with Rosenberg? Mr. Coons, well now, the invitation to you was to get government documents, was it not? Yes. Mr. Coons, now let's see whether you accepted it with or without qualifications. Did you go and get any government documents? No. Mr. Coons, right after you had the conversation with Rosenberg in early June 44, did you communicate in any way with Sobel? I don't recall any such communications. Mr. Coons, afterward, you didn't see Sobel for some time, did you? I saw him in 45. Mr. Coons, when? At his wedding. Mr. Coons, did he say anything to you about getting documents from the United States government? 172. No. Mr. Coons, and then the next time you saw Sobel was in *46, up in Schenectady, is that right? Yes. Mr. Coons, Sobel didn't invite you up there, did he? No. Mt. Coons, now on each occasion that you had a conversation with Rosenberg or with Sobel where they made invitations to you, did you accept those invitations to commit espionage? I accepted the invitations, yes. Mr. Coons, did you get any documents from the United States government? No. The line of questioning was important. Ilitcher's saying that he had accepted the invitation to commit espionage was meaningless. His yes answer had no verifiability. Had he answered no, it would have been just as meaningless. Saying yes and not participating in espionage activities was certainly less culpable than saying no and engaging wholeheartedly in espionage. Yes or no answers to what Ilitcher believed he was doing should have been rejected as meaningless. The testimony developed during the trial established beyond dispute that Max Ilitcher never once transferred a secret of any kind to Sobel or Rosenberg, who supposedly solicited and harassed him for 4 years without success. Mr. Coons, did you hand any documents of the United States government to Sobel? No. Mr. Coons, I just wanted to spend a few minutes. 173. Time, if you please, on this occasion when you came up from Washington in the car with your family, and I think that was in June of 48, am I right? It was in July. Mr. Coons, the same day you were being followed by FBI agents, weren't you? Yes. Mr. Coons, Mr. Ilitcher, if I remember correctly, between 1942 and 1948 you only saw SABI on a very few occasions, is that right? Yes. Mr. Coons, this occasion of your trip to Catherine Slip, that loomed rather important in your mind, did it not? R/IES. Mr. Coons, but you didn't tell this to the FBI on the first visit? No, I did not. Mr. Coons, were you trying to conceal it? At the time, perhaps. Mr. Coons, in other words, you were trying to lie to the FBI, weren't you? No. I omitted it, but I didn't. All right, I lied. Mr. Coons, you only mentioned Miss Bentley to the FBI after the FBI suggested that name, isn't that true? Yes. Judge Kaufman, well, is that the fact? Well, not right after, in time. Judge Kaufman, well now, I wish, Mr. Witness, that you would explain and answer, if it requires explanation, and that you don't answer simply yes or no, because I am beginning to get a bit confused here. Now what is the answer to that? 174. Judge Kaufman was ordering Ilitcher to change his testimony, and he did. A. During the early questioning, they mentioned Bentley, they might have mentioned other names, too, saying, "Did you have anything to do with Miss Bentley?" I said no. That was the end of that. There was no further questioning by the FBI about the name Bentley until I brought up the name of Bentley myself, at a later period. Mr. Coons, what you are trying to say is, they did not direct your mind to this particular incident? A. That is correct. Ilitcher simply withdrew his previous testimony relating to Elizabeth Bentley. Mr. Coons, let's take it from there. Didn't you answer my question only a few minutes ago, when I asked you whether it wasn't a fact that you told about this conversation with Bentley after the FBI mentioned Bentley? Didn't you tell us that? A. Yes, but much later. Mr. Coons, didn't you tell this jury that only 2 or 3 minutes ago? The witness, I am now confused, sir. The name Bentley was brought up by the FBI agents and I said I had nothing to do with Miss Bentley. At a much later period, I told them that the name Bentley had been mentioned to me by Sobel. Mr. Coons, I move to strike out the answer. Judge Kaufman, it will stand. Mr. Coons, it is not responsive, and I ask the witness to answer the question I propounded. I submit. 175. It is in answer to something but not the question I propounded. Judge Kaufman, don't raise your voice to me. Mr. Coons, I am sorry. Judge, I am sorry. Judge, it means nothing. It is my customary way, Your Honor. Coons knew very well when it was time to be humble. The meanness of Judge Kaufman was not something to test. This meanness did not belong to Judge Kaufman alone. All Coons had to do was look back little more than a year before to see the way Judge Medina handled communists and their lawyers in his court. Medina not only sentenced 10 of the convicted Communist Party leaders to 5-year terms, he held their lawyers in contempt and sentenced them to terms of up to 6 months in jail, though it was he who instigated the contempt. 2 of the lawyers, who were from New York, Abraham J. E. Sermon and Harry Sacker, had their names forwarded to the Bar Association of New York for disbarment proceedings at the insistence of Irving Sapel. They were disbarred. The other 3 lawyers were also disbarred in their states. It took several years of appeals before they were finally reinstated, and by that time their careers were ruined. Destruction of the Communist Party in America required the destruction of lawyers who would represent communists. As a result, the American Bar Association recommended expelling lawyers who were communists or believed in Marxist-Leninist doctrines. Various state bar associations throughout the country set up committees to institute disciplinary proceedings against lawyers who had communist affiliations. It was several years before the courts reversed themselves. 176. And decided that it was wrong to punish a lawyer for representing a communist or a similarly unpopular client. Before the courts reached that decision, accused communists often could not even find a lawyer. One communist leader had to defend himself in a New York trial, because he had been turned down by over 200 lawyers. It was under these conditions that Edward Coons, Harold Phillips, Alexander Bloch, and Emanuel Bloch undertook the defense of Ethel and Julius Rosenberg and Morton Sobel. Judge Kaufman, all rights. I think the subject has been exhausted. Kaufman saw to it that questions which brought out Ilitcher**'s dishonesty and the influence exerted upon him by the FBI and the Attorney General's office were discontinued. The following discussion took place at the bench, outside of the hearing of the jury. Mr. E. H. Bloch, the defendant Julius Rosenberg, now asks the government to produce for use in this trial and with respect to further cross-examination of this witness the following, all written statements signed by this witness and delivered to the authorities of the United States of America. In support of my application, Your Honor, I contend that, there were prior contradictory statements made in some or all of those documents or material that I have mentioned, and in the testimony that he gave before the grand jury on the first occasion, to warrant the granting of the application. Judge Kaufman, well, I don't agree with you, at least insofar as that first statement to the FBI, and 177. If I did, I would do it in the fashion that has at least been indicated by some of the cases. I think that I should examine that first FBI statement. I believe that is the only statement where it has been pointed out that there may be some inconsistency, and I would examine that, and if I find that there is an inconsistency in a substantial manner with what has been testified here in the trial, then, of course, I will have to take the next step on it. Mr. Phillips, may I add to this request, while you are examining the first statement there, you might just as well examine the other statements from the same standpoint, as long as it is discretionary with you, as to the rule. Judge Kaufman, may I say to you, Mr. Phillips, the cases have held that in the first place there should not be an undue burden placed upon the court to examine everything. I am willing to give you the benefit of the doubt in examining this statement, and I shall examine this statement. Mr. Sapel, may I know if there are any other discrepancies that counsel pointed to? Mr. E. H. Block, yes, I think the June 1944 incident. Mr. Sapel, you mean, as to when the first meeting with Rosenberg took place, when Rosenberg called him to his home? Mr. E. H. Block, yes. Mr. Sapel, there is a conflict? Mr. E. H. Block, yes. Mr. Sapel, I don't know how that is material. Judge Kaufman, my own opinion is that it is immaterial. You see, his testimony today is unusual. He told the FBI several months before June 44, but his recollection today is that it was June 178. Kaufman made nothing of the fact that the dates applied to the defense, listing the time when a supposedly criminal act occurred, was false and misleading. The judge considered outright lies merely misrecollections of the truth. Irving Sapel next began to re-examine Max Ilitcher. Mr. Sapel, there has been some examination here concerning statements questioning of you by agents of the Federal Bureau of Investigation by myself and by members associated with me. Do you remember the first day that the agents of the FBI called upon you at your place of employment? Yes, if I do. Mr. Sapel, I think that was July 20 to the power of 1950th, was it not? I don't know the date. It wasn't in July. Mr. E. H. Block, if you say that is the date, we will accept that as the date. Mr. Sapel. Litcher said that he was not questioned by the FBI on July 20, 1950. He even denied that he was questioned for the first time in July at all. Yet Block was so respectful of Sapel or intimidated by him that he voluntarily discounted Ilitcher's contradictions of his own testimony. Mr. Sapel, in the course of cross-examination of you by Mr. Kuntz, he asked you a question whether or not it was a fact that you had lied to the agents in regard to Bentley. Did you deliberately make a misstatement of fact to the agents with the intent to deceive them? 179. I did not. It was obvious that during a recess Sapel reviewed Ilitcher's answers with him and persuaded him to give very different answers to certain questions. Ilitcher after recess decided that he was no longer a liar. Mr. Sapel, do you wish to make an explanation in regard to the answer you have given when you said that you lied? When I said that I meant that I had not revealed to them this trip the fact that I had been followed to New York and what resulted at Sobel vs House F and going down to Rosenberg's house, going down to the east side and the mention of Bentley. When I said I had lied, I meant that I had not told them that story at that particular time. Otherwise I didn't lie to them. Block cross-examined Max Ilitcher. Mr. E. H. Block, now, didn't you testify on cross-examination by Mr. Kuntz just before the luncheon recess that you deliberately omitted mentioning this automobile ride that you took with Sobel from your home in Flushing to Catherine Slip and the conversation that you are alleged to have had with Sobel where Bentley's name was mentioned? Yes, I omitted to say that. Mr. E. H. Block, you deliberately omitted to say that, did you not? As Judge Kaufman, this witness is excused, but I would like to have him available Monday morning in 180. The building in the event that I deem it necessary that he be recalled on the matter of these statements. 181. David Greenglass, Ethel Rosenberg's younger brother, was then called as a witness for the government. After being first sworn, he was questioned by U.S. Attorney Roy Cohn. Mr. Cohn, now in 1943, did you enter the Army of the United States? A. I did. Mr. Cohn, now am I correct in stating that during the next year July 1943 to July 1944 you were stationed at various posts Army posts throughout the United States? A. I was. Mr. Cohn, after your 2 weeks orientation at Oak Ridge, Tennessee, were you then assigned to report to some other place in the United States? A. I was. Mr. Cohn, where was that? A. Los Alamos, New Mexico. Mr. Cohn, about when did you report to Los Alamos? A. August, 1944. Mr. Cohn, were you told at the time the nature of the work being done at the Manhattan Project? A. No. Mr. Cohn, was the fact that it was secret reaffirmed to you? A. It was. Mr. Cohn, you knew that the information as to who Dr. Boer out there was secret? A. I did. 182. Mr. Cohn, now was one of the scientists who was present at Los Alamos and whose name and presence you came to know Dr. Walter Koski? A. That is correct. Mr. Cohn, I believe Dr. Koski is here in court. Would you rise Dr. Koski? Mr. Cohn, did you specifically work in the machining of a flat-type lens mold and other molds which Dr. Koski required in the course of his experimentation on atomic energy? A. I did. Mr. Cohn, now am I correct in stating that during the entire period of your stay in Los Alamos 1944 to the time you were discharged in 1946, you worked in the machine shop and in the theta shop on apparatus and equipment in connection with experimentation on atomic energy? A. I did. Mr. Cohn, now did you have any discussion with Ethel and Julius concerning the relative merits of our form of government and that of the Soviet Union? Mr. A. Bloch, objected to as incompetent, irrelevant and immaterial, not pertinent to the issues raised by the indictment and the plea. Judge Kaufman, I believe it is relevant. In view of the fact that the indictment charges conspiracy to commit espionage in that matters of national defense which would be advantageous to Russia is charged in the indictment, one think it is most relevant. Mr. Cohn, talking about socialism over capitalism, did they specifically talk about socialism as it existed in the Soviet Union and capitalism as it existed here? A. They did. Mr. Cohn, which did they like better? Did they tell you? 183. The witness, they preferred socialism to capitalism. Judge Kaufman, which type of socialism? The witness, Russian socialism. Mr. Cohn, Mr. Greenglass, when you went out to Los Alamos, was your wife out there with you? A. N. She wasn't. She came to visit me on our second wedding anniversary. It was November 29, 1944. Mr. Cohn, now, was there any time when you had a conversation with your wife concerning the atom bomb? A. I did. Mr. Cohn, will you tell us, Mr. Greenglass, what your wife said and what you said? A. My wife said that while she was still in New York, Julius Rosenberg invited her to dinner at their house at 10 Monroe Street. He then went on to tell Ruth that I was working on the atomic bomb project at Los Alamos, and that they would want me to give information to the Russians. Mr. Cohn, what did you tell your wife? A. I told my wife that I wouldn't do it. And she had also told me that in the conversation, Julius and Ethel had told her that Russia was an ally and as such deserved this information, so later on that night after this conversation, I thought about it and the following morning I told my wife that I would give the information. Throughout the trial the Greenglasses were described in court and in the newspapers as a young couple dominated by the Rosenbergs, Ruth Greenglass an unwilling participant in espionage, and David Greenglass a dupe who joined the young communist. 184. League in order to play handball. Ruth Greenglass, quoted by Louis Schaffer of the Daily Forwards in an article, September 2, 1950, said, there was a time when David and I were partial toward communism. But we were never embittered or intolerant toward people who did not agree with us. But Ethel was quite different. She did not buy from a butcher or grocer unless he were an open sympathizer toward Soviet Russia. She considered everyone who was against communism her personal enemy. There is evidence to dispute Ruth's self-portrait in the letters she and David wrote one another while he was in the army. There is a vital battle to be fought with a cruel, ruthless foe. Victory shall be ours and the future is socialism's. All I can say is that I am sorry I missed so many other May Days, perhaps the voice of 75,000 working men and women that were brought together today, perhaps their voices demanding an early invasion of Europe will be heard, and then my dear, we will be together to build under socialism our future. Dearest, you are no snob, what you say is true and there are only two ways to look at it. Either convert our friends or drop them. 185. J. Edgar Hoover and Niels Bohr. The questioning continued. Mr. Cohn, would you tell us, as you recall it, what your wife asked you? She asked me to tell her about the general layout of the Los Alamos atomic project, the building, SF number of people and stuff like that, also scientists that worked there, and that was the first information I gave her. Mr. Cohn, you say she asked you for that information, is that right? She asked me for that information. When I gave it to her, she memorized the information. She told me that she was instructed not to write it down, but to memorize it. Judge Kaufman, instructed by whom? The witness, instructed by Julius. Mr. Cohn, in giving to your wife the names of the scientists working at Los Alamos on that occasion, can you now recall any of the names which you furnished to her? I gave her Oppenheimer's name, cf. I gave her Bohr's name and Yalkowsky's name. The whereabouts and identity of certain scientists was considered classified information, since the special knowledge they possessed, if learned, could enable a foreign government to deduce the direction of the U.S. government's plans. Oppenheimer and Yalkowsky were scientists working at Los Alamos whose presence there was not considered classified. Niels Bohr's presence, however, since he was so closely. 186. J. Edgar Hoover and Niels Bohr associated with atomic energy, was considered top secret. But David Greenglass did not give his wife Bohr's name. The presentation of this false evidence had the full participation of U.S. Attorneys Irving Sapel, Roy Cohn, and Miles Lane. No less involved in the falsification of Greenglass's testimony was the director of the FBI, J. Edgar Hoover. In Greenglass's original statement, given to the FBI when he was arrested on June 15, 1950, he said that he furnished Gold with information concerning the identity of a world-famous scientist working at Los Alamos under an assumed name, but he did not mention Bohr's name. Interviewed repeatedly during June and July 1950, Greenglass never identified Bohr. Ruth Greenglass, when she was questioned on August 7 by U.S. Attorney Miles Lane in the presence of two of Hoover's most reliable agents, William F. Norton and John Harrington, also failed to support her husband's claim that he provided her with Bohr's name. Ruth Greenglass's answers to Miles Lane's questions follow. Q. Did he give you the name of any of the scientists working down there? Yes, F. Oppenheimer and L/Ray, I remember. Q. Any others? No. Not even Harry Gold supported David Greenglass's testimony. On August 1, 1950, when Gold was interviewed by Special Agents Norton and Harrington, Gold denied that Greenglass had told him that Niels Bohr was working at Los Alamos. When the FBI originally claimed that Greenglass had said that he gave Harry Gold the name of a 187 world-famous scientist, they did not mention the scientist's name. Niels Bohr was the scientist finally chosen. That choice was announced in August 1950 when J. Edgar Hoover, referring to David Greenglass' signed statement of July 17, wrote to Assistant Attorney General James M. McElnerney. It is somewhat doubtful that the fact that Dr. Oppenheimer and Dr. Yalkowsky were employed at Los Alamos was considered by itself to be classified information by the Manhattan District. For your information, it was Dr. Boer who was referred to by Greenglass in his statement. Hoover, however, knew that David Greenglass had not told anybody about Niels Boer working at Los Alamos. Hoover obstructed justice and suborned perjury. He created an entirely false set of facts which he knew to be false. 188. Mr. Cohn, after you furnished this information to your wife, did your wife return to New York? My wife returned to New York, and I had told her that I would be in New York in January on furlough, so she left for New York, knowing that I was going to be there. Arrived home January-ist, 1945. Mr. Cohn, how long was your furlough? It was a 15-day furlough with travel time. Mr. Cohn, after your arrival in New York, did there come a time when you saw the defendant Julius Rosenberg? Yes, he came to me one morning and asked me to give him information, specifically anything of value on the atomic bomb, whatever I knew about it. And he told me to write up anything that I knew about the atomic bomb. The following took place at the bench, in the absence of the jury. Judge Kaufman, let me say for the record that I have examined 3 statements given by the witness Ilitcher to the FBI dated respectively July 20, 1950, July 21, 1950, and October 23, 1950. I have as well read the grand jury minutes of Mr. Max Ilitcher dated August 14, 1950 and January 31, 1951. It is my feeling in the matter, that while I find no true inconsistency, have determined that I shall turn over to the defense the statements given to the FBI respectively noted before, and the grand jury minutes. I don't want a long protractive cross-examination. 189. Again to start. Mr. E.H. Block, yes, Your Honor. As you can see, it would take probably about a half-hour minimum to even read teak statements without trying to digest teakum for inconsistency. Would like to make the suggestion to the courts and ask a favor of the courts that the witness Ilitcher be asked to come back on some subsequent date, whatever date. Judge Kaufman, no, no. You know the testimony. It only occurred on Friday. It is clear in your mind. We will recess at 1 o'clock until 2:30. That will give you an opportunity. It didn't take me long to read the statements, no more than a half hour tops. Mr. Phillips, will we have enough time in a half hour to read these? Judge Kaufman, no. You will have an hour and a half. You don't eat for an hour. I don't. I eat for 10 minutes. I have a sandwich and coffee. You can arrange to have a sandwich and coffee brought in for you today, but we must move this trial along. In order to get this trial moving in an orderly fashion, I have determined that you are to examine these statements I have referred to before and the grand jury minutes. You are to do so during the 1.5 hour lunch period. I have read them. It didn't take me half hour to read them. You will have an hour and a half. I don't think you will have any difficulty whatsoever in crystallizing the particular thoughts you have in mind. So there it is. My own feeling in the matter is that this man really told a very good, honest, logical story, consistent with what he told here in court. That is my general feeling on the subject. The jury was recalled and direct examination of 190. David Greenglass continued. Mr. Cohn, now Mr. Greenglass I think that on Friday afternoon before we adjourned we were at the point where Rosenberg had returned to your apartment to get this information on the atom bomb that he had asked you to write down, is that correct? That is correct. Mr. Cohn, will you tell us again first of all, did you in fact furnish him with written information concerning the atom bomb? I did. Mr. Cohn, will you tell us just what information you furnished him with on that day? I gave him a list of scientists who worked on the project. I gave him some sketches of flat-type lens mold SF and I gave him some possible recruits. Mr. Cohn, what kind of recruits? A for Soviet espionage. He said he wanted a list of people who seemed sympathetic with communism and would help furnish information to the Russians. Mr. Cohn, now Mr. Greenglass SF have you at our request prepared a copy of the sketch of the lens mold which you furnished to Rosenberg on that day in January. I did. Mr. Cohn, would you examine Government's Exhibit 2 for identification and tell me if that is the sketch which you prepared? A. That is the sketch that I prepared. Mr. Cohn, did there come a time when you and your wife did in fact go to Rosenberg's home in response to the dinner invitation? A. We did. When I got to the apartment with my wife there was Julius and Ethel Rosenberg and a 191 woman by the name of Ann Sidorovich. Mr. Cohn, now had you ever met Ann Sidorovich before? A. I had never met her before no. Mr. Cohn, did you know any members of her family? A. I knew her husband. Mr. Cohn, would you tell us exactly what happened on that evening, exactly what was said and by whom? AWELU The early part of the evening we just sat around and spoke socially with Ann and the Rosenbergs, and then Ann Sidorovich left. It was at this point that Julius said that this is the woman who he thinks would come out to see us, who will come out to see us at Albuquerque, to receive information from myself. Mr. Cohn, what kind of information? A. On the atomic bomb. Ann Sidorovich was never arrested though, according to Irving Sapel, she was a courier for the Russians. The government's failure to prosecute her or call her as a witness, when she would have no choice but to testify or plead the Fifth Amendment, had to be because she had denied that she was involved in the espionage Greenglass described. But the government did list Ann Sidorovich as their witness. This in effect precluded Bloch from calling her for the defense, since her listing by the prosecution led him to believe that she, like the Greenglasses and Ilitchers, would be coerced to testify for the prosecution. FBI reports of interviews with Ann Sidorovich that later surfaced revealed that she would have been willing to testify if called as a witness by either side and was 192 convinced the Rosenbergs were innocent. Mr. Cohn, now was anything said about the reason for Ann Sidorovich being present at the Rosenberg home on that particular night when you were there? A. Yes, if they wanted us to meet this Ann Sidorovich so that we would know what she looked like, and that brought up a pointy what if she does not come? Mr. Cohn, you mean there was a possibility that somebody else would come? A. That's right. So Julius. My wife and Ethel went into the kitchen and I was in the living room, and then a little while later, after they had been there about 5 minutes or so, they came out and my wife had in her hand a jello box side. And it had been cut, and Julius had the other part to it, and when he came in with it, I said, "Oh, that is very clever," because I noticed how it fit, and he said, "The simplest things are the cleverest." Mr. Cohn, now, let me see if I understand that. Your wife had one side, is that correct? A. That's right. Mr. Cohn, who kept the other side? A. Julius had the other side. Mr. Cohn, was there any conversation as to what would be done with these two sides? A. Well, my wife was to keep the side she had, and she was to use it for identification with the person who would come out to see us. Mr. Cohn, during this evening, was any reference made by either of the Rosenbergs, to the material which you had turned over to Julius a couple of days before? A. Well, we discussed the lenses we generally 193 talked shop about what I had done at Los Alamos SF and we discussed lenses all during this evening and whatever was going on at Los Alamos SF scientists, things of that nature, and he said that he would like me to meet somebody who would talk to me more about lenses. Mr. Cohn, did he tell you who this person he wanted you to meet was? A. He said it was a Russian he wanted me to meet. Mr. Cohn, did anything further come of Julius's statement that he wanted you to discuss this lens with the Russians? A. Yes. Mr. Cohn, tell us. A few nights later an appointment was made for me to meet a Russian on 1st Avenue, between 42nd and 59th Streets it was in that area. Mr. Cohn, Who made the appointment? A. Julius made the appointment. Mr. Cohn, when was it in relation to the dinner meeting in January? A. It was a few days after. I took my father-in-law's car and drove up there. Julius introduced the man to me by first name, that I don't recall at this time, and the man got into the car with me. Julius stayed right there and we drove around. Mr. Cohn, now, about how long did this drive with the Russian last? A. About 20 minutes or so. Mr. Cohn, did you see Julius any more on that night? A. Yes, if he came back, I mean, he was around there, and the Russian got out and they went off together, and I drove back home. 194. Mr. E. H. Block, now if the court please just a second. I move to strike out T characterization of Teak man T cat K met especially in Teak last answer as Russian. Judge Kaufman, T cat is denied. Teak testimony as I understand it, is T cat Julius said K wanted to introduce Kim to a Russian. Mr. Cohn, about when did you leave New York and return to Los Alamos? A. About Teak 20 TK. Mr. Cohn, did your wife go with you? Aske did not go with me. Mr. Cohn, did Teaker come a time when Ske joined you at Albuquerque? Aske did. Mr. Cohn, when did you say it was Teak at Harry Gold came to your cow cf Mr. Greenglass? A. It was Teakered Sunday in June 1945. Mr. Cohn, book at time of day? A. It was in Teak Moming. Teak te was a knock on Teak door and I opened it. We had just completed eating breakfast and Teaker was a man standing in Teak Calwayoko asked if I were Mr. Greenglass and I said yes. He stepped Krog Teak door and K said, Julia sent me, and I said okay, and walked to my wife's purse, took out Teak wallet and took out Teak mat part of Teak jello box. Mr. Cohn, after you produced Teak cat did Gold do anything? A. He produced kiss piece and we ek Teakum and Tiki fitted, and Teak identification was made. Mr. Cohn, now, after mutual identification was effected, did you cave any conversation with Harry Gold? A. Yes. I offered Kim some aching to eat and K. 195. Said he had already eaten. He just wanted to know if I had any information and I said, I have some but I will have to write it up. If you come back in the afternoon I will give it to you. Mr. Cohn, tell us exactly what happened when he came back. AWELU when he came back to the house he came in and I gave him the report in an envelope and he gave me an envelope which I felt and realized there was money in it and put it in my pocket. Mr. Cohn, going back to these sketches which you gave to Harry Gold, do you remember just what sketches you gave to Harry Gold concerning a high explosives lens mold on that occasion? A. I gave sketches relating to the experiment setup, one showing the face of the flat type lens mold. After Greenglass identified court exhibit numbers 6 and 7 as the replicas of the sketches he gave to Harry Gold, questioning of him was interrupted to allow another witness, Walter Kosky, to be called to the stand. 196. Walter S. Kosky, called as a witness on behalf of the government, being first duly sworn, testified as follows, Mr. Sapel, Dr. Kosky, what is your profession? A. Physical chemistry. Mr. Sapel, in 1944 did you become associated with the United States government? A. I did. Mr. Sapel, in what capacity? A. As an engineer at the Los Alamos Scientific Laboratories. Mr. Sapel, you have been in attendance here and you have heard the witness Greenglass's testimony the defendant Greenglass's testimony F. Have you not? A. I have. Mr. Sapel, I show you government's exhibit 2, rather. Will you examine that please? Is that a reasonably accurate portrayal of a sketch of a type of Len SF mold or lens that you required in the course of your experimental work at the time? A. It is. Mr. Sapel, in your special field as you knew it at the time 1944 and 1945, did you have knowledge that the experiments which you were conducting and the effects as they were observed by you could have been of advantage to a foreign nation? To the best of my knowledge and all of my colleagues who were involved in this fields, there was no information in textbooks or technical journals on this particular subject. 197. Dr. Yalkowsky evaluated his work as highly creative. Whether it was or not was a question that was not satisfactorily answered at the trial. Mr. Sapel, and up to that point and continuing right up until this tria, you has the information relating to the lens mold and the lens and the experimentation to which you have testified continued to be secret information? It still is. Mr. Sapel, except as divulged at this trial? Correct. Mr. Sapel, will Your Honor allow a statement for the record in that respect? The Atomic Energy Committee has declassified this information under the Atomic Energy Act and has made the ruling as authorized by Congress that subsequent to the trial it is to be reclassified. Bloch began his cross-examination of Dr. Yalkowsky. Mr. Bloch, is it not a fact that a scientist would not consider Government Exhibit 2, 6, and 7, until the scientist knew the dimensions of the lens or the cylindrical apparatus? This is a rough sketch and of course is not quantitative, but it does illustrate the important principle involved. Mr. Bloch, it does omit, however, the dimensions. It does omit dimensions. Mr. Bloch, it omits, for instance, the diameter, does it not? Correct. Judge Kaufman, you say it does, however, said. 198. Fourth, the important principle involved is that correct? The witness, correct. Judge Kaufman, can you tell us what that principle is? The witness, the principle is the use of a combination of high explosives of appropriate shape to produce a symmetrical converging detonation wave. Mr. Bloch, now weren't the dimensions of these lens molds very vital or at least very important with respect to their utility in terms of success in your experiments? The physical overall dimensions that you mention are not important. It is the relative dimensions that are. Mr. Bloch, now the relative dimensions are not disclosed, are they, by these exhibits? They are not. Mr. Bloch, that is all. Kaufman tried to represent the sketches of the lens mold as valuable, but Dr. Yalkowsky admitted that the missing relative dimensions were of critical importance. Sapel then re-examined Dr. Yalkowsky. Mr. Sapel, the important factor from the experimental point of view is the design, is it not? Correct. Mr. Sapel, that was original, novel at the time, was it not? It was. Mr. Sapel, would I be exaggerating if I were to say colloquially that one expert, interested in finding out what was going on at Los Alamos, could get enough from those exhibits which you have before you to reveal what was going on at Los Alamos? 199. One could. Mr. Sapel, so that the sketches, particularly 2 and 6, do show relative dimensions in that they show the relations of each of the factors in the lens, one to the other? They do. Mr. Sapel, that is all. In this way, Yalkowsky was led to restate that relative dimensions were shown when they were not. Yalkowsky contradicted himself, giving a conclusion contrary to the facts. The dimensions were missing, so by mathematical logic the relative dimensions had to be missing. Sapel misled the jury by using the broad words relations and factors, enabling Yalkowsky to say that relative dimensions were shown and thus confusing the jurors. A conference was then held between the lawyers and Judge Kaufman concerning the grand jury minutes and statements made to the FBI as they related to Max Ilitcher*'s testimony. Bloch and Kuntz were willing to let the issue die. But Phillips, their colleague on the defense, was not so willing to discontinue pursuing the discrepancies he thought existed in Ilitcher's statements. Judge Kaufman, however, was determined to obtain Phillips's consent on abandoning further questioning of Ilitcher. When Phillips failed to give in, Kaufman simply ignored his protest. Mr. Phillips, as for the defendant Sobel, frankly, I am not quite convinced that I would be doing my duty by answering one way or the other. I should like the indulgence of the court to think it over between tonight and tomorrow. 200. Judge Kaufman, I am going to ask you to make your decision now. You have had 1 hour and 45 minutes. Mr. Phillips, do you know how much reading matter there is? Judge Kaufman, I read it myself. Mr. Phillips. Mr. Phillips, did you read all the statements in an hour and a half? Judge Kaufman, I read every word of it, and I read it in about 35 minutes. Having in mind the testimony while I was reading it. Do you want another 5 minutes? Mr. Phillips, we are in disagreement at this moment. Mr. Coons, I personally feel as far as our client is concerned. I am satisfied with the record as it stands. Judge Kaufman, then as I understand it, gentlemen, everybody is now in agreement that there is going to be no further use made of court's exhibits 1 to 5 and the witness Illichir is excused, is that correct? Mr. E.H. Block, yes. Mr. Phillips, by the way, I don't like the word agreed. We are not all agreed, and I make request of the court to give me time until tomorrow morning to make up my mind as to what is in the best interests of justice to my client. Judge Kaufman, I have given you 1 hour and 45 minutes. Personally read all of that matter in 35 minutes. Mr. Phillips, maybe I am not as quick-witted as the court. Judge Kaufman, very well then. We will proceed with the next witness. 201. Do you want the witness Greenglass? Mr. Sapel, yes. We have sent for him. 202. David Greenglass returned to the witness stand. Mr. Cohn, now you have told us about the visit of Harry Gold to you in June, about the material that you turned over to him. When after that was the next occasion when you saw Julius Rosenberg? It was on my furlough in September 1945. Mr. Cohn, did you tell him what you had for him? Yes. I told him I think I have a pretty good description of the atom bomb. Mr. Cohn, the atom bomb itself? That's right. The government at first assumed that Harry Gold's visit to Albuquerque, New Mexico, in September 1945 could establish an espionage meeting between him and Greenglass at that time. But the prosecution subsequently learned that Greenglass was not in Albuquerque, but on furlough in New York City at that time. So the government simply reconstructed Greenglass*'s story that he met with Julius Rosenberg in New York instead of with Harry Gold in Albuquerque. Greenglass testified that he turned over his first lens mold sketch to Rosenberg in January 1945 and the other 2 sketches of the lens mold to Harry Gold in June 1945. Cohn continued questioning Greenglass about the information he gave Rosenberg in September 1945. Mr. Cohn, did you draw up a sketch of the atom bomb itself? I did. 203. Mr. Cohn, did you prepare descriptive material to explain the sketch of the atom bomb? I did. Mr. Cohn, was there any other material that you wrote up on that occasion? I gave some scientists' names, and I also gave some possible recruits for espionage. Mr. Cohn, now about how many pages would you say it took to write down all of these matters? I would say about 12 pages or so. Mr. Cohn, have you prepared for us Mr. Greenglass a replica of the sketch? I believe it is a cross-section sketch of the atom bomb, a replica of the sketch you gave to Rosenberg on that day? I did. Mr. Cohn, I show you Government's Exhibit 8 for identification Mr. Greenglass and ask you to examine it and tell us whether or not that is a replica of the sketch cross-section of the atomic bomb. It is. Mr. Cohn, and how does that compare to the sketch you gave to Rosenberg in September 1945? About the same thing. Maybe a little difference in size, that is all. Mr. Cohn, we offer this in evidence, Your Honor. Mr. E.H. Block, I object to it on the same ground urged with respect to Government's Exhibits 2, 6, and 7, and I now ask the court to impound this exhibit so that it remains secret to the court, the jury, and counsel. Mr. Sapel, that is a rather strange request coming from the defendants. And I am happy to say that we join him. Judge Kaufman, all right. It shall be impounded, it will be sealed after it is shown to the jury. 204. Mr. E. H. Block, let me say by way of explanation, Mr. Sapo, that despite the fact that the Atomic Energy Commission may have declassified this, I was not at all sure in my own mind, and I am talking privately, whether or not even at this late date, this information may not be used to the advantage of a foreign power. Judge Kaufman, let me ask you this. Perhaps we can even avoid this matter of clearing the courtroom if counsel stipulate right now that the matters that were described, as he is about to describe, were of a secret and confidential nature. Mr. E. H. Block, if the court please, after some conversation between counsel, we cannot find concurrence among ourselves and, altcog I cave made my position, or at least I cave given my kinking to teak court, I am willing in teak interest of carmony of teak defense, to yield to teak reservations and misgivings of Mr. Pkilips and Mr. Kuntz and let teak trial proceed, and if teak court desires to keep tki's type of testimony secret I, for one, would cave no objection. Judge Kaufman, you would like to stipulate it? Mr. A. Block, I would like to stipulate it as an American citizen and as a person who owes kiss allegiance to tki's country. I would like to stipulate it first to save teak expense. I understand it would save quite an expense to teak government to bring all tki's people here. Judge Kaufman, may I ask you gentlemen, Mr. Pkilips and Mr. Kuntz, why aren't you stipulating tkis? Mr. Pkilips, for teak reason tkat I do not feel tkat an attorney for a defendant in a criminal case could make concessions ukik will serve teak people from teak necessity of proving teakings, ukik in teak. 205. Course of the proof we may be able to refute. Judge Kaufman, Mr. Block I understand that you are willing to concede the testimony concerning that particular phase of it is that correct? Mr. E. H. Block, I was willing to do this, Your Honor. I want to restate it very clearly. I thought that in the interest of national security any testimony that this witness may give of a descriptive nature concerning the last government exhibit might reveal matters which should not be revealed to the public. Judge Kaufman, therefore. Mr. E. H. Block, and, therefore I felt that his testimony on this aspect should be revealed solely to the court, to the jury and to the counsel and not to the public generally. Block *''s willingness to concede to not have the secrets of the atomic bomb exposed could have been his most important legacy. Criticism of Block **'s judgment in this instance was unfair. Block had no way of knowing for certain at the time that David Greenglass was providing worthless information. In the years since, many lawyers have insisted that it was incumbent upon Block to question in open court the value of Greenglass's atom bomb sketches, not to have them impounded. This was reasoning that could only be arrived at after it was known that Greenglass's information was without value. Realistically, the information was no doubt worthless. But what if it was not worthless? It would mean that Kaufman, with the help of Irving Sapel, was in effect giving the secret of the manufacture of the atomic bomb to every nation of the world, friend or foe, and even private individuals. Kaufman, with or without declassification, according to his own evaluation, openly transferred to virtually 206. Every foreign power information that was capable of being injurious to our nation. Judge Kaufman, ladies and gentlemen, in as plain and simple language as I can possibly put it to you. When the defendant is put on trial under our form of government, I am happy to say, he is entitled to full confrontation, and that means confrontation of all the evidence which the government contends to prove the guilt of the defendant or defendants. Mr. Benson, will you ask the press to come back before we bring the jury back? Mr. E. H. Block, you want the press excluded? Mr. Sapel, no, we want them in. Block could not understand why Kaufman was calling the press into court. Phillips and Kuntz, while wanting to see the evidence so they could dispute it, didn't want the press. With only the jury hearing this sensitive information, it possibly could have been kept secret, but certainly not if it was given to the press. Mr. E. H. Block, my position is that I think the press ought to be excluded in the prohibition. Judge Kaufman, in the prohibition? Mr. E. H. Block, I believe so, otherwise I believe the purpose would be defeated, unless the press is enjoined to secrecy. Judge Kaufman, no, they won't be enjoined to secrecy. They will be enjoined to good taste. Mr. Murphy, are there any members of the press who want to come in? Mr. Murphy, I can get them in a moment. Judge Kaufman, will you get them? Mr. Murphy, yes. 207. Judge Kaufman, may I say to the members of the press that I have considered the question of the press being present during the period of the taking of this part of the testimony. My personal feeling in the matter is that all of this testimony that is anticipated has probably fallen into the hands of those from whom we are trying to keep the information. Personally can't be certain of that fact. However, there has been a discussion here between Mr. Sepoyu, where it could be seen that these were not passport photos, but ordinary family photographs. Two of the photographs, which were dated June 15, 1950, on the back, were merely part of the inventory of personal effects taken by the FBI from Green Glass's home on the day of his arrest. As 217. To the additional photographs, the government produced them months later. 11 years after the Green Glasses had testified, the Schneers located the photographer's studio and visited the proprietor, who showed them a receipt. It was dated January 19, 1951, and was signed by Special Agent William F. Norton. It was for 6 negatives. In other words, Norton merely took the 6 negatives from the photographer on January 19 and had them developed. He chose 2 of them, and on January 26, 1951, inventoried the chosen photographs by signing and dating them on the back. He then added them to the 2 photos dated June 15. The evidence strongly suggests that neither David or Ruth gave a set of passport photos to the FBI when David was arrested. They had only 2 photographs of themselves on hand. Furthermore, why would only 2 photographs be dated June 15, 1950, unless the others were not available? And why would the FBI agent go to the photographer's shop to pick up negatives unless he did not have the original prints? The most logical conclusion was that the FBI manufactured the evidence. According to both Ruth and David, they both said they gave the FBI a set of passport photos. A set consisted of 5 photos. But the FBI received only 2 photos on the day it claimed to have received them. The FBI's approach to evidence on the question of the passport pictures is illuminated by the following story, revealed years after the Rosenbergs were dead. In December 1952, RA5 Anand El Paradis, a cellmate of David Greenglass at Lewisburg Penitentiary, reported to the FBI that Greenglass told him he could get for him a false passport if Paradis ever desired to leave the United States. Greenglass identified the source of 218. These false passports as Theodore Harris. The FBI reported. Greenglass told Paradis to mention Greenglass's name to Harris and that Harris for a payment of $500 to $1,000 would fix him up with the necessary papers. Greenglass also advised Paradis that at the time he was picked up by the FBI he had a passport on him. But the FBI concluded that in view of David's Pacarati cooperation with the Bureau, this information had been fabricated either by Paradis to ingratiate himself with the Bureau or by Greenglass to impress Paradis. The Philadelphia FBI office did everything it could to stifle the report, claiming that it could be dangerous to Paradis if other inmates learned he was an informer. Paradis described how knowledgeable Greenglass was about obtaining false passports. He said that Greenglass wanted to refer him to a lawyer in Mexico City, and he felt confident that he could get more information from Greenglass. The Philadelphia office decided not to interview David Greenglass on the subject until April 29, 1953, the date Paradis was scheduled to be released. But the Washington office of the FBI, learning of Paradis's revelations in February 1953, overruled Philadelphia and ordered that Greenglass be interviewed immediately. Thus, while the Philadelphia office had tried to sabotage Raymond Paradis's efforts, first slandering him as a braggart and then avoiding further meetings with him, The Washington office did even more to sabotage the investigation by interviewing David Greenglass on February 9 and alerting him to Paradise's objectives. In their report of this inside HT 219. The FBI scoffed at Paradise's allegations by stating, "It is recalled that at the time of Greenglass*'s arrest by Bureau agents in June 1950, no passport was found in his possession, although he had passport photos on him. It was not until April 3, 1953, that Theodore Haralampopoulos, who used the name Harris, was contacted by the FBI. Harris, who was always available since leaving Lewisburg prison in November 1952, was not sought out for several months. When he was finally interviewed, he did not contradict Paradise's claims, but merely refused to mention names. The FBI's questioning of him was as shallow as it was brief. The information that Paradise and Harris could have provided was lost, and the strong inference that David Greenglass had a passport and had helped frame the Rosenbergs was submerged and forgotten. 220. $5,000 is less than $1. Roy Cohn continued to question David Greenglass about Julius Rosenberg's visit to him in May 1950 when Rosenberg allegedly gave him $1,000. Mr. Cohn, when had he given you the $1,000? A. When he first came into the apartment and showed me that Harry Gold had been arrested. Mr. Cohn, he had given you $1,000 in cash, is that right? A. That is right. Mr. Cohn, what did you do with that $1,000? A. I gave it to my wife who paid bills with it and spent it, generally. Greenglass added that Rosenberg returned a week later and delivered $4,000 in a brown paper wrapping, placing it on the mantelpiece of his bedroom. Emanuel Bloch proceeded to cross-examine David Greenglass. Mr. E. H. Bloch, now let me ask you this, you have testified you got $1,000 from Rosenberg in 1950. And you insisted upon that money to pay your debt SF, isn't that correct? A. That is correct, Judge Kaufman. Excuse me, this $1,000 that you got in 1950 I want you to get this clear in my mind, was that in payment for the information which you had at or about that time turned over to Rosenberg, or was that in anticipation of your trip out? 221. Of the country? The witness, in anticipation of the trip out of the country. Judge Kaufman was emphasizing to the jury the prosecution's theory that Rosenberg gave Greenglass the $1,000 for the purpose of leaving the country. Kaufman did not want any other answer from Greenglass, especially not that the $1,000 was money he believed Rosenberg owed him. Mr. E. H. Bloch, when you as you testified finally told Rosenberg that you were not going to leave the country and you were going to stay right here, did you ever offer to give him back that $1,000? A. I did not. Mr. E. H. Bloch, now then, I think you testified further that you received an additional $4,000 from Rosenberg sometime in June, is that right, sometime in June 1950? A. That's right. Mr. E. H. Bloch, do you know now that that $4,000 or a major part of it went to pay your lawyer? A. I do. Mr. E. H. Bloch, have you been told how much of that $4,000 went to pay your lawyer? A. Yes. Mr. E. H. Bloch, all of it? A. All of it. Mr. E. H. Bloch, did you have any doubts when you, as you testified, got $1,000 from Mr. Rosenberg in June 1950? A. I did. Mr. E. H. Bloch, but you took that money and 222. 1. You used it to pay off household debts, isn't that correct? A. Well, about that $1,000, I felt that I was given nothing for this $1,000, I had plenty of headaches and I felt the $1,000 was not coming out of Julius Rosenberg's pocket, it was coming out of the Russian's pocket, and it didn't bother me one bit to take it, or the $4,000 either. Mr. E. H. Bloch, you had no qualms at all about taking the $1,000 or the $4,000, did you? A. Not at all. Mr. E. H. Bloch, even though that money, as you say, was given to you for purposes of flight. A. That is right. Mr. E. H. Bloch, you never offered to return TCAT money? A. I certainly did not. Mr. E. H. Block, at any rate, at present you bear an affection for Itkel? A. I do. Mr. E. H. Block, do you bear an affection for your brother-in-law, Julius? A. I do. Mr. E. H. Block, when was teak first time after your discharge from teak Army teak at teak FBI came around to talk to you about your activities at Los Alamos? A. In 1950, February. Mr. E. H. Block, Booker did teak's FBI representative see or speak to you in February, 1950? A. One man called me up on teakcone and K said K would like to see me. He came to my house, K sat down at my table, I offered Kim a cup of coffee and we spoke. K did not say to me that K suspected me of espionage or anything else. K just 223 spoke to me about whether I had known anybody at Los Alamos. And that was the gist of the whole conversation. He walked out of the house maybe an hour later, and that is all there was to it. Mr. E. H. Block, did he ask you any questions, either directly or indirectly, with respect to your knowledge of any illegal activity that occurred at Los Alamos while you were there? A. I don't recall exactly what the whole conversation was about. It made very little effect on me. It didn't seem like anything. I mean, Judge Kaufman, were you asked to sign any paper of any kind? A. No, not at all. Mr. E. H. Block, did he tell you what he came for? A. Well, he wanted to know. It was very difficult to find out what he wanted. He didn't come out and say he wanted some information. He just talked around the point. I didn't get what he really wanted to find out. Mr. E. H. Block, was Los Alamos discussed? A. Oh, yes. Mr. E. H. Block, did he say he was looking for people who might have conducted illegal activity in Los Alamos? A. No, he didn't say that. Mr. E. H. Block, what was the name of the FBI man? A. I can't remember the FBI man's name. Mr. E. H. Block, did you ever see the FBI man since? A. I have not seen him since. Mr. E. H. Block, you didn't tell that FBI man at that time, that you had engaged in any illegal activity. 224. At Los Alamos, did you? A. I didn't tell High Knife, but I was pretty well on the verge to tell him. Mr. E. H. Block, did you mention to him anything about the fact that you had given secrets of the Los Alamos project to any unauthorized person? Judge Kaufman, don't answer that. He has already answered it. Kaufman did not want Green Glass to be asked about the visit by the FBI in February 1950. Additional questioning could establish that Green Glass had been under the control of the government long before he was officially arrested. Further exploration into this area could also lead to perplexing questions as to why J. Edgar Hoover ordered an investigation of Green Glass on February 8, only days after Green Glass's one-hour meeting with the FBI agent who just talked around the point. What became of Hoover's order and what other meetings occurred between the FBI and David Green Glass between that February date and his arrest in June would not be told. Mr. E. H. Block, when was the next time you were interviewed by the FBI? A. When I was arrested June 15. Mr. E. H. Block, and when were you arraigned? A. Do you mean the time? It was in the afternoon, I believe. Mr. E. H. Block, and that was on June 16. A. That is right. Mr. E. H. Block, did you have counsel at that time? A. I did. Mr. E. H. Block, who was your counsel? 225. A. O. John Rogg. Mr. E. H. Block, and was Mr. Rogg there personally? A. He was. Mr. E. H. Block, now did you make a request for counsel at any time after you were taken down here to the federal building on June 15, 1950? A. Somebody said to me, you ought to get a counsel, you ought to get a lawyer. Mr. E. H. Block, did you call any relative on the evening of June 15 or in the early morning hours of June 16 from this buildings telling him or them that you wanted counsel? A. I did. Mr. E. H. Block, and to whom did you speak? A. I spoke to my brother-in-law, Louis Abel. Mr. E. H. Block, No WF Mr. Greenglass. Let's come back for a moment to the night of June 15, 1950, and the early morning of June 16, 1950. How many statements did you sign that evening and the following morning? A. I signed one statement that evening and the following morning. Mr. E.H. Block. Now, in that statement did you refer to the incident in Albuquerque, New Mexico, in the latter part of November, 1944, in which you had a conversation with your wife and in which she invited you to commit espionage? A1 referred to it, yes. I also, in that statement, I gave a general outline of everything I was to say. And later statements. I had more memory of what I had done and one filled in more. Mr. E.H. Block. Now, one understand that, but please, Mr. Greenglass, we are trying to find out specifically just what you said to the FBI. 226. Judge Kaufman. Yes, and I don't think you ought to go into such minute detail. Don't you think you are laboring the point really? Mr. E.H. Block. I honestly don't care, Your Honor. I feel in good conscience that it is my duty to ask these questions. Otherwise, I assure you that I wouldn't ask them. This is not going to take long, Your Honor. Kaufman just did not want Block to thoroughly cross-examine David Greenglass. The judge was not confident that Greenglass could maintain credibility if he was questioned too carefully. Block continued cross-examination. Mr. E.H. Block, was there anything in your statement which you signed on the evening of June 15, 1950 here in the Federal Building about the receipt of $1,000 from Rosenberg in the year 1950? A. I don't believe it was in the statement. F. No. Mr. E.H. Block. All right. Judge Kaufman, but you had told them about it? To protect Greenglass, Kaufman wanted him to say that he had told the FBI about the $1,000. Greenglass complied. The witness. One had told them about it. Mr. E.H. Block. Now, is it your testimony that you mentioned the $4,000 to the FBI representatives that evening? A. I did, and I will tell you how I know that, because when they searched the house they couldn't find it, and I told them then later on that I had given it away. 227. If Greenglass were as truthful and cooperative as he says he was, why didn't he refer the FBI to his brother-in-law Louis Abel, who was holding the money? If Greenglass had told the FBI all of this, would the agents leave it out of their report when they were investigating a case that was so notorious? Greenglass had to be lying. Mr. E.H. Block. Now, did you tell them that evening to whom you had given that money? A. I don't remember that either. Mr. E.H. Block. Didn't one of the FBI representatives, when you mentioned the $4,000, ask you where the $4,000 is? A. He must have. I just don't remember saying anything to him about where it was. Mr. E.H. Block. But you are not sure? A. I am not sure that I did or I didn't. Mr. E.H. Block. And then you made attempts to get a lawyer, isn't that right? A. That's right. Mr. E.H. Block. You called up your brother-in-law and you told him, get a lawyer, didn't you? A. That's right. Not exactly. Greenglass hired O. John Rogge, a specific former U.S. attorney, who was also Max Elicher's lawyer, not just any lawyer. Mr. E.H. Block. You involved your wife that night, did you not? A. Well, I don't know sufficiently enough about the law to realize that I did involve my wife. Mr. E.H. Block. Didn't you tell the FBI that? 228. Night that your wife came out to Albuquerque? A. That is absolutely true. Mr. E.H. Block. And made CI invitation to you to commit espionage, you told them T/IAT, did you not? A. That's right. Mr. E.H. Block. You also told them, did you not, that she had accompanied you to Rosenberg's house in September, 1945, you told them that, did you not? A. That's right. Mr. E.H. Block. Did you tell the FBI about your wife's participation in the Gel Zero box incident? A. I did.